Then we go to the issue of the 27 constituencies. And this makes me feel very sad. Because, my lords and my ladies, as this process was going on the 15th of August, at about 3 o'clock, the whole exercise of tallying and verifying had been completed, and that is in the affidavit of Marjan and Professor Gulier. Members of certain political parties decided that it was time to stop a process that had already started. We all watched in horror on TV as members, some of them who were in this court, confronted the chairperson, threw down the pulpit where he was to announce the results, threw down chairs, assaulted the chairperson and the commissioners. In fact, Professor Gulier, the chairperson, and the CEO were injured. And we have attached documents showing the injuries that they sustained. And the intention was to stop the declaration from being made. Now, this is critical, my lords. Everybody has said why it is important that a government should not be established by means other than those set out in the Constitution. But equally, nobody should stop the process of the Constitution that result in the establishment of a government in accordance with its provisions. Stopping that process is equivalent to preventing the Constitution from being effected. It's a transgression against the Constitution. And it cannot fall from the lips of those people who tried to stop that process to come before you and say the results of 27 constituents were not publicly announced, and yet you are the one who precipitated a situation where there was disorder, there was chaos. And this chairperson and the members of the commissions were now in fear for their lives. How do you tell them to still turn up and come and undertake an act that you have prevented from happening? And my lords, in the second petition filed in 2017, and my lords, at this time also remember, this is a time when one of the officers of the commission had been abducted, the other one had disappeared and feared to be dead and turned out to have been murdered in any event. This is the situation that was prevailing at that time. My lords, faced with this situation, this court in 2017 in the repeat election was categorical that you cannot foment trouble, you cannot foment chaos, and then try to use the chaos as your reason, or the non-performance of an act because of the chaos, as the reason to come before this court for relief. My lords, it is critical that it becomes clear to political leaders that the decision as to who will be the leader of this country is made at the polling station. The agents, the commission agents who declare the results are just doing their job. If there is a problem, if the numbers of the votes that you got are not enough, the problem is not at the declaration. The problem is with the people who you did not persuade to vote for you in sufficient numbers. That is where the problem is. You cannot come to threaten members of the commission for purposes of them living in fear and refusing to do what they're required to do under the Constitution, and thereby enable you achieve a political purpose. And so, my lords and my ladies, the 27 constituencies, the critical point is, the results from those constituencies were tallied, were verified in accordance with the provisions of Article 138(3)(c). And you will notice that Article 138(3)(c) does not talk about announcing the results in the constituencies as a precursor or what will justify or validate the outcome. It doesn't. Lord, the next area that I just want to quickly go into, and I will just mention this in passing, the purposes for which we come to this court is that once they have made a decision, we don't revisit it. The question of the rejected votes, which I had been referred to yesterday, was determined in 2013. In 2017, Raila won, 2017, the issue again was raised, and this court said with finality that the only votes that will count are those votes that are valid. It's just valid votes. A vote that is rejected, a vote that is spoiled, does not express a choice, and therefore cannot count for anything. This court pronounced itself again in 2017. My lords, we cannot keep coming back before you and asking you the same question. You have answered it twice. I don't think I need to say more about it. The last item that I just want to deal with is the issue of constitutionality of certain regulations, which was raised by one of the parties. My lords, all I need to say about this again is that the provisions, these regulations, were promulgated on 27th of April 2017. They were the ones that were used for purposes of conduct of the 2017 election, first one, and of the repeat elections. No one has ever complained about those regulations. No application has ever been filed regarding the constitutionality of those regulations. In fact, when you retire to write your ruling, you will find that in both instances, this court relied on the provisions of Regulations 83 and Regulation 87 as the basis for the findings that were made, including the role of the chairman and the requirement for him to verify and tally the results of an election. And so, my lords, to now come late in the day, after you were made aware there is an election that is coming, you participated in those elections knowing that those regulations are there, and then when you do not succeed, you turn around and say, in fact, one of those regulations that were used is unconstitutional. That's one. Two, the law is clear, and I set out in the decisions that my ladies and my lords made in 2017 too, where you said that the determination as to constitutionality cannot affect antecedent acts. It can only look forward, so that even if there is a finding of unconstitutionality, and my humble view is that there is nothing unconstitutional about it, my lords, that cannot affect the election that was conducted on the basis of a law that was valid then. And so, my lords, it's my humble submission that this issue of whether or not the regulations are legal or not, my lord, is a small screen, because these parties, and especially the main petitioner, has been aware of this regulation and has participated in elections where this regulation has been used now for the third time. The last item, my lords, is on the question of the postponement of the elections. Again, my lords, this has been explained in the affidavits that have been sworn by Mr. Gulia and also by the chairperson. And what happened is that the ballot boxes that were delivered, they had a mix-up in the names and the photos. And my lords and my ladies can imagine the confusion it would cause if this election was allowed to proceed on the basis of those ballots. Now, because of the deficiency of trust in this country, ballot pallets can only be opened on the eve of the elections to avoid a situation where IEBC is accused of having interfered or in any way manipulated the ballot papers. And so they were opened on the eve of the elections, which is on the 8th, and that is set out in the affidavit, when this mix-up was noticed. My lords, there was absolutely no time for fresh ballots to have been printed and delivered in time for the elections to be held. And therefore, in pursuant to the provisions of Section 55B of the Elections of the Elections Act, IEBC considered that this issue was an emergency. And what is an emergency? An emergency is an unexpected issue that requires immediate action. That's what an emergency is. And this was an issue that arose on the eve of the elections. These ballot papers could not possibly have been given to the electorate and told to use them for purposes of the election. And it is for that reason that IEBC, for purposes of securing the rights under Article 38 of the Constitution, decided to postpone the election to give the electors the opportunity to use the proper ballot papers for purposes of this election. And the mix-up was admitted by the printer. And what the printer did is that they agreed to print those ballot papers afresh at no cost. Now, my lords and my ladies, if we had used those ballot papers, obviously, we could not have been able to get a reprint at no cost. And secondly, for sure there would have been a petition on the basis that there was confusion arising from the mix-up in the images and the names. And so the postponement of these elections was justified in the circumstances. My learned friends dwelt at length on what the chairperson is alleged to have said in a public statement. My lords, these are newspaper reports that are given from time to time. And the important thing is, what does the law say in situations such as this? Does the IEBC have the power to postpone the elections? And the answer is yes, because it secures and protects Article 38 rights. My Lord, the second issue that, and this is the court will take judicial notice of this, is that there was ongoing litigation in Mombasa regarding the gubernatorial seat. And this litigation went on up to close just before the elections were concluded. And so, my lords, again, this caused delay in terms of the timing of when those ballot papers would arrive. So, my lords, importantly, before the ballot papers were brought, the commissioners that are complaining all traveled to Greece. All four of them traveled to Greece to review and see how the printing was going on. They were the ones who represented the commission in Greece. And so, my lords, for them to now say that there was no, that this was an error, that it cannot come from their lips. They were there, my lord. So it's a humble submission that based on what we have submitted, that the elections were conducted in accordance with the provisions of Article 138 of the Constitution, and that these petitions should be dismissed with costs. That's all, my lords.
May it please you, my ladies and my lords. For the record, my name is Eric Gumbo. I will be addressing the first, second, and third issue in the list of issues that were framed by the court. My ladies and my lords, I will, in addressing you on those issues, rely on the affidavits of Michael Ouma, dated the 26th of August 2022, and rely on the affidavit of one Martin Wachira Nyaga, dated the 27th of August 2022, and the affidavit of Hilda Kavonga, sworn on the 27th of July 2022. So coming to the first issue, which is whether the technology deployed by the IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. I will take a few moments to demonstrate how the technology that was deployed in the just concluded elections then met those constitutional imperatives. As a starting point, my ladies and my lords, we may want to ask ourselves, what exactly is this technology that we are talking about? And in answering that question, perhaps a bit of context would be of help. In the period just before the 2007 elections, when we still were dealing with the defunct Electoral Commission of Kenya, the legislative provision then, the equivalent to our Section 44, was worded in very loose, perhaps permissive terms. It was that to the effect that the Electoral Commission shall use technology where applicable or as may be appropriate. After the 2007 elections, we had the Kriegler recommendations, which then, one of which was that we must employ, or we should employ, the use of technology in our elections. When we got to the 2013 general elections, there was a good attempt at using technology, but the various forms of technology that were used were not were in different platforms, so that there was a different platform for purposes of registration, a different platform for purposes of identification, and a different platform for purposes of transmission. That did not work very well, perhaps because of the inefficiency attendant to the system then. Came the amendments in 2011 to Section 44, which required then that the technology to be employed was one to be integrated, meaning that in that one solution, we had the option for voter registration, which is biometrics. The second was electronic identification of voters and electronic transmission of results. Now, the question that we have before you today is whether, as conceptualized, that solution then meets the constitutional imperatives under Article 86 of integrity, verifiability, security, transparency, and accuracy. I will take a moment to just demonstrate how each of these would have been achieved. But when you retire, though, to consider the decision, I would invite your attention to specifically the affidavit of Michael Lohuma, who sets out in a very granular sense how these imperatives were met. I then would want to talk, that is specifically paragraph 39 to 49 of the affidavit of Michael Lohuma. I then would want to talk a bit to the process entailed in those three items. And I'm sure we are most of us are familiar, those of us who have participated in elections are familiar with that process. That once the voting has been done and the polling station has been converted for to the evening now for purposes of tallying and counting of results, we start by the counting in a very transparent manner. The presiding officers count each and every ballot, and I'm sure we've witnessed this, showing a vote for Gumbo, a vote for so-and-so, and a vote for so-and-so. Now, at the end of that process, they are then tabulated to give us Form 34A. How then is technology infused in Form 34A? Form 34A has internally identified security features. There are 8 in number. We have watermarks, we have UV potentials, we have microtext, amongst other security features. What is the significance of this? It is so that when somebody looks at the Form 34A, the original, it cannot then be confused for any other form, and that whatever it is that happened at the polling station remains an authentic representation of the will of the people. What then happens is that after that form has been tabulated, it is captured with a KIMS device. One copy is sent to the National Tallying Center. Another of that image is sent to the Constituency Tallying Center. And the presiding officer then collects all takes the Form 34A for purposes of the collation to the Constituency Tallying Center. That, again, is to achieve the constitutional imperative of verification. When we get to the Constituency Tallying Center, the returning officer has a back-end access to be able to load their Form 34B and transmit it to the National Tallying Center. Once that is done, they will then go with their Form 34A, together with their Bs, to the National Tallying Center for purposes of the verification and tallying at the National Tallying Center. Again, it is important to note that by the time the returning officer gets to the National Tallying Center, we have the image that is already in the portal. When they get there with their original form, an opportunity is then presented again for verification, for confirmation of accuracy, and more importantly, that in this election, because of the decision that was rendered by this court in the Raila Odinga decision in 2017, the Commission, in reconceptualizing or reconfiguring its electoral architecture, gave a public portal for people to be able to also follow, thereby meeting the constitutional imperative of transparency. It then meant that if I'd gotten my results from my village, my primary school where I vote, I would be able to follow those results all the way to Nairobi and take account and follow if at all there is anything that would have happened or changed. Then I must be the first person to be able to raise that concern. It should also not be lost that in that polling station, we have our agents, we have our observers. Again, to add to the fact of verifiability. So that then is the architecture of what our election pathway looks like. That said, it then must follow that at the polling station, if I am a candidate, I certainly must have interest in the outcome in that particular polling station. Because a copy of the results from the polling station would be given to me, I then should be able to communicate with my team, perhaps my national agent for a particular candidate, a particular party, to be able to demonstrate that what we got in member primary school and what has been transmitted to the National Tallying Center is one and the same. And that in the event that there's a discrepancy, it does not take magic to be able to point out that. Now, as to whether this technology was successful, Michael Ouma deposed in his affidavit that 46,201 KIMS kits deployed throughout the Republic worked out of the 46,229. It then leaves us just with about 200 KIMS kits, which did not work at the opening or start of election on that particular day. I ask myself, if out of 46,000 KIMS kits, only 200 do not work, would I say I've failed? Even in our educational system, an A does not connote 100%. It starts somewhere from 88%, going all the way to 100%. The mathematical representation of this gives us more than 99% success rate. In our view, that then achieved the constitutional imperatives that are contemplated under Article 86. Again, for purposes of confirming whether that system is secure, I invite you, my ladies and my lords, to look at paragraphs 51 to 63 of the affidavit of Michael Ouma. Again, just to mention a few items in relation to that, that KIMS gadget works in specific ways. It is first locked to a specific polling station, meaning you can then not use it once you've locked it to the events of that day to transmit results from a different station for purposes of that election. That the entire network through which the results are transmitted are secured or double layered with firewalls, meaning there's the first firewall and the second firewall for purposes of securing that transmission. Very significant again to mention that at the point at which that image is to be transferred, it is encrypted. So as it is transmitted, it is not in the form of what we would imagine the image of Form 34A. If I was to use an example, if it was to be a water pipe and it is to be encrypted, it means if you broke into that water pipe, because we all know that the chemical formula of water is H2O, you'll get your hydrogen on one side, you'll get your oxygen on one side. It then means you'd not be able to make sense of that water that you're looking for. Again, we must be able to relate this with other factors. In the KIMS kit, we have certain information that is resident, close of business in any polling day. One of them is the question as to the voter turnout of a day. It means for somebody to intercept that system, they must have information in relation to the voter turnout of that day. It may not be practical for somebody to say that they have the capacity to know the voter turnout throughout the country at the second at which they want to intercept a particular form transmitted. Again, if we exceed the number of people who voted, then again, from an accountability perspective, it would be very easy to point out to say, because of the fact of this interference, you've exceeded the numbers of what was captured in your report. To give further comfort, this transmission is done over a virtual private network, which is provided by the mobile network operators, who themselves also secure that environment to ensure that there is no intrusion or interference coming from any quarter into the system. For a good, perhaps, mental understanding of what this means, or how this was applied, Michael Ouma in his affidavit says that there were more than 380 million hits on trying to, just to access the public portal. And that, according to him, none of the systems even blinked. That is how secure that environment is. Now, the other question that somebody would want to look at in relation to Article 86 is the compliance with the provisions, statutory provisions in relation to procurement and all those. Again, I invite you, my ladies and my lords, to look at paragraph 64 to 71 of the affidavit of Michael Ouma. He then ends at saying that close of business, more than 14,239 people were successfully identified through that system. He describes it, to use his words, as a military-grade system. That is how comfortable he is with that, with the security features of that system. I come to the second question, which is whether there was interference with uploading and transmission of Forms 34A from the polling stations to the IBC public portal. The emphatic answer is no. I have given a general description of the infrastructure that was laid out. I will take a few moments to demonstrate that it wasn't possible to get into that system, and that even if somebody attempted to get into the system, then it would have been noticeable, to again speak to the fact of verifiability, and that one would be able to pick that with pinpoint precision because of the manner in which the system works. For purposes of a clear understanding, it is purely because of that verifiability that we are able to hear our colleagues appearing on this other side for the petitioners saying that they saw a gentleman called so-and-so who accessed the system. So-and-so accessed the system because of verifiability. It means that those who were able to access the system must have been people who were then authenticated to access the system, because certainly you must get some human intervention if the system is to work. To this extent, we'll then invite you to look at the affidavit of Hilda Kavonga. Hilda Kavonga is the manager, security and business continuity. Again, Hilda confirms emphatically that the system was not breached. She speaks at paragraph 7 in good detail about how robust that system was. I invite you, my ladies and my lords, to look at the structure of that infrastructure and just appreciate for yourselves how then it was secure for purposes of protecting the will of Kenyans. At paragraph 12, she even goes on to give security assurance through certification from the National Institute of Standards and Technology. Now, we look at this in relation to the allegations that have been made. There's an allegation about staging. learned counsel, senior counsel, Philip Murgor, spoke about the man in the middle. The indication or the allegation appears to be that somebody intercepted the system or broke into this system, downloaded this form, altered this form, uploaded it again, and sent it or transmitted it to the National Tallying Center. Like I said, when eventually we have an opportunity to look at the details that we have submitted, including the KIMS returns, it will be apparent that there was no such intrusion. But assuming for one moment that we want to interrogate this fact of staging, we then would want to ask ourselves, at what point in time did this happen? Because according to the infrastructure that is laid out by the IEBC, once a form is transmitted from the polling station and it gets to the public portal, it also has certain inbuilt security components. It has a digital signature. That digital signature marks an indication as to the exact time when that form was transmitted. If there's intervention, then certainly there must be a lag between the time when that form was transmitted and the time the form got to the National Tallying Center. It is our submission that nothing has been presented before this court to even come close to making that suggestion. Again, as part of the security that is in the portal, each of the forms that get there are serialized. And the serialization is tied to the polling station. It is tied to the date, to the time, up to the second when that form was received. It then, as an additional property, gives you a tab to be able to confirm or verify whether there's been any alteration on the form from the time it was transmitted. One would then very easily pick up that as a concern to say, we refer you to, again using my primary school in Member Primary School, that the form 34A that was sent from Member Primary School was intercepted, manipulated at this point in time. That is a report that the portal would be able to generate. Again, not a single piece of evidence has been given to come close to suggesting this. I've pondered since the submissions and presentations yesterday from our learned friends appearing for the petitioners as to what really this evidence is. I have, in the course of struggling to look for this evidence, come across three possible areas they'll be talking about. In the affidavit of one John Mark Gidongo, they make reference to a form 34A from Baringo County, Tiaty constituency. They then say that that is an example of a form that was intercepted. Michael Ouma, in his affidavit, confirms that in fact the form that was uploaded or that was attached in the affidavit of John Mark Gidongo is not a form that arose from the process that, that they allude or allege it arose from. That according to him, this form was downloaded. Somebody tried to interfere with the details on it and attached it to an affidavit. Now that, if you asked me, is perhaps the silliest way of doing any of these things, because if somebody asked you whether that form was authentic, you only need to look at the public portal. You then need to verify it with the form 34A that was presented. My ladies and my lords, as a statutory requirement, we delivered all the form 34As to this court. We have a copy. The entire public has copies of each and every of those documents. our team went through those documents, and in relation to that specific Form 34A, to say the least, it's a forgery. The second attempt, again by John Githongo, in his affidavit to try and present some form of evidence, is in the form of logs which were alleged to have been gotten somewhere. It says Karen with these 56 mysterious people, and this I think is what senior counsel Professor Githu Muigai was talking about, hearsay on the back of hearsay. I was told that I had. Really, is that the sort of evidence that we want to present before this court? We took time, that is, the ICT team took time to study the logs that were presented. My ladies and my lords, I'm sure you have appropriate infrastructure to be able to make a determination on your own as to what these logs entail. From the analysis that were conducted, and this is again contained in the affidavit of Martin Nyaga, these forms, these logs arose potentially or were picked potentially from the 2017 general elections. Martin Nyaga, in his affidavit, identifies 9 obvious inconsistencies. I want to allude to just 2 or 3 of them. That, if you, and that is in paragraph 13 of the affidavit of Martin Nyaga. If you look at the manner in which those forms, those logs are structured, they serialized. In 2017, the IEBC serialized its logs using the names of the constituencies. In that particular log, you'll find a name Changamwe. This time round, they did not use the names of the constituencies. They used the serial numbers. So that is the first inconsistency. Looking at those logs again, you see the name of one Asenge running an IEBC email account. Asenge was one of the returning officers of the IEBC in Changamwe in 2017. One is then left to wonder, at what point do we get to even forging documents, forging logs, to be able to demonstrate our case? Perhaps I will get to that a little later. Enters the third piece of evidence, which was supposed to now clean what was presented by John Mark Githongo. The affidavit by one Commissioner Justice Nyang'aya. Commissioner Justice Nyang'aya attaches logs to his affidavit. He then emphatically indicates that those logs go into confirming that specific named people accessed the system and that they then interfered with the results. He names 3 officers from the IEBC. Their details are in the affidavits. My ladies and my lords, again, we took time to run through those logs. The logs that were presented in the affidavit of Justice Nyang'aya, according to the information from the ICT team, and this is to be found in the affidavit of Hilda Kevongo, one, do not speak anything towards identifying any of those names that are contained in the affidavit of Commissioner Justice Nyang'aya. In fact, according to Hilda Kevongo, those logs speak to the ordinary applications that run the systems in IEBC on a day-to-day basis. If you read through them, because they are written in English, you'll find indications like daily update completed, news downloads for the day completed, At no point throughout the 7 or 8 pages, which is supposed to be a representation of the logs, does any of the names of these individuals feature. One then is left to wonder why such an inconsistency had to come in the manner in which it came. We have had allegations about certain named individuals. There's been an allegation about one Abdidahir Malim. My ladies, my lords, Abdidahir Malim was one of the returning officers, duly gazetted for purposes of this election. Like I earlier said, he then had access limited to the singular purpose of transmitting the Form 34B in relation to the area he was presiding over. That, therefore, is an authorized person. And indeed, Hilda goes on in her affidavit to confirm that all those other people who were mentioned were people who were duly authorized. There is the heavy weather that was made about the Venezuelans. A specific name has been dropped of one Gaidino Omar. My ladies and my lords, the contract between Smartmatic and IBC was for the supply and maintenance of the infrastructure that they had. It then meant that they had to bring their personnel to manage or just monitor the smooth running of that system. Of significance is that Hilda, in her affidavit, then goes on to say that before the election, these people were all logged out of the system, and that on the date of the election, none of these people was in the system, even for purposes of that maintenance. My ladies and my lords, it would make a lot of sense if somebody said that so and so got into the system and they interfered with the system in this manner. It is not enough for somebody to say Gumbo was found in the system, because what matters here is the allegation around manipulation and alteration of the results. Now, if we do not get into this space, what exactly are we talking about? I would want to again equate this to a situation where in your house, you decide to assign a plumber to do for you some work. When the plumber comes to do the work, then you raise an alarm and say, oh wait, there's a plumber in my house. How is a plumber to do the work that he's supposed to be doing in the house? Certainly, it does not make much sense. If you expect the plumber to fix the plumbing problem, then certainly you must give him access to the plumbing problem that you have. Now, I have looked at, and we've tried perusing through all these documents. There is not a single form that has been presented which appears to suggest, even in the lightest of ways, that there was any interference. And again, just relating this to the architecture of our elections, if at all there was any such interference, it would have been an interference that goes into the numbers. Now, because we have not seen that, is this the case then, therefore, why numbers has become a very dicey and perhaps an area where everybody would want to avoid or run away from? In the petition, I suppose the first and most important thing is you must demonstrate that you had specific numbers. Even if there's to be contest, let it be contest between this set of numbers and the other set of numbers. It can't be a contest between the man who was said to be the man in the middle and numbers. If that man was in the middle for sure and he had a job to do, then that is a man who slept on his job. Because we are not shown anything that he perhaps could have done while in the space that he is alleged to have done anything that would have interfered with the will of the people. Hilda continues to wonder in her affidavit as to why their boss, who is a commissioner, would expose them to that extent that they mention names of people who are employees and staff of the institution doing their legitimate work. Then you cast aspersion without basis that they were engaged in a criminal enterprise. My ladies and my lords, it might sound like a light issue, but we must have seen it in social media, in mainstream media, that these people, who some of whom ran this election, have had to go into keeping house. They've had to go into hiding because people read these sort of things and they imagine that this is the gospel truth. Certainly, this is not a light issue. Yesterday, there was extensive submission as to whether this court is handicapped in terms of dealing with some of these things. Now, as the IEBC, on the one hand, tries to improve the system based on the law and the guidance from this court, I think there's also a responsibility that should attach or follow where we have very deliberate attempts at misleading the court. If we look at, for instance, the logs that have been attached by John Mark Gidongo, if it turns out to be a forgery, does it not disclose an offense? It is not in my province to make that determination, but where I see it, it bothers me because as we go into elections this year, in 2027, we need to then sanitize some of these things that we do. And one of the ways of sanitizing them is by holding people to account, so that if you present evidence that is obviously not true or that is falsified, then you must stop to ask yourself whether there would be a consequence or not. That is the only way through which even this court would be able to sit, to be able to determine or preside over any of those matters that are presented with ease. I need to add that at the Bomas, which is the National Tallying Center, when the returning officers got to Bomas, what happened? Now, in the floor of Bomas, these returning officers would come with their original Form 34As, hand them to the national returning officer for purposes of a presidential election. After that, they would be subjected to an ICT team, and that ICT team was not sitting in isolation. They sat with the agents of the parties, they sat with observers, and what they were doing was to again confirm those security features we had spoken about. After that, they went into the detail around the numbers, comparing what they had in the Form 34As that were in the portal and the Form 34As that were then presented, the physical hard copies. From the direction and guidance of this court in 2017, Raila Odinga, what the commission was to do was to record those errors. I confirm, my ladies and my lords, that the commission did exactly that. The error report has been availed to this court, but of significance is that as they were preparing that error report, a copy of that error report was also availed to the agents of all the parties. This is important in the architecture of our elections. It is important because, as opposed to asking the court to now go through scrutiny, it will be a question of saying, wait a minute, in the error report, there's a difference between the results that came from member primary school, which I have either in my carbon copy from my agent, or that was presented by the returning officer, and what we are now seeing in the portal. That is the only way through which somebody could make an allegation that would stand the test of time. If you have that, then certainly, if you apply yourself in the, to understand the architecture of our electoral platform, then there is really no need to go into scrutiny, because that report is scrutiny by itself. In fact, it was a forensic audit. they had their watermark readers, they had their UV light readers, and these are things that are all contained in the affidavits of these three individuals that I've spoken about. When you take time, you look at that, and it is then our submission that to the extent that there is an allegation that there were interferences or that there were differences between the Form 34As in the portal and the Form 34As physically presented by those returning officers, there was none, and this is verifiable. Indeed, none has been presented before you. The last issue I'm to deal with is whether there was a difference between Form 34As uploaded on the IBC. Sorry, I think I've gotten into that point as well. And so, there was a question that was raised about Form 34C and the concern about the multiple entries. Submission was made by council that the Form 34C is supposed to be generated once. Again, that sort of submission would only come from a false, if not limited, understanding of the process. I say that because as the verification and retallying of the Form 34As were going on at the National Tallying Center, whenever they completed the verification and retallying of a constituency, they would then upload it onto the Form 34C after the completion of the verification. That then meant that that process had to be an incremental process. That is why when somebody says that there is a gentleman called so-and-so who accessed the server or the rear end of the result transmission network 1,000 times, it simply speaks to the fact that they had to make entries. It should not be lost that we were using, according to the jurisprudence in Maina Kiai, results from the polling station, which is the original Form 34A. Now, if we look at the number of the polling stations, it speaks to about 46,000 and a few hundreds. It then meant that a corresponding number of entries, entries had to be made on that Form 34C. And that, because I'd said it is supposed to be done incrementally, I would want to refer for clarity again to the affidavit of Commissioner Justice Nyang'aya. At paragraph 51 of the affidavit of Commissioner Justice Nyang'aya, he says, or he acknowledges, that indeed it would be inaccurate, impractical to expect the 7 commissioners to be the ones to do all these specific assignments that the commission is supposed to be doing. Similarly, and by parity of thought, when the law says that the commission shall, for purposes of this, generate that Form 34C, the law does not contemplate that the chairperson of a commission will sit with a laptop and make 46,000 plus entries by himself. This is what my learned senior counsel Kamau Karori was speaking to. This is what is contemplated under Section 11 and 11A of the IBC Act. And so, if we then tie this to the submission that he had earlier on made, that if we read under Article 138(3)(c), the Independent Electoral Commission to mean the entire institution, then we would not run into the problems that we are running into. Because as we saw, and as will be demonstrated in, by our subsequent speakers, that exactly is what happened. The entire bureaucracy or the entire institution of IBC participated in that process. As I conclude, I want to make a submission that when we make these allegations in our election petitions, perhaps we need to also ask ourselves if we have done that which the law contemplates of us. And that if the law gives you an opportunity to choose your agent for purposes of verifying or speaking to you in relation to the processes in the election, if you fail to present an agent, would it be appropriate to then come and burden the subsequent processes through applications such as what we're seeing for scrutiny? Because the law contemplates that that agent should be able to point you to the fact there's a problem in a particular primary school. Go there. Don't ask for the entire of a constituency. Don't ask for the entire of a county. And I think that has been the jurisprudence that has been developed. It then follows that we must sanctify the place of agents in our elections. And because agents are like our spouses, you choose your own. You choose the one you trust. If you get, nobody imposes an agent on you. If you choose one you don't trust, then really you can't blame anyone. If you choose one who does not understand why you assigned them that responsibility, again, you cannot possibly blame anyone. So, as I seek to take my seat, we ask, my ladies and my lords, that in the usual strong manner in which you've spoken in relation to these issues, and following the very lengthy submissions that we had yesterday, we also rely on you to help us clean this electoral system, so that as the commission does its part, on the other hand, the public and every other person must also do their part. I am most obliged, and thank you for according me this opportunity.
My Lady the Chief Justice, the Deputy Chief Justice, and the members of the Supreme Court, it's indeed a great honor to appear before you in relation to this petition. My role today here is to take you through the numbers. I will take you through the numbers. The numbers will be running on the screen.
Your name, please.
My name is Mahar Somane Advocate. My name is Mahar Somane Advocate. I'll take you through the numbers as it relates to the petition that has been filed. I will also give you an audit trail of mechanism which the court can use to measure the petition. The first question that I'll answer today relates to the question that has been put to us. And the first one is whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kachaliba, Rongai, and Pokot South constituencies, and electoral wards in Nyaki West, in North Imenti, and Kwanjenga in Embakasi resulted in voter suppression. The allegation of voter suppression due to postponement of these elections is not a question of hypothesis. It's a question of fact. It's a question of numbers. What I have done is we have gone through the numbers to give you a comparative data on whether the same is true. The first one, as it relates to Kitui Rural, we have gotten the data for the constituencies in Kitui. Your Ladyship, if you look at the constituencies for Kitui, the voter turnout for Kitui Rural was 60.29%. So for us to actually make a comparative data and analysis to actually see whether there's been voter suppression, we look at the constituencies nearby and see the data we are getting from the constituencies nearby, whether the inference can be made by this court that there has been voter suppression. The voter turnout for Kitui Rural is 60.29%. I have highlighted in yellow in your screens. It is comparatively similar to the voter turnout in Kitui Central. In fact, it is Kitui Rural is higher Kitui Central is 60.10. It's comparative to Mwingi Central. So to the question the court asked, whether there was voter suppression in Kitui Central constituency because of the postponed election, the answer is an emphatic no. I will go to the second question. The second question the court asked is whether the postponement of elections in Kachaliba and Pokot South led to a voter suppression that led to a low voter turnout in favor of the petitioner. The answer is data-based. I have provided the comparative analysis. I want the court to look at it. The voter turnout for West Pokot was 81.44. The voter turnout for West Pokot, for Kachaliba was 81.44. I have highlighted in yellow. The voter turnout for Pokot South is 80.44. It is higher than Kapenguria. It is higher than Sigor. Comparatively, in fact, those voter turnouts were higher than the ones which the elections were not proposed. That claim falls flat on the data that were provided to court. I will proceed. I will go to Rongai. The question the court asks is whether the postponed elections in Rongai led to suppression of voter. I have provided the data on Rongai. The voter turnout of Rongai was 61.41 for the presidential. It is higher than in Joro. It is higher than in Naivasha. And it's comparatively similar to the other similar constituencies. To the allegation that there was voter suppression in those places because of the election that was postponed, that allegation is untrue, falls flat on the data we have provided. To the other question, whether the postponed elections in the MCA ward for Nyaki West led to voter suppression, the voter turnout for Nyaki West was 64.32. If you look at North Imenti, it was even lower. It's comparatively similar to the other we have provided. To that allegation, that falls flat on the data than the comparative data we have provided. To the allegation that the MCA ward in Kwanjenga, that there was voter suppression because of that, the MCA ward in Kwanjenga, the voter turnout was 46.32, comparatively similar to Embakasi South, which is 49.62, comparatively similar to Imara Daima and also in Pipeline. To that allegation, when you look at the comparative data, it's not a matter of hypothesis, it is not borne out by the data. To the allegation that the postponed elections in Kakamega led to voter suppression in terms of the petitioner's votes being undercast, the allegation falls flat on the comparative data. We have provided the data for Vihiga, which is similar. Bungoma was a bit higher, but Vihiga is the same. So comparatively, when you look at those data points, that allegation falls flat. To the allegation that in Mombasa, there was a voter suppression because of the election that was run, I want to point out, even in 2017, the general voter turnout in Mombasa is generally very low. That data is available. It's always lower than the other constituencies. But comparatively, it is almost something that is comparable. To those, so I have answered. So to the question that the court put out on the comparative data, the answer is there was no voter suppression in those places. Senior Counsel Kamau Karori has already explained on the reasons why those elections was not held. There was nothing premeditated about those elections, not holding those elections. Reasons have been given in the affidavits of the chairman Wafula Chebukati and Marjan Hussein Marjan. So to that allegation, we want to show the court the petitioners have a hypothesis. We have provided the data to the court to actually aid the court to come to a conclusion. The second question I want to answer that the court put out to us was whether there are unexplainable discrepancies between the votes cast for the presidential candidates and other elective posts. Indeed, if there was unexplainable discrepancies, is a grave issue, which we know. We will show through the data that we have provided to the court that the same is not true. In fact, we can account for each ballot. To just guide the court, refer to the affidavit of Moses Ledama Sunkuli, which is on record. We have provided the comparative analysis. In fact, what I did is we provided the 34C, the 37C, 38C, and 39C. Those are the forms for the governor, the senator, and the women rep. We tallied against the presidential. I want to refer the court to paragraph 36 of Moses Ledama's affidavit for the court to look at it. And if you do a tally, and we started with a tally for Senate, if you do a tally for the votes that were cast for the Senate, vis-a-vis, and that, your ladyship, that runs from page 13 of Ledama's affidavit up to page 15. And I just did the summary analysis, but there's a very big big comparative table that I've put out there. If you do the analysis, you will come to the following conclusion. What is the voter difference between the senator and the presidential? 500 votes. The variance. And how do we account for those variance? So when you do the presidential like for like and the senator, you will get a difference of 22,801. You have to minus diaspora voters, which only vote for the presidential. You have to minus prisons, which only vote in the presidential elections. Okay? And then you have to look at stations which were affected and did not have any results for any of those elective posts. For example, in some of the stations, some few stations, some violence happened. Likely they did not report for Senate. When you do that analysis, you will get the differential is 500 votes. I have done an elaborate analysis also on the stray ballots. When we get to that, I will explain. So the differential between the Senate and the presidential is 500 votes. And that 500 votes, we can account for in stray ballots. I have attached the polling day diaries for Kibra and Makadara. I have done an analysis to actually check what is the stray ballot per constituency. And this tally is like for like. So to the question whether there was discrepancy between the presidential and the Senate vote, the answer is an emphatic no. It is explainable by looking at what the information that we have provided. To the second question, whether there was a discrepancy between the women member of National Assembly for the women rep as compared to the presidential, I will tell the court to look at page 18, page 17 and 18 of Moses Ledama's affidavit. And our answer is there is no much difference. And the differences can be accounted for. The variance analysis we have provided. To the question whether there was a discrepancy between governor and presidential, we have also explained that there's no such variance. Petitioners have been talking of variance of 800,000, 900,000. There's no such variance. And in fact, the small variance that you will see for the women rep, which is 9,419, can be explained for by the stray ballots. A small analysis we did for the stray ballots, Your Lordship, is that in Kebra constituency alone, we did a stray ballot analysis, and it's shown there. So to explain, and this is how we understood the court to mean the duty of the IEBC is to explain each ballot cast and track that ballot to see where it has gone. So once we do the analysis for the presidential and we remove the prison voters, once we remove the people who voted for diaspora, once we removed some of the small polling stations that did not report for any of those seats, you will see a small variance. So we thought the court will ask where that small variance is coming from. And so what I did is we went and we went to sample one of the constituencies in Nairobi. And in one of the constituencies, Kibra constituency, we got 405 stray ballots. So you can't account for the way it will work is it will take from any of those ballots small incremental numbers. So you will see a variance of 500 here, 200 here, but cumulatively it is not something that cannot be explained. And I have attached all the polling day diaries. In fact, if you look at the Form 34A, which was supplied to the court, some of the comments section will indicate that they found some stray ballot in the presidential ballot. But to the court, whether there is discrepancy between the senatorial, governor, and the women rep seats, as compared to the presidential, there is none. We have demonstrated that with data. And even when there's a small variance, we have shown the stray ballots that cumulatively over those 3 seats, that will be there. A question was, a submission was made by learned counsel, Ms. Julie Soweto, that there is 33 per polling station stray ballots in Kirinyaga. I will explain that. I don't know what numbers they are using. is an old litigation strategy in numbers for shock and awe. I think what they are trying to, if you look at the numbers for Kirinyaga, there's no difference between presidential and the governor of 22,000. In fact, the variance is 900 votes, which can be explained for by the stray ballots. The number they have indicated for governor, I don't know where they have gotten it from, is not what is in our 37C, and we've indicated that in our submission and also in our presentation. So to the question that the court asked, that whether there are inexplainable discrepancies between the votes cast for presidential as against the governor, for presidential as against the women rep, for presidential as against the Senate, the same is not borne out by the data that we have provided to the court. Now I'll go to another issue which was made heavy weather of by learned counsels on the voter turnout. Justice Muki Wanjala asked, how important is the voter turnout to the actual valid votes and to the actual declarations? Of course, it's an important issue. The only problem with it is that counsel are not understanding how we calculate voter turnout. And I want to explain to the court how voter turnout calculation is done using the kits. Pursuant to the Maina Kiai case, the court was very emphatic that elections must be conducted at the polling stations. And pursuant to that, voter turnout reporting is done per polling station. So how do we do it? When the polling station opens and Kenyans are voting, depending on the network access of the kits will be sending us information every 2 hours. The kit will be telling us 200 people has passed by this kit in this polling station, and that information will be collated until the end of polling day. So two things to note here. The first one is that the reporting is done per KIMS, per polling station of the reporting KIMS. So for example, on the 9th August 2022, when the polls closed, the IEBC gave a turnout figure of 56.1679%, which is the percentage turnout. That correlated to the total number of registered voters in those schemes, in those polling stations. The problem that the petitioners are having, they are saying these 56.1679% you announced must be of the total people in the register, which is 22,140,258. 120,258. We don't do that. We report per KIMS. So if 200 people reported in that KIM and the number of registered voters is 600, we say 200 of 600 voters. We add the next KIM, 300 people have reported, we say 300 over 600 voters. The next KIM, 400 KIMs have reported, 400 over 600. We keep on aggregating until we see how many KIMs have reported of those polling stations. Why do we do that? Because of two reasons. The first one is, which is in the affidavit of Hussein Marjan and the affidavit of the chairman, because of network issues in some places, far-flung places in Kenya, some of those KIMs will report late. Some of those KIMs will report much later. So if we did a number over the total number of registered voters, we'll be giving a false turnout. So the turnout we give is based on the aggregated voters of the reporting station in that KIM. So if you took when we announced The 56.1679% is based on the total registered voters in those stations who have reported in those schemes, which was 21,481,642. Your Ladyship, you'll realize this is much lower than the total number of registered voters. And we'll keep on accumulating. Kims will keep on reporting. 235 polling stations went manual. We will have to later on aggregate the 235 polling stations which went manual. Then we come with a total voter turnout. And if that is the reporting we do, two arguments that have been made in the petition of Omtata and in the petition of number 5 fall off. The first one is, their contention is that the chairman announced a turnout on 10th August 2022. That is the third line, Your Ladyship and members of the court, announced a turnout of 65.4%. What we have indicated is 64.6%. Your Ladyship, I will pause there to just inform the court that the chairman clarified that statement. The recording is in the affidavit of the chairman. And the actual clarification the chairman gave, he said that the total reporting polling stations, and if you hear his statement, it will give some clarification. We never say the total number of registered voters, because we will have that information when our manual count and everything has reported. We say total number of polling stations reporting. So in those schemes. So they're saying 64.6% must be of the total registered voters. That is their contention. That is their voter turnout. That is not the voter turnout of IEBC. The voter turnout as a percentage was, at that point, 64.6%. The number of reporting Kims were 21,926,565. You will notice from this number, there are some polling Kims which haven't reported. As they go to the constituency tallying center, those Kims will report. You will also notice that we haven't included the manual count to give us a total figure of the total voters who will have registered, who will have reported. On 10 August, when all the Kims returns have come from all the polling stations, the number of persons identified, that is the last number on the table, 14,239,862. As against the total registered voters in those stations which reuse the Kims, 22,005,541, giving a turnout of 64.7103. You notice, Your Ladyship, we haven't included the manual count. So that is all Kims in all polling stations. What remains now? Manual count. And this is important. I will pause there. We were very deliberate in trying to help the court in be able to identify and actually provide an audit process for the contesting parties' allegations. In the affidavit of Michael Ouma, we have attached 7 volumes of the Kims returns for every polling stations in the Republic. Why is that important for the petitioners and the court? That is the first audit trail process. How is it at the first audit trail process of? We've provided the Kims returns per polling stations in the Republic. We've also provided the certified copy of the 30A. So if anyone wanted to look at how many people pass in that polling station, you will look at your Kims return, you will look at your 34A. And if there is any inconsistencies between the Kims return and the 34A provided to the court, then question can be asked to our client. So in providing an audit trail process, the first way of providing an audit, which is both manual and electronic, is the Kims return provided in the affidavit of Michael Ouma in 7 volumes, as against the certified copy of 34A we provided as per the regulations of this court. So we provided that. And if you look at those Kims returns, they will correspond with this. They are from 45,994 polling stations. The number identified by Kims, 14,229,862. The total number of registered voters, 22,005,591. And the percentage is as indicated. We've indicated how many Kims there were. And I just want to and after the aggregation of the manual and the Kims, and that's the table that's there. So to the question, I think that is important for the court, and the court will ask, is the first question that the court will ask, what is the registered voters in the Republic? And I think that is not contested. 22,120,458. I think it's in the affidavit of everyone, that the register is publicly available, that can be accessed. How many polling stations do we have in the Republic? 46,229. How many people are registered in those polling stations? 22,120,458. How many polling stations were authenticated through using the kits? 45,994. How many registered voters are those in those polling stations? 14,239,862. What are the registered voters in those polling stations authenticated through the kits? 22,005,591. What are the polling stations that were not authenticated through the kits? 235, out of which 6 polling stations, 3 in Eldas and 3 in Quisero, there was violence. And no voting took place, in fact, at the time of that. And so how many polling stations went manual? Using complementary system, 229. What are the number of voters authenticated through the complementary manual system? 86,889. What are the registered voters in those 235 polling stations? 114,917. Why are these numbers important? They are important for audit trail. First, we have provided the Kims returns to the court, which can be compared as against. Secondly, 99.9914% of Kenyans were authenticated through the Kims. Less than 0.001 Kenyans were authenticated through a complementary mechanism. And the reason why I go back to that is giving the court an integrity check as to what we did. So if we are telling the court that 99.99% of Kenyans were authenticated through the kits, we have provided the receipts from those kits to the court, we have provided the Form 34A, then the court can compare and will bear out the work we did. Another allegation falls off. So what is the allegation in the Omtata petition? And I will go back to the turnout table. Your Ladyship. They are saying that the turnout announced by the chairman on 10th August 2022 must be over the total registered voters. That is where the mysterious 140,000 is coming from. So they are saying the 64.60 must be from the 22,124,58. We are telling them that is not how we calculate our turnout. It was very easy to confirm with us and ask us how you do it. We're telling them that number is out of 21,926,565. We could not do it over the registered voters because some stations went manual, some Kims had not reported. How will we give a number over a total in which we don't know the status of some of those stations? Because the returns have to come for us to be able to give that. So they're saying 64.6 over the total voter turnout will give you 140,000. IEBC has not accounted for 140,000 voters. It's a lie. I think they are wrong on the maths, and they are wrong on the substance, and they are wrong on the substratum of how we are calculating that. And I think it's imperative that the court understands that. So the issue of 140,000 is not here nor there, and we have demonstrated that. And the second issue is they say that there was 110 voters error, 110 error in the Form C. By virtue of that, the Form C is not a valid vote. We have acknowledged that error. It's a data entry error in 2 stations in Kilifi and 1 station in West Pokot. It is the error form for the C is attached to the chairman's affidavit of 110. The form C is a collation of 46,229 polling stations, and there is an error of 110 in which we have explained the data entry. I think that is not something that is material to the form C for the court to say that a form C is invalid because of an error which you have acknowledged. Your Ladyship, we also want to confirm to the court, we have done an error report for each and every polling station in the Republic. And this is going to be, and we really are craving for the scrutiny report to bear, and this will bear us out. That the voters, what Kenyans voted on the 9th of August is what was transmitted, and it's what was actually announced by the chairman. The will of the Kenyan people was carried out through and through. And that will be borne on by the scrutiny of those ballot boxes. That will be borne out by the information and the data we have given. And that is really, really important. The other issue I want to actually address is allegations that have been, Your Ladyship, if I could just go to the affidavit of Mother, I mean, this is what I was talking to. I mean, there's an allegation of paragraph 96 of the affidavit of the petitioner that alleges there's a variance of 25,000 between governor and president. The correct position is there's a variance of 900. It's worth noting the county is home to 2 prisons. And this is what the court should, and we can provide the court with, even if the court is inclined to even order us to bring all the original Form 34As and the Cs. We are ready and willing to provide that to the court. Some of these allegations, when you look at it, you really cringe that the allegations that are being made on these numbers, they have no basis. You will actually wonder how will someone write something like that in the petition? We have provided a tally of our the C series for the governor, for the senator, and the women rep. And we're ready to provide that to the court. We have put that in our affidavit. We are ready to provide whatever the courts will require to actually prove some of those numbers that are being banded. And some of these numbers are just meant for awe and shock, because it is very shocking to the court, to the conscience of the court, if you are told there are 25,000 people who walked into the polling stations in Kirinyaga, voted for the presidential candidate and did not vote for anyone else. It's really amazing. I will expect a variance because of the small stray ballots here and there, or maybe the prisons and diaspora, but it will not be 25,000. It's something should be that is explainable. And that is why the petitioners are wrong on the data, they are wrong on the numbers. And I will also demonstrate they are very wrong on even the ICT. I will add on to what Judge Eric Bumbo had also submitted. There are 2 allegations that are being made that the Form 34A, and I want to explain this to the court. So we have 3 audit trails or 3 verification processes for the court. The first I mentioned, it's the EVI, the electronic voter identification. We have given the KIMS return to the court. So the court will look at the KIMS returns and look at the AOL, the tally. The second one is when the Form 34A is being sent, and I've seen a lot of wild allegations being made, and I want to just explain this to the court. At the end of the polling, what happens is the kit, it converts itself into an RTS system, a result transmission system. The PO scans a QR code, it gives him a transition system. So it tells him, okay, Mr. PO, what do you want to transmit? Enter your PIN. He will enter his code. It gives him a query. You tell him, what do you want to do? He says, I want to transmit 34A. It tells him, okay, can you confirm the following checks have happened? And that's a validation check. Can you confirm that this form is signed by a PO? He says, yes. Can you confirm that this form is signed by a DRO, a deputy PO? He says, yes. Can you confirm this form is a 34A? He says, yes. Can you confirm this form has been signed by the agents? He says, yes. So after saying all that, then he tells him, take an image. And there's a lot of things being bandied here about the image. And we can provide, I think we've done training for the IBC has done training for everyone, for LSK and the judges. And this is something that we can even provide if the kits are required. The kit takes an image, embedded in it, it has a scanner, and the image that is embedded in the KIMS. So it's taking the image, and it's taking the image and scanning it as a PDF. We don't have any other output. We don't, and there's a reason why I'll explain to you why that input is being made, why it's like that for purposes of the security and the other purposes. He takes the image. It actually tells him if the image is not clear, it will tell him your image is not clear. Please retake it. So he takes his image and he presses send. That image travels from that, it is gone. He cannot recall. In fact, even if he does not have network, it will tell him the image has been sent. It will arrive when it will arrive. That image cannot be recalled in PDF. There's nothing that can be called. That scanned image in PDF, there's nothing that can be done about it. That is gone. When he gets a network, or immediately if he has network, it will hit our portal. Now, when it hits our portal, it's something akin to someone who's coming in the Supreme Court. The Supreme Court is established by the Constitution, and it has the jurisdiction by the court is limited by the Constitution. So those forms answer some jurisdiction questions before they are admitted into the public portal. What are those questions? So they ask, okay, you have come here, you have come into the court. If you want to sit here inside the court, answer the following question. They ask, are you a 34A? He says, yes, I am a 34A. Okay, do you confirm that you come from the code of the polling station? So it has a code of the polling station. So it will run against the polling station codes, it will confirm. Then it is asked, okay, we've confirmed you are an A, we've confirmed that you are from the code of the polling station provided to us, because all our polling stations have specific codes. Then we ask them, then it's asked the third question, do you come from a serial number of our kit? Then he answers, yes, I am from the serial number of the kit. If it is another form which is coming, are you from, if it's not from a serial number, it checks, it says, no, you can't come in here, you have no jurisdiction. So it says, do you come from a serial number of our kit? It says, yes. Then it's asked, do you come from the SIM card that has been provided officially, that we have the list for from the various providers? It answers yes. Then it's given two security features, which are very important for the court. So it's given two security features. It is given a date stamp. And I urge the court to interact with the public portal. I want to confirm to the court, 800 million persons access our portal. It did not even blink for a second. Its security, its firewalls, and the SOC are military grade. And in fact, a lot of the allegations that are coming from the other side is, people are so frustrated in trying to hack our system is, why is your system so good? Our system is so good because it's based on blockchain. It actually, what it does, it actually gives resources as is required. If the 50 million Kenyans logged in now to our portal, it will give them without even stuttering whatever form they want. And it will allocate resources on how many people. Out of those 380 million people, 300 million were Kenyans who downloaded, who looked at the result. So after asking that, it gives two things. It gives a timestamp. The form is given a timestamp, and it's given a date stamp. Now, with that, one of the allegations of staging falls away. So someone is telling you, someone captured a form, amended it, returned it. I am telling you, all my forms have a date and timestamp to the millisecond. And there is no one form that has been transmitted at the same time. And in fact, if you look at the portal, you will see that. You open the portal, if you look at the tab of the portal, it will say 34A. It will tell you the polling station. It will tell you the KIM serial. It will tell you the date the form came. And how precise is this system? Some of those forms came on the date of the election. Some of the forms, because of tallying, came a day later. Some of them came 2 days later because of the elections in Eldas. And it will give you the timestamp to the millisecond. And actually, if you look at it, so if someone is telling you, oh, we had staging of 11,000 forms, you will expect that to the millisecond, right? To the millisecond, you will get 11,000 forms which have been uploaded. And I want to inform the court, there is no one who can upload the Form 34A. Form 34A are only transmitted from the KIMS by the PO. Neither Wafula Chebukati, nor Hussein Marjan, nor Boya Molu, nor anyone else can upload Form 34A. Form 34A is transmitted from the polling station, goes, and that is the end of that story. And once it goes, it asks those questions. Now, our forms are designed that way. Why? Some of the forms that have been brought to you, and with due tremendous respect, I spend a lot of time with my ICT people and look at some. Some of those forms are doctored forms. Why are they doctored? Because of the audit trail that will not allow anyone to be able to actually not be able to verify our forms. Why? So I told you about the EVID and the KIMS, returns plus the form. So these forms have 3 manual processes and 3 electronic processes that check each other for the court. And this is very important for the court to actually assess those allegations. So what are the 3 manual processes? PO fills the forms, gives to the agent, paste it there, okay? Travel, so the first one, if you had an agent there, you will get your form. Or it will be in the polling station, it will be stamped in the polling station. The second one is, okay, I didn't have a PO. What check do I have? So I will, both someone who did not have an agent and person who had. So if I didn't have an agent in the polling station, that form travels to the arrow. What does the arrow do with the form? His PO will sit there, he will tell him, I have received the form in the portal, I want to confirm the form you have brought me is the same as the portal. Is it the same serial number? Is it from that KIMS kit? Does the tally agree with what is in the portal? He has a back end for his B, because he has to start populating his B. So he takes the form. So we allow at the Constituent Tallying Center to have agents. If you want copies of the form, can be given. So if you didn't have agent at the polling station, you can still get your form at the Constituent Tallying Center. So say you didn't have an agent at the Constituency Tallying Center, you didn't have an agent at the polling station. We bring the form out to the National Tallying Center. And I think this is the reason why this court made the decision that the chairman must verify each and every form. And court will take judicial notice of what was going on in Bomas. We had 14 verification desks. The arrow will come. I had the pleasure of actually going through the process. The arrow will come. He will be told, okay, you've come with your forms, sit. He will be admitted. And then the verification desk will have all the 4 agents for all the presidential candidates. We take the forms as they are. We make copies of the originals for them. Remember, they have their agents' forms. We make copies of the original. We tell them, okay, these are the copies of our original. Have your agent's forms, compare with our originals, but also what we are going to do is not a verification process. We'll do a forensic audit for you. We'll call the arrow. He will sit on the table there. He will go form by form. Is it the same serial number? Is it from that polling station? We provided microtext readers. We provided watermark readers of the originals. The agents are seated there. They will check, and they will look at it. And the form will have the IEBC. It will have the watermark reader. It will have everything. So even if you don't have the forms at the CTC and at the polling station, and you had the form at the constituency, and you are given the form as at the NTC, you could still verify and actually check. After that, they will go to an ICT desk. The ICT now will confirm whether those forms and what is in the portal is the same. And some of the persons who've sworn some of the affidavits in the petition were seated on those tables. The ICT will open up this portal. He say, oh, this is the public portal. I am looking at the form. Let's confirm what is in the form, what is in the, do they tally? They tally. If there's any issue, we do an error report, which we have provided to the court. We have provided error report to them. That process is documented. And even if you didn't have all those agents, then you had an opportunity to do at the National Tallying Center. After that, we tell them, okay, we've started populating the C. Now, have you verified this polling station? Yes. Okay, now we put that into our C. And the idea that the C was kept on changing and some officers had access to the C, actually that allegation falls off. Why? 14 officers, and we've attached that into the affidavit of Martin Nyaga, including the chairman's PA, Mr. Abdi Dair, who is a registered, who is a returning officer, and 14 other persons were mandated to actually do that verification process on the table. There's a process for them to be given that access, and the access, what access do they have? People are burning up a lot of things, servers and things like that. So there are 3 applications level in any system. You will have the application, you will have the operating system and the network. Okay? So everyone has access. So they have access for the verification of the 34C. So they'll be told, we're putting in this polling station to the C, are you okay with it? Does this tally with what is in the original? They will say yes, that is populated. When we finish for one constituency, we print that aspect of the form 34C. Because form 34C is something that is gradual. The verified form from the form that has traveled from Kipini in Lamu to the CTC, Constituency Tallying Center, through the portal, physically through Bomas, through the verification desks of the agents and the people complaining here, now they are told, are you okay if we put into the C? It's put into the C. It's printed out, and that is what was being announced. So if you got the logs for the C, it will say, the person who's authorized printed out a C because it was being announced. Some of those commissioners now complaining were announcing those forms, and it's incremental. It will go on until we finish. Now coming back to the form. So the first security feature is, if you look at the portal I've indicated, it has all those. But we've put security features to enable the court and everyone to authenticate our forms. If you open our forms in Acrobat Reader, you will get a signature panel. You will get a signature panel. And the signature panel is able to tell you the path of validation of our forms. It will tell you that this form, in fact, the timestamp you will get on the signature panel is the same as the timestamp when that form was received at the portal. And I've projected, your ladyship have projected there. And if you are a good acrobat, it will tell you, it will give you a signature panel. It will tell you that this form was not first modified. If you have any PDF form document and you have modified, it will tell you this document was modified on this date by XYZ. It will tell you this form has not been modified from that day. It will also give you assigning a signature. You see that time there? That is the time that is on the when it was received on the portal. It's the same timestamp that when you open any form on the portal, it will indicate. So the allegation that forms were intercepted, staging happened, the authentication of our forms are very robust. So the second one now. So how is someone able to prove that our forms do not tally with what is in the portal? You only have to do one thing. You have to download our forms from the portal, get a relatively good Photoshop, and change the numbers on the tally. And I'll come to those allegations where the 34A in the portal are the same as what was given to the agents. We have provided 44 affidavits from various POs. Some of our POs who are Kenyans have had a very sleepless nights. Allegations have been made against them that the forms they brought to the ROs were different from what was announced. The allegations of an affidavit made by someone should be checked against the affidavits of each and every polling station clerk and polling presiding officer who we have endeavored to give the affidavits to the court. And we have given 44 affidavits for presiding officers on these allegations, and many more affidavits for the returning officers. So the only way you will be able to show is you have to check, print out our form. And the problem with that one is because you cannot do anything about this, where the agents and everything sign, you have to get a Photoshop, amend it to JPEG, get a Photoshop, and actually just remove with the tally. But like every other plan, it has a lot of weaknesses. And the first weakness you will get is, and the first thing they say is, in Gaina polling station, in Tiati that their agent provided them a form. And this is really important for the court. We say untruths have only one leg. They don't have two legs to stand on. The truth stands firm. They say in Gaina polling station, and this is in the affidavit of Arnold Ochieng, that their agent provided them a form. The form is different to what is in the portal. If you look at what is in the portal, that is in the affidavit of Moses Unkuli, and even the form he has attached himself, it says there was no agent in Gaina polling station. We haven't even gone to authentication and the verification of the process and the form, and I will show that why this is a bad Photoshop gone wrong. So the first allegation is, in Gaina polling station, their agent gave them a form. The tally for their presidential candidate is different from that. Guess what? The form they provided does not indicate there was no agent. And even our portal says there was no agent for any candidate, not only for them. In Gaina, there was no agent for, I don't know why the party didn't send an agent there. Maybe because of security in Tiati, or we don't know. But there was no agent for anyone. He says, I had an agent, and this is his tally. So to the question that whether the forms provided by the agents are the same as what is in the portal, the court has to come to one conclusion. Those forms that are being provided in those stations are doctored. They are forgeries, and bad forgeries at that. The first paragraph of that affidavit says so. The other thing you will notice, that what they have attached, we were very deliberate why our KIMS kit will have an imaging software embedded and sent in PDF. One is because of the security I've indicated. The second one is because, since it is black and white, and agents will be taking pictures of the form, we wanted to differentiate between what the agents are taking with their form and what we are sending ourselves. So what have they done? Our forms have been printed from the portal, converted to JPEG, numbers fudged. But the problem is, all the background for those forms are our KIMS kit. It's what we sent in the portal. And I've indicated that in the affidavit of Moses Unkuli. The second and the more problematic thing, and analytically the court will ask, is it possible that 44 agents all over Kenya will take pictures of forms in black and white, the same as the background of our KIMS kit? And the reason is because of the robustness of our processes. Because we have a manual check and we also have an electronic check. The manual check I have described, the electronic check, the EVI. The second electronic check, I have described how our forms arrives. So if someone made an allegation that, oh, the form of my agent is different from what I have, the court should ask, okay, we have a portal, we have IEBC POs who are saying something else, we have the original, which has gone different stages. How come it's only your form? And what is fudged, Your Ladyship, I want to point out to the court, is the only thing that has been amended in those forms is the number of tallies. Why have they done that? To tell the court, oh, look, IEBC portal is different from what we have. Okay, if you are thinking, and the challenge that I have been given the challenge that I've been told by my ICT people is we will leave our portal open for another year. If any one of these people who are alleging anything, let them go upload one form. And we took our constitutional duty very seriously to give that audit trail to the court, for the court to be able to make a determined decision. I will mention 3 things on ICT. The first one is John Gidongo has given us an affidavit, which we have answered with Martin Nyaga's affidavit. He has given forged logs. And when we actually answered and actually told him these are forged logs from 2017, he said, oh, these are demo, but these are the real ones. But I think the court should look at the real logs. For example, one of the logs that is attached is the one for Justice Nyangaya. Justice Nyangaya attached Linux cron logs. The ladyship is like, and he says these people had access. It's easy to read those logs. They did not mention, no one of those people had access. It's like someone telling you, as you are using your computer, it's running background information, it will give a lot of, the OS will be running. It gives a lot of information. And someone says, oh, Emma had accessed the laptop of the judges and did this. And the information that person is giving you is the OS system. Oh, this server, there was an update of this program, there was this. If there was any evidence of that, you should provide something that says this person accessed at this day on this at this time. So even the logs which are attached to Justice Nyanga's affidavit are not things that will bear out the allegations they are making. The second thing that I want to mention to the court is the affidavit. A lot of people have made the submissions by the petitioners was that the affidavit of Benson Wesonga and John Joroge proves there was access. We've answered those affidavits, and you will really, it will surprise this court that Joroge says, I audited the IEBC system. And in answering the first question, we told him, that is a criminal offense. How do you have access to the IEBC system? Which, of course, is a lie. Then he attaches logs. Some of them cooked up, but some of them we've answered. So, for example, he says, the chairman's PA, a gentleman of repute and an advocate of this court who's been a row all over the country, who was part of the 15 people who were doing verification on the bomber's desk, who all the agents were present when they were making the verification of the C. Oh, him he accessed, and 2 other people. How many times? 1,000 times. First, what did they access? I told you, no one can access or upload anything apart from the Kim Sone. What they accessed was at the verification panel for the C, and all the agents were there. Did they require the chairman to sit there entering manually the 46? And in fact, we have attached the authorization for each and every person who was seated on that table. And the court should take judicial notice of what was going on in Bomas and the constitutional timeline relating to the 7 day. Those people had access, the agents were there, everyone was there, and of course, they will verify. He verified 1,000, another person will verify 800. They are Kenyans who have not slept for 5-6 days to actually undertake a constitutional duty of a higher calling. Not well remunerated people who hadn't slept for 6-7 days. They are actually, what they are doing is, they access. Yes, what were they supposed to do? They will access the RTS panel for the C. They will verify you are there. The deponent was on the floor of Bomas. Joroge was there. Their agents were there. The ICT was there. And the court should make note of, there was no one allegation that a form that is in the portal was different than an original which they had verified as relates to the tally. So there's another argument that they say, oh, our client, the petitioner votes were deducted and added to this. We told them, show us the proof. How are they deducted? We have 7 proofs. So in mathematics, you use proofs to prove a point, to prove knowns and unknowns. We have 7 proofs. We have our arrows at the polling station. They had agents. You had agents at the CTC. We have the original. You have agents at the NTC. We have original. We have what is transmitted in the portal. We have original. All of them tally, and you are saying your client's votes were deducted. How? I will mention a small issue on the register. I want to note the court, we understood the issues as framed by the court as those issues. The issue of the register was not one of the issues. We have answered in the at paragraph 85 of Hussein Marjan and Michael Omar's affidavits. We did an audit as per the law. The audit was as required by the law, was transmitted to the Speaker of both houses. We did a resolution of most of those audit processes. We have documented what has been done. 262,000 deceased people were removed. There were some Kenyans who were registered both with their passport and IDs. And that process of audit is an ongoing process. We will endeavor to complete it, but I want to confirm to the court that that audit process undertook, and we acted on that audit process, and we went to with a clean register. With the elections. An allegation was made that, oh, your client was printing 34 A's, many of them to actually do something untoward. We want to tell the court, and we have put before the court, that the reason that was actually done, book 2 of 2 and book 1 of 1, is to ensure that as many Kenyans as possible had copies of the 34A. So you have a form 34A, and if you printed only 6 copies, one copy goes to the ballot box. 1 copy is supposed to be attached to the polling station. Those are 2 copies. 4 copies are supposed to be given to presidential copies to the presidential candidate. Then we have an issue that a copy has to go to the RO. And what we did is we wanted to print many copies of the A's for the purposes of the result. And the reason why, because the carbon copy, if you reach 6 and you are actually writing on the carbon copy that you are giving copies of, when you reach the 3rd copy, it will not even be able to, you will not be able to read it. When that happened, the petitioners, together with religious leaders, traveled to Greece, and they raised an issue. They say they did not want book 2 of 2. So what did we do? We just gave instructions. We had a meeting with them. The same was shared by the chairman. The chairman, the same directive was given to our officers, and when they opened the polling stations, book 2 of 2 was being put in the ballot box. 34 2 of 2. An allegation was made, and this is, I think my ICT people have told me they actually want to buy the patent of this technology, that a JPEG of handwritten document can be converted to CSV, amended, on a form that has signatures and watermark, and converted back to PDF and uploaded. If such technology exists, we actually want to buy its patent. It's actually impossible to do that. And that is why all of the forms that have been submitted, the only thing that can be done is you have to just look at the tally numbers and try to use Photoshop to change the tally numbers. You can't do that, because the verification process has 8 stages. This form is widely available from the village to the NTC, that for someone to say that, oh, my 34A has been tampered with, it's impossibility. To just conclude, the petitioner's case says 500,000 Kenyans who conducted the elections, POs, deputy POs, ROs, and everyone, conspired against them. That is, the numbers don't pan out. the allegations of the form don't pan out. And the question I kept on asking, and this court should ask, is, what if on the day of the election, God forbid, that the RTS system of IEBC collapsed? And the only thing that is available to this court are original Form 34As. Will this court say, since your RTS system collapsed, there's no election that you held, that the franchise and the vote of the Kenyan cannot be gotten from those ballot boxes and those forms? And the second question, and which is really, and we have indicated that in the firewalls and the affidavit of Hila Kavogo, and how robust our system was, and how many who tried to do that. The other question is, 300 million Kenyans access that portal. They know the results as indicated. Those results can be verified from the forms original available, from the forms of the agent. And I think the court should make a determination that their numbers don't add up. The allegations of the form fall flat on what we have demonstrated. And the allegations relating to forms in the portal being different from what their agents have are an attempt to actually present the court with evidence that it forged. And the court should actually look at those documents, look at those forged logs, and take necessary action against any officer who will have presented those logs or documents. Allegations have been made about Gudino and access. You will find in the affidavit of Hila Kavogo, those people were leads who were actually providing ICT help at the level of the systems. Every person was logged off from our system on the 8th of August. There is an email we have attached to the affidavit as relates to that. Anyone who had access to our systems was someone who was authorized to do. And finally, the court should ask the question, whether the 50% plus one was met. And to that question, Your Ladyship, the late Justice Antonin Scalia, whenever he went to give lectures to all over the United States, everyone used to ask him about Bush v. Gore, and he will know whether someone is a Republican or a Democrat as to the question they will ask, and his answer will be, get over it, it's over. So to 50 plus 1, the court made its determination in 2013 on the votes cast and valid votes and the rejected ballot. Rejected are not votes. Votes is an authentication of preference. There's nothing called rejected votes. That's a rejected ballot. The court emphatically made that decision in 2013 and in 2017. To the petitioner's answer as to that, I think the simple answer will be, get over it. With those few remarks, I yield the floor.
Thank you very much, my colleague, Mr. Mahat. Madam Chief Justice, Madam Deputy Chief Justice, honorable members of the court, may it please you, I am called upon to look at issues number 8 and 9 on the materiality question and on reliefs. My Lord, in view of the time, I will not go into...
Sorry, counsel. For our recording system, if you can just introduce yourself. We know you, but for our...
I apologize, my lord. My name is Abdi Kadir H. Mohammed. I appear with my learned colleagues for the IEBC and the chair. My lords, my ladies, in view of the timing, I will not go into a lot of the law as far as the standard of proof is concerned. This matter is tried as far as the law is concerned. The standard is higher than 4 civil cases, normal civil cases, but does not go as far as required for criminal cases. In other words, it does not go as far as beyond reasonable doubt, but it is higher than a balance of probabilities, except where criminal conduct is alleged or there is an election offense alleged, in which case then you go to the higher proof beyond reasonable doubt. The submissions of the first and second respondent in the lead, the submission of the respondents in the lead petition at paragraph 8, page 4, deal with the law, the cases, Raila, Odinga, 2013, para 203, number 1, presidential election number 1 of 2017, para 151 to 152, and the courts clearly state that the allegations should not be general, they should not be bare allegations, and the standards must be met. In John Harun Mwau, at page 349 to 350, 2017, that was the holding of the courts. So the law is very clear on this matter, my lords and my ladies. I'll then go on itemizing some of the allegations or some of the issues raised in terms of illegalities and irregularities, and specifically state whether those standards have been met, and in broad case, they haven't. So there have been allegations of a dysfunctional commission. This, my lords, is not a court dealing with a corporate governance case. It is an election petition court dealing with the presidential elections in 2022. My lords and my ladies, the case of Maina Kiai dealt with the issues of the commission and the chair and their place in the process that we are talking about, in the verification process. And it's very important to understand that the petitioners want to turn that case on its head, because if you recall, what the petitioners in the Maina Kiai case were fighting against, it was the interference by the commission or the chairman in the results when they come to the National Tallying Center. This is exactly what the petitioners are asking to do. They are asking the commission to interfere with the results at that point. That is not the law. Number 2, there was the allegation that the commission is equal to the commissioners. That was dealt with by my learned colleague, Senior Counsel Kamau Karori. But let me just add that it will be absurd to say that the only elections, the only verification that is acceptable under the law is verification by the commissioners. What then would we make of the elections at the counties and the tallying and verification at the counties and the tallying and verification at the constituencies where no commissioner is present? What would we make of section 39(1)(c), which says the commission will transmit? Which commissioner transmitted when? It is the commission officers, the commission employees, and the commission is certainly more than the commissioners. My lords, that allegation, therefore, that there was a dysfunctional commission and this led to the results not being verified is not borne. The standards have not met, and it is not the law. The commission practically will need to rely on its officers across the country in the 46,000 plus polling stations for the work of the commission, including presiding officers verifying and transmitting. The next allegation broadly was the issue of the rogue chairman. Here we have a bogeyman where all the issues can be affixed to this good gentleman. At the end of the day, after you clear through the fog, What were the issues that the chairman was being accused of? They do not meet the standards, I pray, that would be required for us to overturn the presidential elections in the general election of 2022 and send 14 million plus Kenyan voters back to the vote and spend immeasurable amounts in treasure. The chairman is accused of single-handedly conducting the elections, of gazetting himself, and it's alleged that the office of returning officer for the presidential election does not exist. I adopt the presentation from my learned colleague, Mr. Kamau Karori. But suffice it to say that we all accept that 138.10 gives a role to the chairman to declare, that regulation 87.3 gives legal roles to the chairman, and case law has given legal roles to the chairman. Those roles, when you put them together, essentially spell out the role of a returning officer. And in the old company law, the definition of a director used to go that a director is a director by whatever name called. And the returning officer is the returning officer by whatever name called, because he is undertaking the functions of the returning officer. Let me now turn to the allegations from the other commissioners and the averments in the affidavits. If you look at the totality, what you get is that these good ladies and gentlemen were either negligent or unaware of their functions, or in fact were not stating the truth as such, because the law requires for the commission to hold a minimum of 1 meeting per month. More were held during the elections. They attended all those meetings under the affidavits. The vice chair and Mr. Wanderi attended the trip you are told about in Greece, where they went to check on the presidential ballots. The announcement were made by these good people almost 70% of the time. In other words, almost 70% of the announcements done at Bomas were done by these particular commissioners. And the tables were there for everybody to see where verification was happening. And they had no one stopping them from going to attend or direct if they wanted to direct. We would have shown at this point their access to the floor in the 4-minute clip, but in view of time, I will skip that. But I would urge the court to look at that video clip to show the extent of the operations of the commissioners, and especially these 4, in terms of the operations at Bomas. Then we go to the 27 constituencies. The affidavits clearly show that those constituencies were tallied and they were in fact verified, and that the record will clearly show that what was remaining was the announcement. And the 4-second clip will show you the environment and the fracas at the announcement podium at the point in time when Professor Gulie was to go to that podium to announce the 27 stations which had been verified and tallied. I'll play the 4-second clip. Thank you, Sonia. Please. Yes, this is Bomas just before Professor Gulie was to announce. This is covered in the affidavit of the chairman, and it's also touched on in the affidavit of Professor Gulie and also the chief executive, Mr. Marjan. My lord, that was the environment at that particular time. It was practically not possible for Mr. Gulie to announce. Our contention is that that lack of announcement does not go to the level where you would consider those constituencies untallied or unverified. What then were the aim of the commissioners when they say we wanted to, quote unquote, own the results. Because verification is a very simple process. It has been defined. I'm not going to waste a lot of time on it. Tallying is a mathematical process. The only other verification required, other than compare the forms, was has the candidate met the 50% plus one. What the commissioners actually wanted to do was what was stated in the affidavits of the chairman, the Professor Gulier, and Mr. Molu, which was to moderate the results so that a pre-agreed or pre-arranged result can be declared. That is what they wanted. What they wanted was for a meeting to sit over the decision of who will be president, not the voters, not Form 34A, not the polling station as the law is, but for a meeting of the commissioners at the National Tallying Center after the work had been done to moderate. That is illegal, it is unconstitutional, it is completely unacceptable. And this is in the affidavits. There were two meetings prior to that final meeting. One where there were visitors from the security agencies and the other from individual Kenyans. And those meetings were confirmed by all the protagonists. And this really was the scheme. This was the rupture. You asked yesterday, how come we had not heard of this dysfunctional commission earlier? Because it was a process that was going on, and at the point of disagreement is at the point where now we have rupture. And from that point onwards, those commissioners are part of the scheme, and this time instead of announcing the wrong results, it is aimed at getting this court to overturn the results. That is the scheme. That is the decision the commissioners wanted to be part of. In terms of technology, there are a number of allegations. I adopt the presentation from my colleague, Mr. Gumbo. In terms of the numbers, I adopt the long presentation of Mr. Mahat. And I would stop there in terms of the allegations. Suffice it to say that there have been many, they have been sensational, they have remained unproven, and they are not worthy of the level required to overturn the presidential elections of this country. Let me now go to the remedies very briefly. And the remedies, just one point in terms of the earlier issue. There was a push for moderation. That essentially is to overturn the elections. There was interference from state agents, again asking for a specific. Those are averred in several affidavits. There was the issue of the DCI and certain other state agencies. Contrary to the law requires that under Section 105 of the Elections Act, that all state organs and state officers must give assistance to this commission during this difficult period. Contrary to that, the DCI was indeed an impediment to the holding of the elections and to the functions of the IEBC at that point in time. There were very many officers of the commission picked from the tallying center, outside the tallying center. It is not a coincidence that the four commissioners refer to those staff members which were then picked by the ATPU. Ask yourself, what is the anti-terrorism police unit got to do with our elections in Bomas? Why would the anti-terrorism police unit be involved in the tabulation verification exercise at Bomas? And that scheme, that assault on our democracy is what you are being asked now at the tail end to. Let me also refer you to the affidavits of the commissioners where they say that the election process was okay until the very tail end. That tail end is where the matters went haywire. Let me go to the reliefs, my lords and my ladies. The reliefs as known by law in terms of the Constitution is at 143. The Supreme Court, if the Supreme Court determines that the election of the president-elect is to be invalid a fresh election shall be held within 60 days after the determination. And Rule 22 of this court's presidential election petition rules empowers the court, after hearing a presidential election petition, to either dismiss the petition, which is what we are urging the court to do, what our clients are urging the court to do, or to declare the election of the president-elect either valid or invalid, and invalidate the declaration made by the commission under Article 139(5), and then orders to payments. There was a reference to Section 80 of the Elections Act, and it states that the court has additional power to, quote, direct the commission to issue a certificate of election of a president if, upon recount of the ballots cast, the winner is apparent and that the winner is not found to have committed an election offense. Our view is that this is not operative in this case. Number one, this section assumes a recount. We have no recount in this case. Number two, it's not specific to the presidential elections, as is the case with the Constitution. And number three, it says that as a precondition, as a condition precedent, whoever is getting the benefit of that relief must, of necessity, have not committed an election offense, which presupposes that there is a process for that to have been determined, which has not happened in this case. In any event, it is the contention of the petitioners that indeed the petitioners or their agents are guilty of presidential or of election offenses, and therefore they ought not to be entitled to that relief. But can I go back to the relief sought by the petitioners, especially in 005? They are very convoluted. There are many. They are conflicting. If you look at, and some of them are strange. For example, there is in paragraph 18 of the remedies sought in the petition number 005, you are asked to uphold the decision of the four commissioners in rejecting the declaration. No such decision or no such lawful decision exists. You are asked in paragraph 9 to order directing IBC to tally and verify, then declare. That has already happened. The tallying and verification has already happened. You are also asked to find that the elections were held in complete contravention of the Constitution, yet declare under section, hopefully 84, the petitioners, the president-elect and the deputy president-elect. Those two do not head to the same. And then you are also asked to get the election invalid, in which case the section kicks in that there will be a rerun in 60 days, yet to hold that the IBC, as currently constituted, cannot hold the election. In which case, again, you have a conflict that is not subject to be determined. So our view is that the totality of the relief sought raise a lot of problems, as mentioned by the judges on a number of occasions. In terms of the reliefs we are seeking the reliefs as listed out in the responses, all of them, and jointly. We are also seeking reliefs as far as the chairman is concerned, as far as the number of criminal actions stated or alleged in the respondents. I adopt all the affidavits, my lords and my ladies, stated by my learned senior Professor Gideon Mugai, and the presentations thereafter. Suffice it to say that what we have witnessed is at the tail end of a very long process. We in this country have gone through a lot of reforms as a result of elections. If you recall, the entire ECK was disbanded by legal fiat as a result of an election. Thereafter, we have had to completely redo our election infrastructure. We have come to the point where this court 5 years ago laid the law. Now, if you look at all those steps, we have taken radical steps that have cost treasure, that have cost lives, that has cost livelihoods, including staff members of the ECK who have either died in office or who have been fired as a result of being told you have all been disbanded. Our law has no problem, my lords. Our elections have no problem. The problem lies with our politics, and the problem lies with our political culture. That cannot be legislated. It cannot be delivered through litigation. It has to be elsewhere. Men and women who run for office in this country must accept that it is possible to win. Indeed, it is even more likely to lose, because typically an election involves more than two people, and the chances of the losers being more than the winner are very high. Until we accept that, we are going to be harming the country, we are going to be harming our institutions, we are going to be hurting independent institutions and individuals who work in those institutions. Kenyans who give a lot, ask for nothing, and get to be denigrated in the hallowed halls of this court. My lords, I will stop there. I will ask my... Thank you, my lords and my ladies.
My lady, learned members of the court, it gives me great pleasure to return back to the court 13 minutes and 20 seconds. Thank you very much.
Thank you very much for donating to us 13 minutes. We will... Yes. We would like to break now and resume exactly at 2, when we will start now the case for should be yes. Yes, I'm trying to get the right description of the parties, but it will be the case of William Ruto and also the Attorney General. Not now, when we resume at 2, because we haven't risen, we need to rise.
I think in order it will be the 2 commissioners. There are 2 commissioners.
Their case has been done.
You are done.
Yes.
Then it's Attorney General, because
yes.
we have to respond to the Attorney General, pursuant to the leave you gave us.
Yes.
That we respond to the Attorney General. So it will be Attorney General. My learned senior, Oraro, Senior Counsel is present, and then I'll take over the case for the first and second.
There is no problem.
Thank you so much.
Yes, so we resume at 2. Thank you.
To the court regarding the ongoing scrutiny. With every passing second, of course, time is lost. It is still with regard to what we consider the non-compliance with order number 2 regarding access to the servers. I wish to report, as of this morning, nothing has changed. IEBC continued to refuse to provide the forensic image of all 8 servers. Your Ladyship, my lords, the 8, we've been using the word servers in plural, but I would like to refer to the affidavit of Mr. George Njoroge at page 11, which gives the name or identity of the 8 servers. Page 11 of the forensic report by George Njoroge, which gives the particulars of all 8 servers. Of those 8 servers, IBC are providing only limited access to server number 5. I have mentioned with every passing second, an opportunity for the court and ourselves is being lost. With the limited access provided yesterday to server number 5, our team were able to observe a large number of deletions. So we suspect and we are concerned that C is to delete vital data, and when finally time runs out, not to provide the information that we require or provide logs that have no use to anybody. So we are requesting that the court direct further that access, forensic access, be provided to all 8 servers, together with copies of logs for all 8 servers. I am further advised that the question of the forensic imaging is the one that takes time. It takes hours. It takes hours. So that needs to be given, that direction or that order needs to be given right away. In the alternative, do not do what they are good at doing, not providing or providing when it is too late. So that is all I wish to mention at this stage. And I would like that the court addresses it before we start the day. Thank you.
Thank Mr. Gumbo.
A question?
Good morning, my lady, my lords and my ladies. My name is Eric Gumbo, once again. Let me start from saying that I think I'm quite perturbed by remarks from my learned senior counsel when he says that IBC is not complying with the court order. That certainly is an inaccurate reporting. I think the most important thing would be to get an accurate and objective position in relation to this matter. It cannot be, because we've seen tweets, we've seen a lot of social media activity in the night, which is not accurate. And I think whatever was happening was that report was meant to be for this court. It wasn't meant to be discussed in social media. I think there was already guidance on that. So even this narrative that is being propagated certainly is not for this court. And I think we take exception to that. But back to the critical issue, yesterday we did give an indication that whereas the order of the court was that the IEBC was to give a supervised access to the servers, that was then interpreted by the applicants to mean that they would get a copy of the whole server. We then expressed concerns with what that would mean, and we asked that the court then gives guidance so that as we proceed, there's clarity. That is really what we had hoped that we would get this morning to enable us resolve the matter. Certainly, it is not to take away the server from IEBC. I'm most obliged.
Thank you very much. On behalf of the court, may I say this? That issue was discussed by the full court this morning. We received a full report from our technical team that was leading the exercise at IEBC, and we have been informed that the process of compliance was completed last night. In fact, when we were here and Mr. Paul Mwangi was saying that the process had stalled, we received a message soon thereafter from the team to say the process is heading to completion. So that as far as our team is concerned, the process at the IBC is finished. The process at Forodha House is coming to an end shortly. And so the court has then asked me to express, in anticipation of this question, that should there be any issues left unattended to or any concerns that parties have, let those issues be addressed when you receive the report later this morning. You can address the question of what you're calling non-compliance. You can address the question of what servers you think were not accessed. You can address the question of the information that you received, your agents were there, and you, IEBC, can respond to say, what are your answers to the complaints by the petitioners' advocates, and then the court will ultimately determine what is the import of all the things you are saying. That report was meant for the court to make a decision on the issues you raised. So as far as we are concerned, that matter is spent. Please address us tomorrow substantively on each of the questions once you see the report, which is actually being prepared right now. That's all I have been informed to tell you by the court. I thank you, CJ. I thank you, Council.
Madam Chief Justice and the Honorable...
Sorry, Senior Counsel. I think, CJ, allow me to say this. As much as possible, let us do matters within this court. I think the debate out there is convoluting matters. And when we see documents being circulated outside the court, it only just inflames the public. Let us please keep matters right here. Let's manage our issues right here until we finish. That's all I'm saying in answer to Mr. Gumbo's concerns. But as far as the court is concerned, we're on top of things. I thank you.
Madam Chief Justice and the Honorable learned members of the court, I am Githu Muigai, and I appear for the IEBC, for its chairman, Wafula Chebukati, and for Commissioner Professor Abdi Yakub Gulei and Boya Molu. I am assisted in the defense of this gentleman and the institution by Kamau Karori, Senior Counsel, Abdikadir Hussein Mohammed, Senior Counsel, Mr. Eric Gumbo, Mr. Mahat Somane, Dr. William Mutumbwa, and Mr. Peter Wanyama. I would like to request you, Madam Chief Justice, if you could kindly confirm that our combined team has 4 hours, our 3 hours plus the 1 hour between the two commissioners who are represented by our team.
That is not correct, Prof. The two commissioners have 30 minutes. You remember the other 4 commissioners and 15 minutes each. They had 1 hour among the 4 of them. So you have 3.5 hours.
I am guided by you, my lady, and I have changed that to 3.5 hours. Thank you. We have filed before you a wide range of documentation, which in our very humble view is very, very comprehensive. We draw your attention, honorable members of the court, the responses on behalf of the chairperson and IEBC, the affidavit of Wafula Chebukati, the affidavit of Marjan Hussein Marjan, the CEO, the affidavit of Professor Abdu Yakub Gulei, the affidavit of Commissioner Moya Mulu, the affidavit of Martin Washira Nyaga, the database administrator, the affidavit of Michael Uma, the director of ICT, the affidavit of Moses Lendema Senkuli, the acting director of voter registration, and affidavits filed by presiding officers and residing officers. It is made worse, my ladies and my lords, by the fact that the petitions make grave allegations of a criminal nature: fraud, tampering with election materials and results, conspiracy to unlawfully influence an election outcome, and even implied treason. Implied treason. All that without a shred of evidence. All that without a shred of evidence, especially as it relates to the Honorable Chebukati, the chairman of the commission. The vilification against this gentleman goes beyond anything we have ever had before in this courthouse. It was personalized, it was vindictive, it intended to lower his standing in our community and within the legal profession. It was unwarranted. I have had occasion again to defend Mr. Chebukati, although he was not my client. I was in a different office. But I recall mentioning in 2017, before your lordships, that this gentleman was being vilified for doing exactly what the minor Kiai court told him to do. It told him, don't touch the results coming out of the polling station. That is the final result. We then came here to this court and he was called all manner of names at that time. This has not stopped. What should we learn from this? We should learn one thing, and it is a very unhappy lesson. The attack on the chairpersons of the commission has a long history. There was Justice Zacchaeus Chesoni, there was Samuel Kivuitu, there was Isaac Hassan, and now there is Chebukati. The pattern is the same. The pattern is the same. None of them has been allowed to leave office without vilification and a vindictive process being engineered against them. I don't want to go to the details because we all know the details. We remember the details. So what is wrong? There is nothing wrong with IEBC. There is nothing wrong with Wafula Chebukati. There is something very wrong. There is something very wrong in the way the persons who participate in the electoral process accept winning or losing. That's the problem. At an appropriate time, when all this is over, I entertain no doubt that an independent group of people looking at the work that Mr. Wafula Chebukati has done for our nation will recognize him as one of our outstanding heroes in the history of our nation. Thirdly, I want to say that the evidentiary material, which will be addressed by my colleagues, is of such a character that it falls way below the standard you set in petition number 1 of 2017. And since I don't want to take too much time, I'll leave that for that purpose. To return to this issue, that this court, in our very humble view, needs, and I'm very sure from the questions the court has asked so far, that the court appreciates very deeply, and that any order has consequences, and those consequences must be consequences that can be contained in our democratic and constitutional process. The Supreme Court cannot act in vain. It cannot act so as that the judgment should read like a learned legal article. The Supreme Court always acts so that it can defend democracy and the rule of law and constitutionalism in a practical and enforceable way. So if this election is so badly flawed as you are invited to find, then this court would have to find that every MCA, every MP, and every senator, and every governor was not properly elected and the whole of the government of the Republic of Kenya should be reconstituted afresh. I don't know whether my learned colleagues have contemplated the consequence of what they have requested. My client, Mr. Wafula Chebukati, is a man who enjoys constitutional protection of his tenure. Why did the Constitution protect him? Not him alone, the chairman of independent commissions, for precisely this form of witch hunting. The Constitution cannot countenance that a constitutional office holder is to be witch hunted in the manner suggested here. That he walked out of his office and took the phone many times, then came down and sat down and did not consult the people who were having tea. A whole lot of irrelevant material that cannot be the basis of interfering with the independence in section 163 of Mr. Wafula Chebukati. It is said that he should be removed from office and forbidden from ever holding public office. And I want to ask my learned colleagues for the petitioners, is that really a serious submission when the Constitution itself contains complex processes of the removal of a person? He is now to be removed here by reference to affidavits of hearsay on the back of hearsay? I do not think it is a serious submission, and I invite my lords not to act on it at all. Two final points before I invite my learned colleagues. My very able senior learned friend, Paul Muite, said that the commission is the majority of the commissioners. That cannot be a meaning of the commission that arises from the Constitution. The Constitution contemplates that the word commission will be used in multiple senses. The returning officer, when he makes a declaration, is the commission. The officers of the commission, when they procure, let us take procurement. When the procurement process is done by officers of the commission, that is the commission. When the chairman declares the presidential vote, he is the commission. There are multiple senses in which the Constitution uses the commission. It does not intend that the commission is to be used as sitting in plenary and voting, because very little of the commission's work involves voting. I believe that if we cure that misunderstanding of the commission, the rest will follow. It will be quite clear that Wafula Chebukati was acting as the commission in the manner defined by the Constitution at that point. Because it is a body corporate, and that has already been spoken to. Let us come to this last point about how did the commission break apart? Again, I don't want to belabor this point because the learned court itself has raised this issue. We have an election conducted up to the 11th and a half hour, and everybody is on board. Everybody is on board. The public can see them declaring the results. What is this that happens within the half hour? the affidavits speak for itself, for themselves, rather. And my learned colleague will take you into the detail. The affidavit speaks to themselves. There is a concerted effort. There is a concerted effort, external, to ensure that the process comes to an end without a declaration. So the sanctimonious, self-righteous, pompous pontification of the so-called 4 commissioners are an afterthought. They are a complete and total afterthought. And should be seen as that. One shudders to contemplate what would have happened constitutionally. So there is no, the election is not called. The deadline is the following day. It is not called. We then go into an uncharted waters. Totally uncharted waters. We have a caretaker government in place that is hamstrung in what it can do. We cannot set up a new government because an election was not declared. We cannot call a fresh election. I shudder to think what would have happened. I'm sure the court would share the same concern. And I want to say this before I sit down, my ladies and my lords. Integrity is not numbers. Integrity is not numbers. And that's why the great statesman said, I protest. I protest even if I do so alone. To do the right thing does not require you to be with the majority. It requires you to be with your conscience. I invite Mr. Kamau Karoli to address you on the issue of 183, and I thank you.
Senior Counsel, before maybe you see it, we have received information that your side is going to present 2 videos and a PowerPoint presentation. The first video will take 4 minutes, the second video 14 seconds, and the PowerPoint presentation, which has 28 slides. We don't know how long it will take, but just to warn you that that is within your time.
Most
your
obliged.
time will be taken into consideration. We will not lose time like we did yesterday. We are very keen.
Most obliged, my lady.
May I please, my lady, the Chief Justice and judges of this court, and good morning. My lady and my lords, I will be addressing you on mainly on the issues surrounding Article 138 of the Constitution. And my ladies and my lords, the reason why we are starting from there, and which is right about where my learned senior left it off, is that there are many allegations that have been made in this petition. In fact, that seems to be the main issue surrounding these petitions, regarding the manner in which the functions set out in Article 138.3 and 138.10 were conducted. One of the allegations that has been made is the chairman unilaterally tallied, verified, and declared the results of the presidential elections, that there was a requirement for a complete corporate process of internal tallying and approval by the commissioners, and that the chairperson can only act with the concurrence of the commissioners. Now, it's my submission that the reason why these submissions are being made is based on a confusion that stems from a misunderstanding of the nature and character of the commission and the interplay between the commission, the functions bestowed on the commission, and those cast upon the chairman of the commission. So first of all, the question that comes up is, who is the commission? And my learned friend, Senior, has alluded to it briefly, but let me just make this distinction because it is important. The commission, IBC commission, is established like all the other independent commissions under the provisions of Article 250 of the Constitution. But more importantly, and this is the distinction that I think is important to draw, if you look at what Article 250 talks about, 251 says each commission shall consist of at least 3 but not more than 9 members. The next one says the chairperson and each member of a commission, so that these commissioners are members of the commission, they are not the commission. So that where the law refers to the commission, it is not referring to the commissioners, but it is referring to the body corporate that my learned senior referred to, and which is established or under the provisions of Article 253 of the Constitution, which says that each commission is a body corporate with perpetual succession and a seal. So where in Article 138 reference is made to the commission, it is that body corporate that is referred to. And this is amplified by the provisions of Sections 11 of the IBC Act. My lords and my ladies, Section 11.2 of the Act establishes the Secretariat and the Commission, so that the Commission consists of the commissioners, the chairman and the commissioners, and the Secretariat. Then 11.2a defines who the Secretariat is as such professional, technical, and administrative officers and support staff as may be appointed by the Commission in the discharge of its functions under this Act. And B, very critical also, such public officers as may be seconded to the Commission upon its request. This is what comprises the Commission. And then, what is the role that the commissioners are supposed to play? Well, Section 11A of the IBC Act then says that the chairperson and members of the commission, again members of the commission, shall perform their functions in accordance with the Constitution, and in particular, shall be responsible for the formulation of policy and strategy of the commission and oversight. Those are the 3 roles that are specified in the statute: provide or formulate policy, strategy, and oversight. That is the role that they play. Then the Secretariat shall perform the day-to-day administrative functions of the Commission and implement the policies and strategies formulated by the Commission. So this then brings me to the provisions of Article 138, 3C, which is at play in these petitions. And it's important, my lords and my ladies, to read what the provisions of that section say. And the reason why I go straight to that provision is because the petitioners are using that provision to say that the provision requires the commissioners to be involved in the process of tallying, verifying, and declaration of the results. But what 138.3c says is that in a presidential election, after counting the votes, these are the words they leave out, after counting the votes in the polling stations. This is about the polling stations. In the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. So this section refers to what happens at the polling station. My lords and my ladies, there are over 40,000 polling stations in Kenya. It is not conceivable that the 7 commissioners, including the chairman, would be the one to conduct the business of tallying, verifying the results, the votes at the polling station. This activity, as has been acknowledged by the courts in many cases, is undertaken by the officers of the commission in those areas. Indeed, in the first petition in Raila Odinga 2017, My Lords, the court at paragraph 287 says, the duty to verify in Article 138, which I've just referred to, is placed squarely upon the Independent Electoral and Boundaries Commission, which was the first respondent. It is exercised by the various agents or officers of the first respondent. That is to say, the presiding officer at a polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. No reference here to members of the commission. And this is very deliberate. The process of conducting an election is a statutory process. It is set out in statute. It is not an issue that is left to determination by the commissioners in a meeting of plenary as they have suggested. And so, my lords, the assumption by the petitioners that the commission refers to the commission is wrong and belies the case that has been brought before you. And so, my lords, the next issue that I want to deal with is the question of the role of the commission versus the role of the chairperson. My lords, under Article 138(3)(c), as I've said, the role of the commission, not the commissioners, is just to tally and verify the results. Sorry, and what is important here is this. My lords, and to respond maybe to my learned senior John Mohammed, the results of the vote at the polling station are made on the same day. The decision as to who members or the electorate will elect is made at the polling station, and the outcome of the voting is determined on the same day. It is filled in Form 34A. It is pasted on the doors of each and every polling station. Now, the important thing here is that there is not a single affidavit or evidence that has been placed before you by anybody who says that the results that were pasted on the doors of every polling station, the Form 34A, is different from the ones that were announced or declared by the chairperson at the National Tallying Center. And this brings us to what the courts have said consistently, that the results as announced by the polling, by the presiding officers at the polling stations are final. Once those results have been declared, the voter knows that in my polling station, which had a maximum of 700 voters, the outcome of that vote was this candidate A got so many votes, candidate B got so many votes, and so on. So the result is known after the close of voting, when the counts are tallied by the presiding officers. And then, my lords, there is Article 138(10), which places an obligation on the chairperson to, within 7 days after the presidential election, to declare the result of the election. Now, my lords and my ladies, there is nothing strange about the provisions of Article 138(10). Declaration of the result, as was held in the Joho case, declaration of result is done in 3 stages. The first declaration is done at the polling station. If the argument by the commissioners was correct that the declaration requires to be approved, it would then mean that even the result that is declared at the polling station would require the consent of the commissioners. It would mean that the results declared at the constituency tallying center would require the consent or approval of the commissioners. It would mean that the results declared at the county tallying center would require the participation consent of the commissioners. That would introduce what this court has been avoiding all along, which is human interference with the process of tallying, verifying, and declaring results. And my lords, I'll just discuss a few cases that show why these considerations are important, and I'll start with the case of Maina Kiai. My lords, in that case, the court stated that, my lord, let me start with the Raila Odinga versus IEBC, the 2017 decision at paragraph 287. It says, The duty to verify in Article 138 is squarely placed upon the IEBC, and this duty runs all the way from the polling station to the constituency level and finally to the National Tallying Center. There is no disjuncture in the performance of the duty to verify. It's exercised by various agents, that is to say the presiding officer at the polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. Nowhere in that decision do you hear reference to members of the commission. It refers to specific officers whose duty it is to verify and declare the results. And why is this critical? At paragraph 288, this court explains why this is important. And it says the simultaneous electronic transmission, and my learned friend will talk about the electronic transmission. Paragraph 288, the verification process at all these levels is elaborately provided for in the Election Act and regulations. I will jump up to the part which starts by saying, but this electronic transmission also acts an insurance against potential electoral fraud by eliminating human intervention, intermeddling in the results tallying chain. Now you are being told that the commissioners need to be involved in the process of verifying and declaration of the result. This introduces exactly what the court said. We do not want human intervention or intermeddling in the chain of result declaration. And this ensures that there is no variance between the declared results and the transmitted ones. Now, the chair, again, plays a critical role in this whole process. In paragraph 365 of the same judgment, this court said that the chair has the duty of receiving the Form 34A as received from the constituency returning officers by signing the taking over section of Form 34B. It is his duty to do so. And then, my lords and my ladies, I deal with the issue that was raised that said that the chairperson styled himself to be the returning officer in respect of the presidential elections, and the suggestion that was made is that this title does not exist. First, my lords and my ladies, this is, it's wrong. That's not the correct position. The chairperson undertakes the role of declaring results, which is a role that you'll find under the under the Elections Act, is a role reserved for a returning officer. But just to lay this whole issue to rest, my lords and my ladies, in the case of Raila Odinga versus the Law Society of Kenya, this is the first Raila Odinga 1, 2017, at paragraph 8, this is what this court said. It says, the second respondent, who is the chairperson, Independent Electoral and Boundaries Commission, that's the second respondent. The second respondent, comma, the chairperson of the IBC, who is the returning officer for the presidential election. Even this court recognized that is the role he plays. So it is not himself who styled himself. Even this court recognized that role and says it's constitutionally mandated under Article 3810 of the Constitution of Kenya to declare the result of the presidential election and deliver a written notification of the result to the Chief Justice and the incumbent president. So that the role of the chairperson in the declaration of the results is recognized both under the Constitution, Article 138.10, but this court also specified that in playing that role, essentially what he's doing, he's playing the role of a returning officer. But this was even emphasized further in the clarification decision that was rendered by this court in 2017, and at paragraph 61 of the majority, the decision by the majority, the court said that at paragraph 61, it says that the, it talks of, it's a long sentence, but my lords and my ladies, I just want to read what is critical. It says the constituency returning officer aggregates Form 34A from the polling station into Form 34B before generating Form 34B. Doesn't the returning officer verify the figures in Form 34A? Is it not a fact that the second respondent as the national returning officer? So that even in the clarification, when we came back to court and sought clarification, this court confirmed that in fact this gentleman is the returning officer, national returning officer, for purposes of the presidential election. And so the issue of him styling himself, my lords, does not arise. And it just shows you the levels to which the chairman has been unfairly vilified in a situation where the law is quite clear in the conduct on how he should conduct his affairs. The other thing that was also clarified a lot, my lords, and I'm just referring to this because there's no need for me to argue this if the authorities already say so, is that the chairperson, the verification that is referred to in Article 138 3C, this court said that the verification that is undertaken by the commission employees, by the people that we saw in the rotunda, in the tallying center, it says the first respondent on behalf of the second respondent, commission employees on behalf of the chairperson, must verify the results against those in the transmitted Form 34A. So that the way the petitioners have put it is completely the other way around. They are suggesting that the chairperson is the one who undertakes activities on behalf of the commissioners. It's actually the other way around. It is the commission employees that undertake the verification process on behalf of the chairman to enable him declare the outcome of the results. Which takes me, my lords and my ladies, to the next issue that I want to cover, which is the declaration of the result a plenary decision? And the question that we must start with is, what is the decision that needed to be made at the National Tallying Center? What is the decision? And my lords, if you look at the architecture of Article 138 of the Constitution, and you look at the Elections Act, there is absolutely no decision that is supposed to be made at the National Tallying Center. None. The only thing that's supposed to be done is an arithmetic exercise, which is tallying, aggregating the results, verify that the form that has been brought by the constituency returning officers, Form 34A, the original, compares or is the same as that which was transmitted electronically. Then add up the numbers. And then the chairperson is supposed to determine whether the threshold in Article 138(4) has been met, which is, has the person met the 50% plus 1 threshold? It's a question of arithmetic, which the chairman must make. And lastly, make a declaration whether there is somebody who has been validly elected. Fill the forms, and that is the end. That is the end of the exercise. He then gives the Form 34D to the president-elect, and that brings to an end the election process in respect of the president. The other administrative steps of giving the certificate to the Chief Justice and to the President comes later. Now, no one here is saying that there is this particular Form 34A that is different from the ones that were received. In fact, as my learned senior correctly says, nobody is saying that the number that was declared by the chairman is wrong, because according to us, the numbers achieved by the president-elect is different because they have calculated it. The number achieved by the second was a different number because they have calculated it. Nobody is talking numbers here. All that they are saying is trying to challenge the process that went on at the National Tallying Center. But nobody is saying that any particular number is wrong. And so, my lords and my ladies, the suggestion that we should have a plenary conversation about the result would one that would cause huge ramifications to this country. Because what would happen if after the elections have been conducted and completed, commissioners, for whatever reason, take different positions and decide that they are not agreed on the declaration to be made, and that a declaration cannot be made until they all agreed? If that was what was intended by the Constitution, nothing would have been easier for Article 138(10) to have made reference to members of the Commission. It is deliberate that it only required the chairperson to declare the results. And in my humble view, my humble submission, is that the protection intended by Article 138(10) of the Constitution worked in these circumstances. We got a declaration made because it is the obligation of the chairman to make that declaration, and anybody unhappy with that declaration, the option available to them is to come to the court, and the court will determine the issue. The option cannot be that a number of the commissioners can decide we are the majority and we are going to walk away, and therefore there will be no declaration of a result. That is capturing the Constitution. It is ensuring that the Constitution is not able to ensure the establishment of a government in accordance with its provisions. It is the reason why that obligation is cast on one person and one person only. And it is unfair to vilify Chebukati for doing what the Constitution told him to do, that if you are satisfied that the threshold in Article 138.4 has been met, and if you are satisfied that there is somebody who has been elected to be president, you need to make that declaration. Just like the declaration is made at the polling station, constituency level, county level, and at the presidential level. Lords, this then takes me to the question of, and I don't want to spend a lot of time here, I will just gloss through it. What is verifying and tallying? I don't think I need to define this. I think verifying, I've already said, is simply just comparing the transmitted, electronically transmitted Form 34A against the Form 34B, Form 34A original as brought by the returning officer from the constituencies against the ones which have been transmitted. That's the exercise that is called verification. Tallying is aggregating, it's adding up the numbers just to make sure that that has been done. And this exercise was carried out. And we'll show you by the videos that will be played that in fact, the members of the commission, the commissioners, were involved in the exercise that was being undertaken at the National Tallying Center. Now, my lords and my ladies, you are also referred to extensively to the regulations and to the Gazette notice. So let me say this first. This is the first time, my lords and my ladies, that I hear a person being criticized for being too open. The chairman informed the purpose of a Gazette notice to inform the general public. The chairman informed the general public that he is the returning officer for purposes of the presidential election. He didn't need to do it, yes, but he did it. And he is being criticized for that very act of informing the public that of this fact. Secondly, they are now saying that because of the forms being in the public portal, it was possible for those forms to be interfered with in some way, and we'll show that there was no such interference. But the criticism now is you are too transparent. You are just showing people things. Even your numbers, you are showing them. That is the complaint. And my lords and my ladies, this court has gone to great lengths to say that under Article 10, transparency is an essential ingredient of governance. So when you are being transparent by providing information, how can you be vilified for that? My lords, the chairperson is also criticized for setting out the result path at the National Tallying Center. He is telling the public, this is how we'll carry out the function of tallying and verifying. How can that be a source of criticism? Nobody is saying that there's a promise you made in the result path that was not followed. And my lords and my ladies, it's a humble submission that the process that was followed at the National Tallying Center, which is set out in the Gazette notice that I do not need to read out to you, was transparent, was verifiable, and was in accordance with the provisions of the Constitution. None of the agents that were involved and that signed the Form 34A has denied that they signed it. Nobody has come to challenge any particular document saying that it is not their document. And an interesting question was asked yesterday. How was a handwritten document to have been changed? In fact, by having it handwritten, it helps in ensuring that if there is any alteration, this is something that can be easily seen because you can't change somebody's handwriting. And my lords, as I leave this point, it is also important to note that the agents of the presidential candidates, all of them, all four presidential candidates, their agents were at the National Tallying Center on the day. All of them. They participated in the process of tallying and verification. None of them has sworn an affidavit saying any of the numbers that were being, or the exercise that was being undertaken was wrong. None of them has picked a document, and they were allowed to take copies of all the documents. They were allowed to take images. None of them has complained about that process. Then we go to the issue of the 27 constituencies. And this makes me feel very sad. Because, my lords and my ladies, as this process was going on the 15th of August, at about 3 o'clock, the whole exercise of tallying and verifying had been completed, and that is in the affidavit of Marjan and Professor Goulier. Members of certain political parties decided that it was time to stop a process that had already started. We all watched in horror on TV as members, some of them who were in this court, confronted the chairperson, threw down the pulpit where he was to announce the results, threw down chairs, assaulted the chairperson and the commissioners. In fact, Professor Gulier, the chairperson, and the CEO were injured. And we have attached documents showing the injuries that they sustained. And the intention was to stop the declaration from being made. Now, this is critical, my lords. Everybody has said why it is important that a government should not be established by means other than those set out in the Constitution. But equally, nobody should stop the process of the Constitution that result in the establishment of a government in accordance with its provisions. Stopping that process is equivalent to preventing the Constitution from being effected. It's a transgression against the Constitution. And it cannot fall from the lips of those people who tried to stop that process to come before you and say, the results of 27 constituents were not publicly announced, and yet you are the one who precipitated a situation where there was disorder, there was chaos. And this chairperson and the members of the commissions were now in fear for their lives. How do you tell them to still turn up and come and undertake an act that you have prevented from happening? And my lords, in the second petition filed in 2017, my lords, at this time also remember, this is a time when one of the officers of the commission had been abducted, the other one had disappeared and feared to be dead and turned out to have been murdered in any event. This is the situation that was prevailing at that time. My lords, faced with this situation, this court in 2017 in the repeat election was categorical that you cannot foment trouble, you cannot foment chaos, and then try to use the chaos as your reason, or the non-performance of an act because of the chaos, as the reason to come before this court for relief. My lords, it is critical that it becomes clear to political leaders that the decision as to who will be the leader of this country is made at the polling station. The agents, the commission agents who declare the results are just doing their job. If there is a problem, if the numbers of the votes that you got are not enough, the problem is not at the declaration. The problem is with the people who you did not persuade to vote for you in sufficient numbers. That is where the problem is. You cannot come to threaten members of the commission for purposes of them living in fear and refusing to do what they're required to do under the Constitution, and thereby enable you achieve a political purpose. And so, my lords and my ladies, the 27 constituencies, the critical point is the results from those constituencies were tallied, were verified in accordance with the provisions of Article 138(3)(c). And you will notice that Article 138(3)(c) does not talk about announcing the results in the constituencies as a precursor or what will justify or validate the outcome. It doesn't. Lords, the next area that I just want to quickly go into, and I will just mention this in passing, the purposes for which we come to this court is that once they have made a decision, we don't revisit it. The question of the rejected votes, which I had been referred to yesterday, was determined in 2013. In 2017, Raila won, 2017, the issue again was raised, and this court said with finality that the only votes that will count are those votes that are valid. It's just valid votes. A vote that is rejected, a vote that is spoiled, does not express a choice, and therefore cannot count for anything. This court pronounced itself again in 2017. My lords, we cannot keep coming back before you and asking you the same question. You have answered it twice. I don't think I need to say more about it. The last item that I just want to deal with is the issue of constitutionality of certain regulations, which was raised by one of the parties. My lords, all I need to say about this again is that the provisions, these regulations, were promulgated on 27th of April 2017. They were the ones that were used for purposes of conduct of the 2017 election, first one, and of the repeat elections. No one has ever complained about those regulations. No application has ever been filed regarding the constitutionality of those regulations. In fact, when you retire to write your ruling, you will find that in both instances, this court relied on the provisions of Regulations 83 and Regulation 87 as the basis for the findings that were made, including the role of the chairman and the requirement for him to verify and tally the results of an election. And so, my lords, to now come late in the day, after you were made aware there is an election that is coming, you participated in those elections knowing that those regulations are there, and then when you do not succeed, you turn around and say, in fact, one of those regulations that were used is unconstitutional. That's one. Two, the law is clear, and I set out in the decisions that my ladies and my lords made in 2017 too, where you said that the determination as to constitutionality cannot affect antecedent acts. It can only look forward. So that even if there is a finding of unconstitutionality, and my humble view is that there is nothing unconstitutional about it, my lords, that cannot affect the election that was conducted on the basis of a law that was valid then. And so, my lords, it's my humble submission that this issue of whether or not the regulations are legal or not, my lord, is a small screen, because these parties, and especially the main petitioner, has been aware of this regulation and has participated in elections where this regulation has been used, now for the third time. The last item, my lords, is on the question of the postponement of the elections. Again, my lords, this has been explained in the affidavits that have been sworn by Mr. Gulier and also by the chairperson. And what happened is that the ballot boxes that were delivered, they had a mix-up in the names and the photos. And my lords and my ladies can imagine the confusion it would cause if this election was allowed to proceed on the basis of those ballots. Now, because of the deficiency of trust in this country, ballot pallets can only be opened on the eve of the elections to avoid a situation where IEBC is accused of having interfered or in any way manipulated the ballot papers. And so they were opened on the eve of the elections, which is on the 8th, and that is set out in the affidavit, when this mix-up was noticed. My lords, there was absolutely no time for fresh ballots to have been printed and delivered in time for the elections to be held. And therefore, in pursuant to the provisions of Section 55B of the Elections of the Elections Act, IEBC considered that this issue was an emergency. And what is an emergency? An emergency is an unexpected issue that requires immediate action. That's what an emergency is. And this was an issue that arose on the eve of the elections. These ballot papers could not possibly have been given to the electorate and told to use them for purposes of the election. And it is for that reason that IEBC, for purposes of securing the rights under Article 38 of the Constitution, decided to postpone the election to give the electors the opportunity to use the proper ballot papers for purposes of this election. And the mix-up was admitted by the printer. And what the printer did is that they agreed to print those ballot papers afresh at no cost. Now, my lords and my ladies, if we had used those ballot papers, obviously, we could not have been able to get a reprint at no cost. And secondly, for sure there would have been a petition on the basis that there was confusion arising from the mix-up in the images and the names. And so the postponement of these elections was justified in the circumstances. My learned friends dwelt at length on what the chairperson is alleged to have said in a public statement. My lords, these are newspaper reports that are given from time to time. And the important thing is, what does the law say in situations such as this? Does the IEBC have the power to postpone the elections? And the answer is yes, because it secures and protects Article 38 rights. My lord, the second issue that, and this is the court will take judicial notice of this, is that there was ongoing litigation in Mombasa regarding the gubernatorial seat. And this litigation went on up to close just before the elections were concluded. And so, my lords, again, this caused delay in terms of the timing of when those ballot papers would arrive. So, my lords, importantly, before the ballot papers were brought, the commissioners that are complaining all traveled to Greece. All 4 of them traveled to Greece to review and see how the printing was going on. They were the ones who represented the commission in Greece. And so, my lords, for them to now say that there was no, that this was an error, it cannot come from their lips. They were there, my lords. So it's a humble submission that based on what we have submitted, that the elections were conducted in accordance with the provisions of Article 138 of the Constitution, and that these petitions should be dismissed with costs. That's all, my lords.
May it please you, my ladies and my lords. For the record, my name is Eric Gumbo. I will be addressing the first, second, and third issue in the list of issues that were framed by the court. My ladies and my lords, I will, in addressing you on those issues, rely on the affidavits of Michael Ouma, dated the 26th of August 2022, and rely on the affidavit of one Martin Wachira Nyaga, dated the 27th of August 2022, and the affidavit of Hilda Kavonga, sworn on the 27th of July 2022. So coming to the first issue, which is whether the technology deployed by the IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. I will take a few moments to demonstrate how the technology that was deployed in the just concluded elections then met those constitutional imperatives. As a starting point, my ladies and my lords, we may want to ask ourselves, what exactly is this technology that we are talking about? And in answering that question, perhaps a bit of context would be of help. In the period just before the 2007 elections, when we still were dealing with the defunct Electoral Commission of Kenya, the legislative provision then, the equivalent to our Section 44, was worded in very loose, perhaps permissive terms. It was that to the effect that the Electoral Commission shall use technology where applicable or as may be appropriate. After the 2007 elections, we had the Kriegler recommendations, which then, one of which was that we must employ, or we should employ, the use of technology in our elections. When we got to the 2013 general elections, there was a good attempt at using technology, but the various forms of technology that were used were not were in different platforms, so that there was a different platform for purposes of registration, a different platform for purposes of identification, and a different platform for purposes of transmission. That did not work very well, perhaps because of the inefficiency attendant to the system then. Came the amendments in 2011 to Section 44, which required then that the technology to be employed was one to be integrated, meaning that in that one solution, we had the solution, we had the option for voter registration, which is biometrics. The second was electronic identification of voters and electronic transmission of results. Now, the question that we have before you today is whether, as conceptualized, that solution then meets the constitutional imperatives under Article 86 of integrity, verifiability, security, transparency, and accuracy. I will take a moment to just demonstrate how each of these would have been achieved. But when you retire, though, to consider the decision, I would invite your attention to specifically the affidavit of Michael Lohuma, who sets out in a very granular sense how these imperatives were met. I then would want to talk, that is specifically paragraph 39 to 49 of the affidavit of Michael Ouma. I then would want to talk a bit to the process entailed in those three items. And I'm sure we are most of us are familiar, those of us who have participated in elections are familiar with that process. That once the voting has been done and the polling station has been converted to the evening now for purposes of tallying and counting of results, we start by the counting in a very transparent manner. The presiding officers count each and every ballot, and I'm sure we've witnessed this, showing a vote for Gumbo, a vote for so-and-so, and a vote for so-and-so. Now, at the end of that process, they are then tabulated to give us Form 34A. How then is technology infused in Form 34A? Form 34A has internally identified security features. There are 8 in number. We have watermarks, we have UV potentials, we have microtext, amongst other security features. What is the significance of this? It is so that when somebody looks at the Form 34A, the original, it cannot then be confused for any other form, and that whatever it is that happened at the polling station remains an authentic representation of the will of the people. What then happens is that after that form has been tabulated, it is captured with the KIMS device. One copy is sent to the National Tallying Center. Another of that image is sent to the Constituency Tallying Center. And the presiding officer then collects all the, takes the Form 34A for purposes of the collation to the Constituency Tallying Center. That, again, is to achieve the constitutional imperative of verification. When we get to the Constituency Tallying Center, the returning officer has a back-end access to be able to load their Form 34B and transmit it to the National Tallying Center. Once that is done, they will then go with their Form 34A, together with their Bs, to the National Tallying Center for purposes of the verification and tallying at the National Tallying Center. Again, it is important to note that by the time the returning officer gets to the National Tallying Center, we have the image that is already in the portal. When they get there with their original form, an opportunity is then presented again for verification, for confirmation of accuracy, and more importantly, that in this election, because of the decision that was rendered by this court in the Raila Odinga decision in 2017, the commission, in reconceptualizing or reconfiguring its electoral architecture, gave a public portal for people to be able to also follow, thereby meeting the constitutional imperative of transparency. It then meant that if I'd gotten my results from my village, my primary school where I vote, I would be able to follow those results all the way to Nairobi and take account and follow if at all there is anything that would have happened or changed. Then I must be the first person to be able to raise that concern. It should also not be lost that in that polling station, we have our agents, we have our observers. Again, to add to the fact of verifiability. So that then is the architecture of what our election pathway looks like. That said, it then must follow that at the polling station, if I am a candidate, I certainly must have interest in the outcome in that particular polling station. Because a copy of the results from the polling station would be given to me, I then should be able to communicate with my team, perhaps my national agent for a particular candidate, a particular party, to be able to demonstrate that what we got in member primary school and what has been transmitted to the National Tallying Center is one and the same. And that in the event that there's a discrepancy, it does not take magic to be able to point out that. Now, as to whether this technology was successful, Michael Ouma deposed in his affidavit that 46,201 KIMS kits deployed throughout the Republic worked out of the 46,229. It then leaves us just with about 200 KIMS kits, which did not work at the opening or start of election on that particular day. I asked myself, if out of 46,000 KIMS kits, only 200 do not work, would I say I've failed? Even in our educational system, an A does not connote 100%. It starts somewhere from 88%, going all the way to 100%. The mathematical representation of this gives us more than 99% success rate. In our view, that then achieved the constitutional imperatives that are contemplated under Article 86. Again, for purposes of confirming whether that system is secure, I invite you, my ladies and my lords, to look at paragraphs 51 to 63 of the affidavit of Michael Ouma. Again, just to mention a few items in relation to that, that KIMS gadget works in specific ways. It is first locked to a specific polling station, meaning you can then not use it once you've locked it to the events of that day to transmit results from a different station for purposes of that election. That the entire network through which the results are transmitted are secured or double layered with firewalls, meaning there's the first firewall and the second firewall for purposes of securing that transmission. Very significant again to mention that at the point at which that image is to be transferred, it is encrypted. So as it is transmitted, it is not in the form of what we would imagine the image of Form 34A. If I was to use an example, if it was to be a water pipe and it is to be encrypted, it means if you broke into that water pipe, because we all know that the chemical formula of water is H2O, you'll get your hydrogen on one side, you'll get your oxygen on one side. It then means you'd not be able to make sense of that water that you're looking for. Again, we must be able to relate this with other factors. In the KIMS kit, we have certain information that is resident, close of business in any polling day. One of them is the question as to the voter turnout of a day. It means for somebody to intercept that system, they must have information in relation to the voter turnout of that day. It may not be practical for somebody to say that they have the capacity to know the voter turnout throughout the country at the second at which they want to intercept a particular form transmitted. Again, if we exceed the number of people who voted, then again, from an accountability perspective, it would be very easy to point out to say, because of the fact of this interference, you've exceeded the numbers of what was captured in your report. To give further comfort, this transmission is done over a virtual private network. which is provided by the mobile network operators, who themselves also secure that environment to ensure that there is no intrusion or interference coming from any quarter into the system. For a good, perhaps, mental understanding of what this means, or how this was applied, Michael Ouma in his affidavit says that there were more than 380 million hits on trying to, just to access the public portal. And that according to him, none of the systems even blinked. That is how secure that environment is. Now, the other question that somebody would want to look at in relation to Article 86 is the compliance with the provisions, statutory provisions in relation to procurement and all those. Again, I invite you, my ladies and my lords, to look at paragraph 64 to 71 of the affidavit of Michael Ouma. He then ends at saying that close of business, more than 14,239 people were successfully identified through that system. He describes it, to use his words, as a military-grade system. That is how comfortable he is with that, with the security features of that system. I come to the second question, which is whether there was interference with uploading and transmission of Forms 34A from the polling stations to the IBC public portal. The emphatic answer is no. I have given a general description of the infrastructure that was laid out. I will take a few moments to demonstrate that it wasn't possible to get into that system, and that even if somebody attempted to get into the system, then it would have been noticeable, to again speak to the fact of verifiability, and that one would be able to pick that with pinpoint precision because of the manner in which the system works. For purposes of a clear understanding, it is purely because of that verifiability that we are able to hear our colleagues appearing on this other side for the petitioners saying that they saw a gentleman called so-and-so who accessed the system. So-and-so accessed the system because of verifiability. It means that those who were able to access the system must have been people who were then authenticated to access the system, because certainly you must get some human intervention if the system is to work. To this extent, we'll then invite you to look at the affidavit of Hilda Kavonga. Hilda Kavonga is the manager security and business continuity. Again, Hilda confirms emphatically that the system was not breached. She speaks at paragraph 7 in good detail about how robust that system was. I invite you, my ladies and my lords, to look at the structure of that infrastructure and just appreciate for yourselves how then it was secure for purposes of protecting the will of Kenyans. At paragraph 12, she even goes on to give security assurance through certification from the National Institute of Standards and Technology. Now, we look at this in relation to the allegations that have been made. There is an allegation about staging. Learned counsel, senior counsel, Philip Murgor, spoke about the man in the middle. The indication or the allegation appears to be that somebody intercepted the system or broke into this system, downloaded this form, altered this form, uploaded it again, and sent it or transmitted it to the National Tallying Center. Like I said, when eventually we have an opportunity to look at the details that we have submitted, including the KIMS returns, it will be apparent that there was no such intrusion. But assuming for one moment that we want to interrogate this fact of staging, We then would want to ask ourselves, at what point in time did this happen? Because according to the infrastructure that is laid out by the IEBC, once a form is transmitted from the polling station and it gets to the public portal, it also has certain inbuilt security components. It has a digital signature. That digital signature marks an indication as to the exact time when that form was transmitted. If there's intervention, then certainly there must be a lag between the time when that form was transmitted and the time the form got to the National Tallying Center. It is our submission that nothing has been presented before this court to even come close to making that suggestion. Again, as part of the security that is in the portal, each of the forms that get there are serialized. And the serialization is tied to the polling station. It is tied to the date, to the time, up to the second when that form was received. It then, as an additional property, gives you a tab to be able to confirm or verify whether there's been any alteration on the form from the time it was transmitted.
Has purported to present before this honorable court that he has neither the knowledge nor connection with NSAC. The record establishes otherwise. Indeed, from Mr. Kenyans' affidavit sworn on 28th October 2022, it is clearly shown that on 4th July 2022, the chairman was in attendance of a meeting of NSAC and briefed the NSA on the status of the preparation of general election and sought to involve it fully on matters of security, both in context of ongoing activities and also to help them from time to time. I would like to refer you to page 31 of Mr. Kenyans' affidavit annexed to the notice of application, which was notice of motion, which was filed before this court to get the context. At page 31, you start from page 29, and there it is shown the remarks which the chairman, Mr. Chebukati, made to NSIC, and then he went out to outline the full infrastructure of what will happen at the elections, agreed on the assistance which was required, and at the end of the meeting at page 31, NSSC reassured IBC that it will offer necessary support to ensure successful conduct of general election and achieve its constitutional duty. Members also pointed out that successful results transmission was critical and the issue of budgetary constraint by IEBC should not arise, and indeed agreed to assist IEBC on any budgetary requirements for purposes of transmission. And it is from there that the relationship continued. You will also notice that the visit to the IEBC Tallying Center was instigated as a result of the activities which had gone on 13th and 14th, when there was suspension of transmission and display of the result, and without explanation from the IEBC. As deponed by Kenya, he called the chairman and advised him that the NSC has intention to send a team to meet him and his fellow commissioners for purposes of discussing the security and implication of concerns surrounding transmission, tallying, verification, and declaration of results. The chairman posits that he was early in the morning when you go through his affidavit, visited by a number of individuals, some of whom comprised politicians and some of whom were various eminent persons in the country, and that their intention was not to enhance the credibility of what he was doing. But he tries to conflate this with the visit of the NCSC by saying, connecting it to what had happened that night, that further, that at 10 a.m. in the morning he was informed by Professor Goulier that the team from NSCA had arrived at the tallying center, and he later learned that they had proceeded to the office of Deputy Inspector General of Police. Nothing could have been true than the fact that he was rang by Mr. Kenywa, who told him that because of security concern and tension which was arising in the country, arising out of non-transmission, and of course we have had an example on this in previous election, he was sending a team to go and visit him and discuss the issue of security. That notwithstanding, the chairman pretends that this was an issue which he only came to know when he was informed by Professor Goulier. But immediately thereafter, he concedes that he was rang by Mr. Kenywa, but pretends that the call was by Mr. Kenywa to tell him that the team was coming to discuss the succession procedure, which is a matter which, to his knowledge, neither him nor NCSC are involved. The chairman then adopts confess and avoid posture to discredit the mission by conceding that Kenywa indeed called him, but to discuss assumption of office. We know that assumption of office is a process which is statutory, and members of that office had been appointed and are known and are not members of NSAC or persons who went to see him. Further, it could have been stated in the midst of the ongoing tension that the NSAC is sending a delegation to discuss assumption of office when the whole country was waiting and tensions were rising, and in fact there was almost a breakdown at Bomas as these things were going on. The mission was led by Kennedy Kihara, who was the only person who addressed the chairman. The other members didn't speak, and the other commissioners of the other commissioners of IBC of NCSAC, Mr. Kennedy Kihara and the mission was led by Kennedy Kihara, who was the only person who addressed the chairman, and the other commissioners of IBC. Mr. Kennedy Kihara, in his affidavit sworn on 28 February 2022, equally confirms that his own presentation was to express the need to expedite the process of declaring the results and ensuring transparency in order to avert public anxiety. But the attitude of the chairman is exhibited by the contempt by which he treated this team. They were not met when they came. They managed to find where to wait, but they were kept waiting for 4 hours. Members of a security team in the midst of an election where tension was rising. Having led them, the chairman claims that Mr. Kihara proceeded to caution him, among others, that if IEBC declared the results the results with Honorable Ruto as the president-elect, chaos would erupt, and that the blood of dead Kenyans, this time, they were meeting and the chairman, the commissioners, results, and ensuring transparency in order to avert public anxiety. But the attitude of the chairman is exhibited by the contempt by which he treated this team. They were not met when they came. They managed to find where to wait, but they were kept waiting for 4 hours. Members of a security team in the midst of an election where tension was rising. Having led them, the chairman claims that Mr. Kiara proceeded to caution him, among others, that if IEBC declared the results with Honorable Ruto as the president-elect, chaos would erupt, and that the blood of dead Kenyans will be in their hands. But at this time, they were meeting not in the presence of Mr. Kiara and the chairman. There were all contingent of commissioners and the team from the security who comprised 4 other people. And he is trying to allege that an executive, a top executive of government would have gone and made this declaration in the presence of all these people. This claim is of course denied. Mr. Kinyua, as you know, is a top civil servant, is a top professional, and we all know that in civil service, discretion is the promise of valor. I mean, in fact, they are so discreet that even in normal things, they would not dare have the public know it. Curiously, the chairman reported the events which unfolded at the Tallying Center on 15th August to the police, and they filed both an OB and also made a statement. There was no mention at all of this heinous act. There's also not any mention of the visit in any of the numerous statements the chairman made. As is common in the divided house of IEBC, the chairman was supported by 2 commissioners who incidentally also went to the police and made statements, and both also filed an OB, no mention of this incident. On the other hand, the 4 dissenting commissioners have filed an affidavit dated 28th August, which confirms on behalf of ourselves and 3 others that the meeting indeed took place, and what was discussed was issues of security, as was indicated by Mr. Kiara. The allegations made by the chairman are extremely grave and have irretrievably sullied the conduct of the official concerned, and indeed, if proven, can constitute an offense under Section 12 of the Election Act. The court views such allegations with great gravity. It has been the position of this honorable court that where an election offense is alleged, the evidence should be clear, cogent, certain, and the proof of which the law commands to be beyond reasonable doubt. It cannot be based on allegation on one side, on a team which is known to be divided, each part supporting its position, and on allegations of the chairman without any further proof when he had had an opportunity to indicate what happened and failed to do so. In the result, it is my humble submission that the allegation made cannot fly. All the chairman is doing is selling the character of other people to augment his claim for higher principle and integrity. And at the end of it, nothing comes out of the allegation. Indeed, after that, they proceeded, considered the results which were not ready as at the time this team was there, and announced the result he wanted to announce. Suffice is to say that this team, having met them and being satisfied that the results were being declared, made a statement to the whole country telling them to keep in peace and that all things were okay. And you will find that statement made on 16th in the affidavit of Mr. Kenywa. The next issue the Attorney General wishes to address is framed as issue number 6, and that is direction of this Honorable Court on queries whether IBC carried out verification, tallying and declaration of results in accordance with Article 138(3)(c) and Article 138(10) of the Constitution. It is the contention of the Attorney General that the interpretation of the said article is a matter of public interest without going to the application of the article to the dispute before you. The parties have made submissions in connection with the above matter and will not try to take your time by repeating submissions already on record. In this respect, I adopt fully the submissions by Attorney General dated 28th August 2022. The starting point, however, are the two provisions which on the face of it have no ambiguity. They are clear and unambiguous. The Commission is established under Article 88 of the Constitution. Article 250 provides its composition as consisting of at least 3 but not less more than 9 members. Article 253 establishes the composition of each of the independent commission, and Article 253 provides its incorporation. Now, there has been interpretation both by this court and by the Court of Appeal as to what Article 138 it means. And in that respect, I would like to refer you to the case of Raila versus Electoral Commission, and that is the second petition of 2007, and at page it is starts at page 153. At page 153, this Honorable Court referred to the case of Maina Kiai, and in it, it stated as follows. Clearly, at paragraph 263, clearly this provision in mind, the Court of Appeal in Maina Kiai decision was categorical as it rendered itself thus: we are satisfied that this elaborate system, the electronic transmission of the already tabulated results from the polling station contained in the prescribed form, is a critical way of safeguarding the accuracy of the outcome of elections. I do not see how the appellant or any of its officers can vary or even purport to verify those results. Further, the Court of Appeal stated thus, and this is the important one: the appellant, as opposed to his chairperson, upon receipt of prescribed forms containing tabulated results for election of the president electronically, transmitted to it from the near 40,000 polling stations, is required to tally and verify the results. The appellant as opposed to its chairman. Later in the ruling, the court stated that it was further argued, that is paragraph 293, it was further urged in court by a number of counsel for the first, second, as well, that disregarding from 34As and exclusively relying on Form 34B, many of whose authenticity would later be called into question in the tallying process, the said judgment was simply complying with the Court of Appeal in Maina Kiai. We have already held that we find little or nothing in this decision to suggest that by deciding the way it did, the appellate court restrained or barred first respondent from verifying the results from the before declaring them, or that was relieving the former from statutory duty of electronically transmitting the results. What the second respondent was barred from doing by the Court of Appeal and the High Court was to vary, alter, or change the results relayed to National Tallying Center from the polling stations and constituency tallying center under the guise of verifying. So here, when they say what the second respondent was barred from doing, they are referring to the chairman. And it seems to imply that the verification ought to be done by the chairman, whereas the court also quoted with approval the finding in Maina Kiai to the extent that the appellant, as opposed to his chairperson, upon the receipt of prescribed form containing tabulated results of election of president electronically transmitted, is required to tally and verify them. The Maina Kiai decision is expressly clear on the issue, and it states at page, I think it is page 104 of our list of authorities, authority number 3, in Attorney General's Case Digest and Bundle of Authorities, page 67 to 107, it says that we hold further that reference to the appellant in sub-article 3C is not to be construed to mean the chairperson, but rather the returning officers who are mandated after counting the votes in the polling station to tally and verify the count and declare the result. The appellant, as opposed to its chairperson, upon receipt. The appellant, as opposed to its chairperson, upon receipt of prescribed form containing tabulated results of the election of president electronically transmitted to it from the near 40,000 station, is required to tally and verify the results received at the National Tallying Center without interfering with the figures and detailed process. In Article 138.10, the chairperson then declares the result of the presidential election and delivers a written notification of the result to the Chief Justice and to the incumbent president. That is now circumscribed and narrow the role of chairperson of the appellant. So it is clear from that according to Maina Kiai, the role of the chairman was to declare the results, and the role of the IEBC was to tally and verify. And that is indeed consistent with the expectation of Article 10, our national principles and national values. So we humbly request this court to take this opportunity to clarify the position without, I think we need to emphasize, and based on what Justice Lena Ola was raising yesterday, the issue of prospectivity and retrospectivity. We're not going to that as the Office of the Attorney General. The Office of the Attorney General wants a clarification of this provision for future election and on how it impacts on other commissions. Is executive role conferred on the chairman, or the chairman is part of the commission and can only act in community with the commission? And that is consistent also with the provisions of the amendments which were done, some of the amendments which were done in 2017. You will notice that the commission has clearly delegated functions to the returning officers. Section 39(1)A, that deals with National Assembly and County Assembly for them to tally and verify and declare. And 39(1)B deals with the right of the returning officers to tally, verify and declare the governor, senator, and county women assemblies. But the provision purported to confer the right on the chairman to deal with presidential elections, and that Maina Kiai was very categorical that it was contrary to the provision of the Constitution, and this is what they said. they said that the controversial regulations 83.2 and 87.2 were not affected by amendments, and the object is not difficult to see. The High Court, having found those regulations, that's at page 105, to be inconsistent with the Constitution, it was in bad faith for the appellant to reenact them while pursuing this appeal. It is our firm position that the purpose for which Section 39.2 and 3 of the Act and Regulations 83.2 and 87.2c were promulgated or made have the effect of infringing constitutional principles of transparency, impartiality, neutrality, efficiency, accuracy, and accountability. So that was the position of Maina Kiai. Maina Kiai came to this court. The appeal didn't succeed, and therefore it has impliedly been confirmed by this court. So we humbly request your lordships to take this opportunity, and my ladies, to take this opportunity to clarify that position. To go back, in conclusion, to the members of the NSAC, Lord, I would like to humbly submit that these are Kenyans of integrity, highly professional, who have pulled themselves with their bootstraps and reached the echelon of our system, and it would be very unfortunate when it is left for their name to be sullied in the midst of a political context in which they have no interest. In fact, they were merely asked by the NSAC to send a message. A spokesman was appointed who went and sent the message, but they are now being tarred with the brush of having been trying to unconstitutionally alter a process which is sacrosanct and which they have sworn by their oath to protect in assuming their position. That's my humble submission, and I will donate the 3 minutes to the court. Thank you.
Thank you very much. The 3 minutes and 16 seconds are welcome.
Thank you.
Yes. Mr. Ngatia.
Thank you, Madam President. Please first allow me to introduce the lawyers who have burned midnight hours to present so many affidavits before you. My name is Ngatia Frederick. I'm assisted by the following lawyers: Mr. Kirago Kimani, Senior Counsel; Mr. Kioko Kilukumi, Senior Counsel; Professor Kithuri Kindiki; Mr. Katwa Kigen; Dr. Muthomi Thionkulu; Dr. Linda Musumba; Professor Kivuva Kibwana; Mr. Elias Mutuma; Melissa Ngania, who I had the opportunity to present a matter in 2017 with her; Mr. Mwanza Ombati; Mr. Kipchumba Mokomen; Mr. Benson Milimo; Mr. Wilfred Nyamo Mati; Mr. Edward Mureu; Mr. Hilary Sigei; Madam Monica Nyogutu; Mr. Collins Kiprono; Wanjiko Nyaga; Emmanuel Kibet; Ian Shelela; Caroline Cherono; and Chris Ayeko. Most of them are in court number 1, following the proceedings very intently. Madam Chief Justice, I rise before you. I know it's been 2 long days. Please bear with us to oppose the petition filed by several petitioners. It is the first time in the history of this country that we now have 8 petitions. It must be a new strategy to disable the president-elect to mount a defense against 8 petitions within 4 days. but we didn't manage the impossible, and we now present our defense as follows. First and foremost, my lords, let us appreciate that these consolidated petitions arise from a presidential electoral contest. It is an electoral contest. Ideally situated, or it should ideally be resolved by electorate, the Kenyan voters, not by a court of law. But because it is also part of the constitutional structure of this country, this honorable court is granted original jurisdiction by the Constitution to resolve this contest. But in resolving this contest, it is necessary to bear in mind that all you have are affidavits filed by the contestants. The difficulty with affidavits is that one can structure fiction and peddle it as a pleading, as I'll be demonstrating. I will start with Article 38 of the Constitution, because to me that is the beginning of an understanding of this contest. Article 38 is the one that empowers a Kenyan to vote by secret ballot. And that simple sentence can be broken into two parts. Voting by secret ballot, meaning it confers on the individual power to exercise a freedom of choice, unhindered by anything. Number two, or the second part of it, the vote gives the citizen a power or a badge of dignity for self-actualization. Self-actualization in the sense that a voter is entitled to vote for a candidate of their choice. Article 38, to my understanding, therefore becomes the beginning of the understanding of the correct situation that is before this court. It is common ground, and this is important, my lords, that on 9th August, voting took place everywhere in this republic. There is not a single place that presidential election was not held. Even in Kakamega, Mombasa, presidential elections were indeed held. There is no area in this country that did not participate in that voting. Accordingly, legitimacy, I go to the next point, legitimacy of any electoral victory is predicated on the fact that voting did in fact take place. From Article 38, one then goes to Chapter 7 of the Constitution, from Articles 31, going all the way to Article 81, going to 87, which donates a power to Parliament to legislate on elections. I would immediately say this, Madam Chief Justice. The power to enact Elections Act, to my mind, relates to the 5 other tiers of elections. For the simple reason that for the presidential contest, the inquiry is defined in Article 140. The relief is defined in the same article, whereas in the other levels of elections, one could look at the Elections Act. But I'll come to that a little later. I'm doing first and foremost a broad introduction of the areas that we'll deal with. As I indicated, the scope of inquiry of a presidential contest is defined in Article 140. Before you are 8 petitions. They have mutated. Now there are 7. Oh, very well. Thank you. They have mutated to a large extent, particularly the primary petition. But my request at this early stage is this, that when you retire to consider your judgment, please carry out some surgery, see the mutations which have been added, remove them so that you are left with the original inquiry under Article 140. Why it is necessary to do so is because other things have been infused in this inquiry, like who is to be punished, who is to be castigated. Those are not matters that can be dealt with within the purview, limited purview of Article 140. As a matter of fact, when we argued Raila 1 in 2013, this apex court said a petition under Article 140 should be, I quote, concise, precise, and well-focused. Well-focused. It cannot be a meandering, never-ending saga involving other persons other than the inquiry which is specified in Article 140. As I indicated, since elections were held everywhere, that legitimacy then translates to the following. The people of Kenya did express their sovereign will. They did express that on 9th, and what is now under inquiry is whether that sovereign will by the 14 million Kenyans is to stand unhindered, or whether this court would consider any other remedy other than upholding the sovereign will of the voters. Madam Chief Justice, just barely 2 years ago, Ghana was in the same position that this court is in. They held their elections. A presidential candidate went to the Supreme Court. Identical complaints were made. Complaint number 1, ballot stuffing. Complaint number 2, votes ought to have included rejected votes. Identical with the complaint before you. Complaint number 3, the chair lady was not being fair to the losing candidate. Identical things. And what is now happening in this new space is that we are all getting the drafting skills of our colleagues in other jurisdictions. Dumping and staging, we learned of it in America not too long ago. It is now before you. Ghana, 2 years ago, had identical complaints with the complaints which are before you. I pause, before I go to the Ghanaian way of resolving this dispute, to acknowledge my good friend, the team leader, Mr. Senior Counsel Orengo. He started by saying his case is not based on conspiracy. And he had to do that disclaimer for a good reason. It is the reason that, other than conspiracy, there is no case. And I'll come back to that in a moment. I go back to Ghana. Ghana considered all the evidence that was adduced, and the Ghanaian Supreme Court came to this conclusion, that the work of the court in a contest of this kind is to look for a substantive truth. I underline the words substantive truth of the elections. Look for the substantive truth of the elections. That's their Ghanaian approach. Then if you look at the you are able to ascertain the substantive truth of the election, then the next very important values, they call them values, is to try to get finality and stability. Substantive truth of the elections. Next layer, finality and stability. Why is there need for finality and stability? The whole purpose of these elections is actually to underscore our democracy, to have a government in place for the next 5 years, and then we'll have yet another round of seeking the voters' validation of who will form government. I emphasize the finality and stability because at the end of this contest, what will be bothering this honorable court, if I dare say so, it is what are the reliefs to be given. Elections are carried out by our good Kenyans. I said in 2013, I repeat it again, we are unable to inculcate amongst ourselves the culture of accepting the electoral result. We are just unable to do that. Maybe it is in our psyche, maybe it's in our makeup, but we are unable to do that. Because we are unable to do that, we must then come to this honorable court to try and resolve that dispute in a very unfair way, because the dispute ought to have been resolved by the electorate. In my submission, when you look at this case, devoid of lawyers' arguments, you find it is based on certain planks. Plank number 1, Form 34A was hijacked mid-air, altered, votes from one candidate, losing candidate petitioner, removed, added to the votes of respondent number 1. That is a major plank of it. The easiest way to look at it, because I do not have the ability of Mr. Mahat, who dealt with technology, is to look at it from a point of logic or the antithesis. The antithesis being this: if that is true, from a point of logic, show us one Form 34A in the public portal, because that is where ultimately it landed, which differs with the hard copy at the polling station. Show us only one. Or show us a ballot box that people from outer space came and voted into, stuffed into it, and then all this hijacking in midair took place. There's no such evidence. And why there's no such evidence is because that is the work of fiction. Work of fiction, not just conspiracy, but work of fiction. In my submission, therefore, amongst the many things this court is now being called upon to do, is to find a way of moderating, I use the word moderating now in the correct sense, the excesses in the political contestants. Excesses such as imagining that this Supreme Court can now take over the role of voters and do a court coronation of any candidate. That would be a heresy. I will be dealing with the reliefs much later. I'm just doing a broad outline. And the next broad outline I would wish to do is to indicate to this Honorable Court that the orders sought in the primary petition, apart from being contradictory, would take this country to a constitutional crisis. We now have the incumbent in office with the limitations in Article 134. Limitations which are set or cast in stone by the Constitution. The incumbent in office cannot even appoint anybody to take over from any of the public officers being vilified before you. If, for example, and I say for example guardedly, this Honorable Court were to even countenance anything other than stability and finality, then a constitutional crisis would be triggered because the petitioner has repeatedly said he will not participate in an election held by IEBC under the chairmanship of Chebukati. We have adduced that evidence in the replying affidavit sworn by the first respondent. That replying affidavit is before you. It was filed on 26th August. We have attached a clip of that discussion. It's in an affidavit by Samuel Gedhae of the same date, 26th August, and all those are matters that are before you. Since the petitioner will not participate in a fresh election, does not want to accept defeat, then what does he offer? What is the solution he offers? The solution he offers is that there be an election presided over by the vice chair lady of IEBC. And only one needs to state that to see the crisis that this country will be engaged in. It will be a crisis of monumental nature, a crisis that I do not think that you would want to play with that kind of fire, because it will be fire upon fire. In my submission, therefore, I would request this Honorable Court, as we begin our submissions, to bear in mind how Ghana resolved an identical situation by, number one, looking for the substantive truth, and then immediately that should trigger a relief which is finality and stability. If this Honorable Court were to do that, I see a future for us. Any other solution, the crisis offered by the petitioner cannot be a crisis that this court can countenance, because your fidelity is not to anybody other than the Constitution. Since your fidelity is to the Constitution, I dare say then the reliefs that you could consider are the reliefs within the constitutional structure of this republic. With those comments, Madam Chief Justice, allow me to invite the first counsel to present, who is my good friend, Mr. Katwa Kigen. Mr. Katwa Kigen will deal with issues issues 1, 2, and 3.
May it please, Madam President, my ladies, may it please you, my Madam President, my ladies, my lords, my name is Katwa Kigan. I propose to deal with issue number 1, 2, and 3, and may I indicate that in dealing with those 3 issues, I'll be dealing with them together with Dr. Mutembei. My lords and my ladies, the 3 issues are to this effect. The first issue relates to the integrity of the technology, and the wording of that issue is whether the technology deployed by IEBC for the conduct of 2022 general elections met the standards of integrity, verifiability, security, transparency to guarantee accurate and verifiable results. The second issue relates to the question of whether there was interference with transmission, and it is to the effect whether there was interference with the uploading and transmission of Form 34A from the polling stations to the IEBC public portal. And the last issue that we will be dealing with Dr. Mutembei is the question of whether there are differences in Form 34A, and the wording is whether there was a difference between Form 34A uploaded to IBC public portal and the Form 34A received at the National Tally Center and Form 34A issued to the agents at the polling stations. Now, my lords and my ladies, some of the issues that I will be discussing, or rather some of the issues we'll be discussing with my learned colleague, are issues that have been discussed, but we must mention them, especially considering what the petitioner in the petition that we are dealing with, the one by Honorable Raila, states at paragraph 35 of his petition. And in that petition, I'm just reading the second sentence of that plea, where he states, the evidence shows that the acts complained of were committed by third parties, senior employees of IBC, acting in connivance with the second respondent in order to achieve a predetermined outcome in favor of the 9th respondent, and the 9th respondent for purposes of this petition is the first respondent. And so we are coming from the position that we maintain and insist that there was nothing that the first respondent did that could be said to have exceeded or to have amounted to collusion with the IBC. And I would like to start my submissions by reference to the issue of Form 34A and what the first respondent and the second respondent did. My lords and my ladies, in Mainakia it was determined that Form 34A is for all practical purposes cast in stone. What Form 34A contains is the last word in respect to the wishes of the voters in the given polling station. And if it has to be in any way impeached, it is only when it has been brought to court. And so in recognition of that, the first respondent, as allowed in law, availed his agents at the polling stations to participate and watch over the process of the elections. And we wish to emphasize that the place of agents is a very material part of this petition. It is going to be a very important issue in your determination of this petition. because the bulk of the evidence in respect to the issue of Form 34A in this petition is the allegation by one Arnold Ochieng, an advocate, saying that he received Form 34As which showed that the data in the Form 34A in the public portal, the data in Form 34A that the agents of the petitioners had, and the data in Form 34A that were brought by the returning officers to the National Tally Center were different. And so the question of whether or not they were agents, whether they could be trusted, and so on and so forth is important. But for purposes of the first respondent, we wish to maintain the position that he had agents, and those agents have failed to him from 34A through his lead agent. And after the Form 34As had been filled at the polling station, and all the agents available had been invited to endorse and confirm that the data captured in the Form 34A were true and accurate. After that had been done, the first copy of the Form 34A was then transmitted to the National Tally Center, the public portal. The other one was then taken to the National Tally Center. Now, I just want to emphasize two issues in that. One is that both the parties for the petitioner and the parties for the first respondent had a chance to participate. The second thing I wish to emphasize, my lords and my ladies, is that in the entirety of the petition, none of the Form 34As at the point of the polling stations have been presented as having been challenged at any point. So that then the irresistible conclusion that should be made from the point at which the Form 34A originates is that those Form 34As represented an accurate state of affairs at the polling station, both in terms of data and in terms of the integrity of the process of voting and the counting of the votes. And as I said, then the Form 34As find their way to the National Tally Center, both in terms of transmission and the physical delivery by the returning officer. Again, agents for both parties were given a chance, and as allowed in law, the first respondent made sure that he had representation of his agents and has presented some of those agents to vindicate and verify that the data that was eventually verified at the National Tally Center were the accurate data of what happened at the polling station and passed on to the National Tally Center. I would like also to emphasize that the two things that were supposed to be done at the National Tally Center was to determine the data, and secondly, to establish the security features of the Form 34As. Having said that, my lords and my ladies, and considering that especially at issue number 3, your attention is on the propriety and the integrity of Form 34A, I must submit that the petitioners have not adduced any evidence of any challenge of any Form 34A at any point in the national tally. And this is the second chance they have, having had an initial chance at the polling stations. There is none of the Form 34As that have been challenged. It is with this state of affairs then, and as a result of this process, that eventually we have the declarations of the result coming out to indicate that the total votes cast, total valid votes cast were 14,213,027, being a product of a process that was interactive and where all the parties were involved. It is a product of this process also that comes out with the result that the first respondents' total votes were 7,176,141. Now, the process of verification of the Form 34As before they were transposed to Form 34C is a process that took 6 days. And over the period, all the 6 days, my lords and my ladies, as I already indicated, there was no objection to the verification of the Form 34S. It is our submission, my lords and my ladies, that the petitioner, through his agents, were happy with the process up to the last minute when the tallies were done, and it reflected a win for a party other than the one they wished. So that the reluctance and even this petition is based on objection as to who the Kenyans had wished to be their president. Having said that, then I would like to move on to the main party who has challenged Form 34A. The witness the petitioner has brought for purposes of challenging Form 34A, being one Mr. Arnold Ochieng, and especially all the respondents have referred to him. Probably I shouldn't miss the opportunity to mention that Arnold Ochieng is an advocate. And some of the criticism we have about his affidavit and what it contains is to be looked at with the higher regard of the fact that being a lawyer, he should know more. One, my lords, he has sworn the affidavit and attached Form 34A when in his affidavit he acknowledges he was not an agent at any point. And so it brings in the point that that affidavit and what he says is hearsay. Number two, he produces about 20 Form 34As, and in all of them, he does not mention the agent who gave him. He does not say, I received. He says this Form 34A is defective because it has data that is at variance with the public portal. It is at variance with Form 34A that was brought to the National Tally Center. But he does not say at any point which of the agents gave him that Form 34A. Number three, he brings the Form 34As and says they were given to him in terms of either photocopies or photographs from the agents who were on the ground because he was not there. But he does not produce a certificate of electronic evidence to show that those agents have confirmed that indeed this Form 34A was properly generated and is capable of being treated as evidence of any property value in the consideration of your case, of this case, sorry. And lastly, my lords and my ladies, Mr. Ochieng then certifies that these Form 34As that I'm producing, having skipped, of course, certification from the point of agents, he does a certificate himself saying this Form 34As that he's presenting to court meets the criteria required by Section 106 of the Evidence Act, the electronic evidence. That certificate, my lords and my ladies, says it is a certification of a production of a video, when in fact the attachment he produces are forms, Form 34A. And so, my lords and my ladies, in considering that item number 3, the issue number 3, we pray that you take into account that the principal witness on that issue of Form 34A has adduced absolutely nothing in support of the petitioner's case. Firstly, my lords and my ladies, on our part as the first and second respondents, and similar to what the third and the fourth respondent did, was to pick the Form 34As that the petitioner had brought and said they demonstrate that the Form 34As lacked integrity. And then we went to those polling stations and asked the agents and the presiding officers in those polling stations to confirm to us what they know about the Form 34As that Arnold had brought to this court. And my lords and my ladies will see that we have attached over 6 affidavits from the agents, and each of them say each of those forms were falsified. And I'm using the words falsified to be polite about the issue. I know my colleagues have said worse than that on that issue. The third issue I wish to take up on the issue of Form 34A, the first one was the process. The second one is the evidence against the first and second respondent on that. The third issue I wish to take up about that Form 34A relates to the issue of how they were housed in the public portal and the transmission. And the first point I wish to observe and submit, my lords and my ladies, is that we pray that the court keeps the conscious awareness that the elections were not electronic elections. They were manual. The only issue that was electronic was voter registration, voter verification, voter identification, and the results transmission. And in these proceedings, our focus and attention relates to transmission. Having said that then, my lords and my ladies, we pray that the court takes in on board the point that is made in Section 39 of the Elections Act, Section 39 1F, and the decision of this court in Odinga 2013, paragraph 237. At Section 39, it is indicated that the propriety of the election process will not be defeated by reason of results transmission. And in the Odinga 2013, the court said that it takes judicial notice that it is possible that technology can fail and our elections will not be held captive to the likelihood and the risks that relate to technology. Now, my lords, we would like them to submit to this effect, that assuming for argument's sake, it is true that there were any deficiencies or any defects in the process of the transmission of the results, it is our submission that that did not impeach the elections, because eventually the election and the results were declared based on the hard copies that were brought by the returning officers from the constituencies. They were not based on the portal, that the portal is meant for comfort, for transparency, for accountability. It is not meant to represent the accurate and the true results. It is the hard copy that is taken to the National Tally Center for purposes of verification in terms of data and for security features. Two last issues on that issue, my lords and my ladies. The first one, my lords and my ladies, is we pray that in reflecting on this issue of Form 34As and the alleged discrepancies and improprieties, you do note that the petitioners do not point out the variances that they are alleging exist. But most importantly, they do not come up with their own tally. They are saying the results that I just read a few minutes ago, that is 14,213,027 being the total valid votes cast, and the 7,176,141 in favor of the first respondent are inaccurate. They say that. However, they do not come forward and say this is the correct tally and it is based on what. And we pray that you take that on board in considering that issue. With that, my lords and my ladies, I submit that the petitioners have failed to discharge their burden of proof, which is above balance of probabilities, to demonstrate that indeed there was any deficiency or defect in Form 34A or in their transmission, and I adopt the submissions made by my colleagues, especially for IEBC. The second issue I wish to address, my lords and my ladies, is related to the same issue of transmission, being the alleged logs that third parties are said to have used to interfere, and in the words of the petitioner, to stage, to dump the Form 34S. And my lords and my ladies will notice that in support of this contention, the petitioners are relying primarily on two affidavits, one by John Kidongo and the other one by Benson Wesonga. And the chain of events is to this effect. John Kidongo swears an affidavit that he sat in some discreet place. He says somewhere in Karen. I don't know what he has against Karen. He says he sat somewhere in Karen with someone whose identity he doesn't disclose, and he was told that some log particulars were used to interfere with the results. Then we have the Nwesonga step in and purport to analyze those logs and say, indeed, his observation as an expert in IT is that those logs were used to interfere with the results. And we would like to observe a couple of things. The first one, my lords, as already submitted by my colleagues in the IBC, for the IBC, is that that evidence from Kidongo is a third level hearsay. It is based on information given to somebody who is not disclosed, and Kidongo is the third person in that order. By the time Benson Wesonga is purporting to do analysis, he is at fourth level of hearsay. But more interestingly, my lords, we took time to look at the logs, and what struck us was that one of the logs which had been manipulated, one of the logs escaped their attention, and it has a date 2017. I know my learned friend Mahat already explained how in the 2017 polling stations were used as part of those, possibly the matrix of the logs. On our part, we noticed the date 2017 and it piqued our interest. When we checked, my lord, we realized that indeed the particulars of those logs, or substantial parts of those logs, were parts of logs that had been posted by his friend Professor Makau Mutua in 2017, and they had just been lifted and purported to be the logs that had been used in 2022. In response, and without being technical, we put in an affidavit saying these logs were the one tweeted in 2017, these logs were the one used in the petition in 2017. And what then Mark Kidongo did was to make a fast retreat and saw an affidavit saying, I am retracting what I said, I am retracting the allegations that those were the logs that were used. Now, unlike the first affidavit where he had said he had been given those logs by somebody else, he now comes and disowns those logs personally. He does not say, I have gone back to the shadowy person that I had used, and he has told me that I'm mistaken. He now takes responsibility for it and says they are wrong. But he not only says that and just leaves it there, he says, by the way, please understand me, they were meant for demo. He says that I had indicated them and they were meant for demo. And you look at that, you'll see that in his affidavit of the 28th August 2022. Now, my lords, more importantly for our petition, more importantly for our response to the petition, is that those are the only logs that had been presented for purposes, in terms of logs, those were the only logs that had been presented for purposes of challenging this petition, these elections. With Kidongo's withdrawal of those logs, my lords and my ladies, we would have expected that then that element of the petition would not be given to you. You would not need to consider them again because they have been withdrawn. What happens then? One Justice Nyangaya walks in as a respondent and introduces new set of logs. And then, almost in character of Benson Wesonga, he jumps into those ones and now analyzes them and again says they demonstrate and indicate that there was interference with the transmission and the public portal. My lords, as my senior counsel Ngatia had indicated, we have a scenario where the petitioners were able to have friends in the part of the case of the respondents. And then we have the situation where Nyangaya as a respondent now makes a new petition, my lords. And we would like that to be an issue for your consideration. Whether you will look at the new logs that have been introduced by Nyangaya in the cause and purport that he is a respondent, when in fact he is an extension and a surrogate extension of the petition. We submit, my lords, that, and my ladies, that you should reject the attempt to have introduced a new petition, one, and number two, a petition that was filed out of time, and number three, that has been innovatively done by the petitioners to extend their case. We pray that you do find that the issues of the logs are dead and they are not available for your consideration. As my learned friend Mr. Amhat said, and Abdikadir said, we would pray, and Mr. Gumba also said, we would pray that you apply your minds to the scenario where parties come and present to you petitions purporting them to be well-founded when in fact they are based on falsehoods, my lords. And my lords, we challenge you to exercise your capacity to be annoyed at this kind of a conduct. Lastly, my lords and my ladies, I have been instructed to also say something about the arguments made by my friend Omutata in petition number 7, in which he argues that the data shows that indeed none of the contestants achieved more than 50+1. And I just want to say three things, my lords and my ladies. Number one is that Omutata, in paragraph 14 of his petition says the 65.4% that he's using was picked on the 9th of August 2022. My lords, as Maha had already explained, that figure kept changing, as by close of day on the 9th of August it had changed to 64.6, and by close of all the data it was 64.7. My lords, he used a percentage that was not static but was moving. The second thing, my lords, is that he used the wrong denominator. He calculated his data using the total registered voters as opposed to total registered voters in respect to the KIMs that had reported their data. And I think Mr. Maha had already explained that very well. And for all those reasons, my lord, we pray that you do not come to any temptation that indeed the 9th respondent did not achieve 50+1, but indeed to adopt the calculations as done by IBC. Thank you very much, my lords. I pray and request to cede ground to my friend, Dr. Thiongolo.
My lady and my lords, my name is Mudomi Thiankolu. My senior started addressing you on the fictional aspects of the case before you, and I'll focus on showing you why it is fiction. And in the literature and the arts, they talk of several genres. When we thought about this matter, we thought the fiction before you is of the genre called tragicomedy. That is a combination of comedy and tragedy. In terms of tragedy, we thought of Macbeth, and we thought of Macbeth talking about the demise of Lady Macbeth and the frustrations of life, and saying it is a story full of sound and fury, which signifies nothing. I will tell you shortly why this petition before you is a work of fiction, and specifically a story full of sound and fury, what my colleagues have called shock and awe, but which signifies nothing. We thought of the comical bit of this case that we have to engage this eminent court to hear spurious allegations. And the comedy we thought about is called Much Ado About Nothing. And we'll be hoping to persuade you that the case before you is not only full of sound and fury but signifying nothing, but is much ado about nothing. Lastly, we came closer home and thought of a work of fiction in the realm of comedy and tragedy by a son of East Africa called Shaban Roberts. That work is called Kusadikika. And many of you, my lords and ladies who have read it, you will find it is a work in which people are invited to believe every allegation, however spurious, however preposterous. And we suggest to you that maybe the petitioner himself is taking you to be that country called Kusadikika by Shaban Roberts, in which if you're told the sun rises in the north, you don't apply your mind. Your challenge, my lady and my lords, is who do you believe amongst all these people with stories and counter stories? Is it the man whose name combines the names of two saints, John and Mark, and the third name, Githongo, who was head of ethics in this country, but has the audacity to produce before you forged logs? And when he is called out, instead of profusely apologizing, he says you yet another affidavit full of ifs and buts. Is it Arnold Ochieng Oginga, advocate of the High Court of Kenya, a learned man, to be fair, but who produced to you documents that were disowned by all the presiding officers, and documents he hasn't told you where he has found them, and which my classmate Mr. Mahat was able to show you have actually been doctored to fit into the narrative of the fiction? Or, my lord, are you going to believe Githongo when he tells you that the undisclosed man was demonstrating to him a Form 34A for governor, even though we all know the results for governor are not streamed on the public portal? Or, my lord, are we going to believe the four commissioners who we all saw day and night for 6 days and 6 nights? I use the word deliberately, my lady, because we never left our TV screens. 6 days, 6 nights. We saw them announcing results that had been verified, and you were told by Mr. Mahat, indeed, they announced most of them. But when the winner becomes apparent, they suddenly turn around and tell you Mr. Chebukati is a bad man, he should be crucified. Are those the people we are going to believe, my ladies and my lords? Or are we going to believe the petitioner himself when he tells you in his petition and affidavit that the Honorable William Ruto intercepted, altered, staged, and then dumped Form 34A on the e-portal? My lady, why we thought this was the most elementary attempt at the fiction, if you do your math, what the petitioner was telling you is that the Honorable William Ruto was intercepting and changing on average 23 forms 34A per second in the span of 8 minutes, that he claims we staged, dumped, and altered over 11,000 forms 34A. A question was asked yesterday, my lady, how do you and when do you change a form 34A? And I will invite you to note from the structure of that form that most of the data comes pre-printed. The name of the polling station is pre-printed, the serial number. So the only things you would alter on that form are actually the things written by hand, either by the presiding officer or by the agents or the deputy presiding officer. 3 clusters of people. In the event there are 4 agents, we are talking handwritings of about 7 people. And you're being told the Honorable William Ruto had the capacity to intercept these forms, 11,000 of them in 8 minutes, and alter them. It is in the realm of fiction. And I suggest perhaps politicians should stick to politics and leave fiction to artists. Or are you going to believe, my lady, when you're told that the Honorable William Ruto had this young man with a laptop at the National Tallying Center, and that this is the laptop he was using to do these things called dumping, staging, and whatever not? I think we may have our own views about various citizens, my lady and my lords, but I am struggling to understand who is this fraudster that would walk to a laptop not in some remote place, some inaccessible place where all he has is the network, but he would go to the National Tallying Center with a laptop, and the only reason he has that laptop is to intercept results in the full glare of our TV cameras, in the full glare of all those security men and women that are in that tallying center, under the eagle eye of all the agents. It is simply spurious. My Lord, you are told all these things, and I'm sorry if this is repetitive. The least we would expect is you to be shown a Form 34A that was altered, and not the ones they have cooked as a work of fiction. The least we expected is for them to tell you which are the polling stations in which this interception, staging, and dumping occurred. In short, my duty, my lady and my lords, is to tell you, even if you are to look at this case with your most magnanimous and generous set of eyes, even if you are to be as benevolent as Father Christmas, the verdict you would return is that this case before you is a story full of sound and fury, but which signifies nothing. The case before you is much ado about nothing, and you must tell the petitioner, this is not the Supreme Court of the Republic of Kusadikika. It is the Supreme Court of the Republic of Kenya. It is to be expected that when you move this solemn court, you don't put us in exercises that leave other civilizations wondering why we have to waste the time of the Supreme Court, or God forbid, even the small claims court, dealing with allegations of the type before you, which cannot be believed even by the most gullible person. Let the works of fiction be left to Hale Grissom, James Adliches, James Bond. This is a solemn platform, I regret and I pity all of us that we came to deal with such a spurious matter. Thank you very much. I see the ground now, my lady, to my learned friend, Melissa Ngania. She'll take over on issue number 4 and 5.
Thank you, Honorable the Chief Justice, the judges of the Supreme Court. For purposes of record, my name is Melissa Ngania. I'm going to address the court basically on issue number 4 and 5 as framed by the court. The cornerstone and the grievance of the petitioners in regards to the two issues, number 4 and 5, is the question of the postponement of the gubernatorial elections, as well as the variance of votes within the elective positions. As to the mathematicals, the custodian of the numbers has demonstrated before this court this morning that there is actually no variance, and whatever variance could be explained. But more importantly, Honorable Chief Justice and the judges of the Supreme Court, what is the grievance against our client? That is William Samoei Ruto and Honorable Rigathi Gachagua. I would pick the choice of words as pleaded by the petitioners for obvious reasons. This is an election petition, a presidential election petition that has the crust of proving its standard to the required laid down principles in law. Now, this is what one Celestine Anyango tells us. She tells us that the grievance against my client is that a pattern throughout the country where the 9 respondent appears to benefit from a fraudulent paddling of votes in violation of the law. They are not sure of that. They've not laid a credible tangent evidence as to the paddling of that votes to the benefit of our clients in this respect to warrant this court to annul the elections as conducted. But what is more disturbing is the position of the Kenyan voter. As laid down by my senior counsel, Fred Ngatia, that is to be found under Article 38 of the Constitution. But more importantly, we have a history as a country. We are a country that has been privileged to legislate on each and every issue that has been litigated before these courts. We are a country that even legislates on the time between which a president should be sworn in office, for obvious reasons, because of the history that has culminated around our electoral law jurisprudence. Now, the appreciation of the cornerstone of Article 38 then would seek refuge in the Constitution of Kenya Review Commission. This court, in the famous BBI case, categorically stated the history behind our constitutional making process. I'll not wish to regurgitate the same, but I'll beg the court, when you retire to write your judgment, to adopt your paragraphs of that decision, paragraph 415 to 441 in that respect. Again, Honorable Chief Justice and members of the Supreme Court, judges of the Supreme Court, then what culminated to the Article 38 of the Constitution. In the final review, for us to get the gist of the Kenyan voter, because all that we are trying to help this court to realize is that what was the will of the Kenyan voter as expressed in Form 34A. And the Kenyan voters said what they wanted, and that is to be found under page 51 to 52 of that report. Now, coming to my submissions and Article 38, in that respect, their views were finally codified in our Constitution under Article 38 in that respect. For purposes of emphasis and so that we do not lose the trajectory of the Kenyan voter, this is what Article 38, Clause 3 says. Every adult citizen has the right without unreasonable restrictions. That is the underlying word. The Kenyan voter wants to vote without unreasonable restrictions, to vote by secret ballot in any election or referendum. What we've been told is that there has been the restrictions of postponement of gubernatorial elections. There have been the restrictions of what happened in Bomas. A Kenyan voter is not interested in that. They want their vote to be traced and traced with the precision that is required. How then do you trace the vote in that respect? Form 34A becomes crystal clear. The petitioners have not challenged Form 34A in that respect, so that the votes that were cast and tabulated in that respect remain unchallenged. And where they have challenged, we have demonstrated before this court that it is unfounded, it is based on generalization, and it is based on conjecture. It cannot stand the test of what Kenyan voter would want. More importantly also, Honorable Chief Justice and members of the Supreme Court, is that how then do you establish at the polling stations? Because the problem that we are having is that there are no agents who have demonstrated any problem with the voting at the polling station. Regulation 81 of the Election General Regulations provide what should happen after the voting has been conducted. That is, the valid votes to be put together, the rejected votes, unused ballots, and counterfolds. They are to be preserved for an election court. Nowhere have we been told that none of that happened, or that there was a problem with whatever happened at the polling sessions. Honorable Chief Justice and judges of the Supreme Court, Justice Njoki Nungu in 2017, in her dissenting opinion, had this to say, that agents are a very important part of the electoral process. These are the agents of the different presidential candidates. Now, if they are not present to certify their role, they should then not blame any other person in that respect. We have established with our agents and filed the affidavits in that regard that indeed the Form 34As were issued to us, and it reflects what IEBC posted in the portal. The petitioners have not discharged that burden. They cannot now come back and say that they would want to challenge an election by failing to do that which they are required in law to do. What has happened? We've been told a lot of stories. We have 8 petitions, all trying to explain a lot of things. In my concluding remarks, I'll seek refuge in the Holy Book. In Proverbs 10:19, it tells us this: when words are many, sin is not absent, but he who holds his tongue is wise. They've had to use 8 petitions to say what they want to say. In those abundant words, then sin cannot be lost in that respect. It will be my humble prayer that the petitions before this honorable court be dismissed. I'll take this opportunity to welcome my learned senior, Professor Kithure Kindiki, to address you on the 6th issue. I'm most obliged.
May it please you, Chief Justice, Deputy Chief Justice, judges of the Supreme Court. My name is Kithure Kindiki for the first respondent. On 15th August 2022, a mob of people, including people holding senior positions as state officers, invaded the dais at the National Tallying Center of the presidential election at the Bomas of Kenya. In what I regard as a very, very orchestrated and clear attempt to interfere with the powers of the IBC to declare the presidential results following the verification and tallying of those results. As a result, chaos erupted. Several IBC commissioners, staff, and other people who were lawfully at the tallying center were seriously injured. To date, nobody has been asked even to write a statement on what happened on that day. Today, no investigations whatsoever have been made by the agencies of state which should be doing this. And to date, this heinous and frontal attack on our democracy remains unresolved, and the perpetrators are marauding around the country, and some of them are in this courtroom. Chief Justice, judges of the Supreme Court, the events on that fateful day mirror what, in our respectful view, took place on January 6, 2021, when a rowdy gang of violent protesters laid siege on Capitol building in Washington, D.C., in the United States of America, following the spectacular defeat of Donald Trump as president of that country in the 2020 election. The chronology of events of that day, the day our country was shamed in the eyes and in the presence of diplomats from all over the world, local and international press. The events are detailed in the affidavit of Mr. Wafula Chebukati, a gallant son of Kenya. That affidavit is before this court and is dated 26th August 2022, particularly paragraphs 58 to 75. This has been corroborated, my lords, my ladies, by the affidavit of Professor Abdi Gulie and Boya Mulu, the affidavit of Boya Mulu, both of which are before this court, and the relevant parts are paragraphs 17 to 37 and paragraphs 9 to 10, respectively. We respectively submit that the aforesaid activities at the National Tallying Center on 15th of August 2022, regrettably perpetuated by emissaries, agents, supporters, and sympathizers of the first petitioner, who is now before this court seeking redress. Those events and those activities amount to nothing short of a flagrant attempt to overthrow the constitution of our country to subvert the sovereign will of the people of Kenya, contrary to Article 1 of the Constitution. It is our view that those events alone constitute nothing but an attempt to establish a government unconstitutionally, contrary to Article 3(2) of the Constitution. And in our humble and respectful view, Chief Justice, my lords, my ladies, the events of that day are basically an attempted but failed coup d'etat. Unfortunately, the jurisdiction of this court under Article 140 does not allow it to punish these egregious acts of treason, but these events must inform the context in which the main petition and its offshoots ought to be adjudged. Curiously, the mentioned public officers, who include civilian state officers, including a cabinet secretary, senior military officials, including the Vice Chief of Defense Forces, Head of Police, Head of Intelligence, the Head of Public Service and Chief of Staff, which itself is an illegal position under our Constitution. All those people have not denied that they met the IEBC in plenary. The only thing they have told this court is that they went there to try and fast-track the declaration of results and not to do what Mr. Chebukati has told this court on oath, which is they went to go and try to have the first petitioner declared as president of the Republic, or otherwise force a runoff between him and my client. With tremendous respect, we ask this court to consider those acts as not only destructive to the independence of our institutions, but more particularly an affront on Article 249, 2A of the Constitution that describes the IBC and other such independent institutions in the following words, that they are independent, and I quote, and are not subject to direction or control of any person or authority. That includes, in our humble view, positive and negative interference, even if, for argument's sake, which is denied, those heads of very sensitive institutions walked into a plenary of the IBC to fast-track the declaration of result. Even that in itself is illegal and unconstitutional. What are the principles upon which the context we have laid should be adjudicated? Chief Justice, members of the Supreme Court, it is the submission of the first respondent that there are at least three immutable principles that run across most Commonwealth jurisdictions upon which this petition and its offshoots should be adjudged. One is the principle that no election shall be questioned or declared void because of errors, informalities, irregularities, or illegalities that have little or no bearing to the process and the result. This principle, Chief Justice, judges of the Supreme Court, this principle has endured for more than 150 years and was first initiated in the United Kingdom Ballot Act of 1872, Section 13. 2, that the burden of proof in election petitions lies on the person who seeks judicial invalidation of the election, not on the respondents. This principle has been cited in one of the authorities we have relied in and already highlighted by learned counsel's senior counsel Fred Ngatia, the case of John Mahama versus the Electoral Commission of the Republic of Ghana, 2021. Principle number 3, and this is specific to Kenya and the minor KI decision. The polling station is the true locus for the free exercise of the voters' will, and I'm shocked to see the petitioner and the latest pseudo petitioner, because when I listened to the Attorney General with due respect, I clearly thought that we are listening to another petition, especially on the issue of Article 138(3)(c), despite the assurances that he was not opposed to any petition, and I think he fell short of saying he's supporting the petitions. What are the specific principles in the interest of time? The first one, those are the 3 are the general principles. What are the specific principles? 1, and what I intend to demonstrate with these specific principles and the general principles is that the answer to the question on the issue number 5 is in the affirmative. That yes, the IBC carried out verification, tallying, declaration of results in compliance with 138(3)(c) and 138(10). These are the reasons. Number 1, the verification and tallying happened and was done by the chairperson, commissioners of IBC and the staff at the National Tallying Center in the presence of the candidates of the agents of the presidential candidates. And this is in the affidavit of William Ruto, paragraphs in support or in opposition of the petition, paragraphs 18 to 20, and the affidavit of Veronica Nduati, paragraphs 7 to 14. Number 2, the IBC complied because an interpretation to the effect that Article 138(3)(c) refers to the 7 commissioners, or a majority of them, is inaccurate and pedantic for this reason, that the Constitution and the Elections Act attributes to the Commission certain acts that are eventually done not by commissioners but by both the permanent and temporary staff of the IBC at the polling station, at the constituency returning the constituency tallying center and county tallying center, and I dare say even at the national tallying center. And that explains why, for example, the Constitution in Article 86(5) and 86(b) and 86(c) talks about the commission, but the work eventually is done by returning officers and in the first instance by the presiding officers. C, B, and C of Article 86 of the Constitution, which is not speaking about the National Assembly election or any other election, but the presidential election. The actions of returning officers, presiding officers, are deemed to have been done by the Commission, and that explains our argument. Number 3, an interpretation to the effect that Article 138(3)(c) refers to the 7 commissioners would lead to an absurdity in interpretation, because it is not humanly possible for the 7 men and women who are commissioners, however important they think they are, it is not humanly possible for them to tally results emanating from 46,229 polling stations across the country at the moment. Number 4, verification, tallying, and declaration was done because the right to franchise, Chief Justice, judges of the Supreme Court, this right in Article 38 of the Constitution cannot be subjected to the will, to the veto, or even to the ego of 7 men and 7 women. Even if, as they claim, they think they hold the constitutional veto to try and moderate or alter or balance the will of the people as expressed at the polling station and as received in original 39As. Number 5, verification, tallying, and declaration was done, even, I dare say, Chief Justice, judges of the Supreme Court, even for the 27 constituency results that were not verbalized. They were not announced verbally, but they were declared because they were posted in the website after chaos broke out at the National Tallying Center. I want to invite the court to consider, in interpreting whether what has been pleaded before this court in terms of what the commission did after that risk on life and limb happened. I want to plead and persuade this court to invoke, by way of analogy, 3 doctrines of law. The first one is the doctrine of frustration in the law of contract, where there are contractual obligations to be performed, but the contract is frustrated. Number 2, the doctrine of necessity in international law. And thirdly and finally, the doctrine of supervening impossibility, where there are legal obligations, but the party on whose those obligations accrue cannot perform them as a result of supervening impossibility. Chief Justice, my lords, my ladies, number 6, the IBC verified and tallied and declared all the results because none of the 46,229 from 34As have been impeached. Number 7, the IBC verified, tallied, and declared all the results because the tallying that happens at the National Tallying Center is basically clerical. And I think the commissioner should know none of them, including the chairman, has any role whatsoever that is significant other than just recording the clerical and arithmetical issues. And this is so, and this explains why, even when there are discrepancies between what was transmitted through electronic means and what comes as a physical form, the best that the chairperson as the returning officer can do is to note the errors in the error form, and only this court can actually interrogate and decide on the fate of those discrepancies. Number 8, verification, tallying, and declaration was done pursuant to 138.3C and 138.10 because an interpretation in the opposite direction would lead to a constitutional crisis where commissioners would think they have a role to veto and moderate the expression of the will of the people of Kenya in the vote, can decide to form factions and have their own candidates, declare their own results, which they have verified in quote and tallied in quotes. Finally, Section 10, 11, and 11A of the Elections Act envisage the commission to include the secretariats and staff, and therefore verification was done according to the affidavit of William Ruto, the affidavit of Veronica Duarte. The tallying was done in the presence of agents at the National Tallying Center. With tremendous respect, I would like to conclude by submitting that this court should find that a petitioner whose agents and supporters are engaged in a kind of behavior that is now of public notoriety, and I invite the court, over and above what is pleaded, to take judicial notice of of the events of that day. A petitioner whose supporters, sympathizers, and agents engaged in those kind of things should not be anywhere near the hallowed ground of a Supreme Court of the Republic of Kenya, trying to seek relief, among them a relief under Section 80A, that they be declared winners of an election that they didn't win. We submit that the mob that swelled our image, the image of our nation, including the conductors of the orchestra, are now before this court shouting loudest that we must release Barabbas. This court should stop Barabbas and his mob from benefiting from their own malfeasance. We pray that all the petitions, including the submissions by the Attorney General, particularly on this issue of Article 138, those petitions be struck out with costs. I respectfully and humbly submit. And now, with the permission of the Chief Justice and the court, I yield the microphone to Senior Counsel Kirago Kimani to address the court and submit on issue number 7 and number 8. I thank you.
May it please the court, I will not, my name is Kirago Kimani, I will not address you on issue number 7. I believe it's been adequately dealt with by the IEBC and its chairman. I will address you on only issue number 8, and I will try and avoid rehashing what the IEBC and its chairman addressed you, in my humble view, very effectively. This is simply looking at the test that has to be met by the petitioners in order to determine whether the election should be nullified. And you've settled this as far back as 2013 in Raila petition number 1, or it was petition number 5 actually, but it was the first election petition under the new constitutional dispensation, and repeated this in 2017. The long and short of it is that the question you must ask is whether it has been demonstrated that the election was conducted so badly that it was not substantially in accordance with the law relating to elections, in this case the Elections Act in Articles 81 and 86. The burden is squarely on the petitioners to demonstrate indeed this is the case. The word used by Section 83 is magnitude, of such magnitude, really. It is not enough to demonstrate there were irregularities. It is not enough to show that there was a breach of the law. But it has to go beyond that to show that it affected the outcome. Has that been done? I'm not going to take you through the multiple allegations of irregularities and breaches of the law, but I've tried to look at these petitions, the 7 surviving ones, and I think there are approximately 46 allegations of breaches of the law and irregularities. This is a classic case of throwing everything other than the kitchen sink at your opponent. There are a lot of overlaps, but by and large, everything that could be said has been said,
And I'll come back to this. The kitchen sink did show up a little later. But I don't want to walk you through all of these allegations. Let's just look at a few of these. It's alleged that there has been an infiltration of the IEBC system. I'm not going to rehash what Mr. Mahat Somane so well explained to you. But I think these petitions are an invitation to this court to lay down the law. It's one of your jobs. That it's not enough to show up here and throw things out there and say, we hope some of it will stick. No. People must be held to account. They must be told, show us where the evidence is. And indeed, this is what Rule 9 of the Supreme Court presidential election rules requires, that when a petitioner presents a petition, they will also furnish evidence. Has that been done in my humble submission? No. This evidence of infiltration, in the first instance, was put in various affidavits. John Mark Githongo, you've been told about how he recanted this. There were allegations in various other affidavits. And what happened then? There was a robust response from the referee, the IEBC, and the first respondent. And then what do we have? We have a second burst of alleged evidence in the nature of an affidavit by George Njoroge. And we are not even, we did want to start playing games by saying this evidence should have come at the start, as the rules require. So this case keeps being panel beaten as we move along. And it's not just petition number 5 where this happens. It has happened in another petition where you were addressed about 291 constituencies and not 290. I believe there was a question from a judge directed at this, because there's a short answer to that, but the question was not directed at me. But that wasn't even pleaded. So what we have is a situation where you keep being told new things as we move along. There's another allegation that the IEBC was so dysfunctional that you couldn't possibly have an election that complies with the dictates of Article 86. And we are told that this started even before. Now the question is, why wasn't a challenge made to the mandate or to this institution before the elections? An Article 140 petition is very narrow. It concerns the results and nothing more. This petition has been turned, or these petitions, by many of the petitions, has been converted into an attack on the second, on the chairman or the chairperson of the IEBC. It's not the function of the court to look at the conduct of the chairperson with a view to taking action. You were addressed in great detail as to why or how he has affected the last 2-3 elections. So what were we waiting for when Article 251 tells us what to do? The Leadership and the Integrity Act tells us what to do. Let me very quickly, without going into any more of these 46 alleged irregularities and breaches of the law, just try and illustrate just how bad these petitions are, or how lacking in substance they are. And I will, Mr. Mahat Somane, my land friend Mr. Mahat Somane has spoken to this, but I want to illustrate by showing you just a little bit about what was contained in the affidavit of Arnold Odinga, Ochieng Odinga. And if I could just, if it could be put up, I want us to look at what has been presented before this court. And it's quite quite easy to come to this court and say, listen, somewhere between the people expressing their will and the declaration of the results, there has been some tampering. Let's look at what they say. Paragraphs 81 to 91 of the affidavit of Arnold Ochieng Odinga says that there was willful, deliberate, and criminal tampering of certain results, and they've identified 41 forms. What I suspect they did not expect to happen is that the IEBC would respond to just about each and every one of these forms. Let's look at just one sample. And before we do that, what are we trying to achieve? We'll look at a Form 34A from the IEBC portal. We will look at a Form 34A delivered by IEBC to the court. We will look at an affidavit from a presiding officer, and we'll look at an affidavit from an Azimio agent, and we'll look at a Form 34A provided by a UDA agent. The affidavit of the IEBC presiding officer is not part of the slides, but we will be able to compare these documents. If we could skip this next slide so that we move quickly. Let's skip that slide, please. Now the question is where the petitioner's fraudulent 34, or allegedly fraudulent 34A came from, and I'll return to that at the end. Let's just look at Kibagare polling station. The next slide, please. If you look at the signatures, one of the signatures is an ODM agent, Mr. Eric Atuma. Now the petitioner in petition number 5 has filed many affidavits in response to the respondents, including the first respondent. They have not responded to this. They have not challenged this, but they put it out there as an illustration of what games were played either by the referee or in concert with the first respondent. So the first thing you note is the signatures of the two agents. The next thing I'd invite you to look at is what the votes were according to the IEBC portal. And Malan from Mahat Somane invited you. The portal is up and running. Check this. What was the total of votes cast, or what was it for the two candidates in Kibagare polling station, stream 2 of 7? Raila Amolo Odinga, 244. Mr. William Samoei Ruto, 114. Let's go to the next slide. If you look at the affidavit of the presiding officer, he's produced a similar Form 34A. It says it gives the same outcome. The next slide. The UDA agent, same 244 and 114. Then you have the next slide, the Azimio agent, again 224, 114. The next slide is the affidavit of their own agent. He says, what is in Mr. Odinga's affidavit is not what I submitted to the party. They decide, we're not going to respond to that. But we expect the court somehow to determine that there were fraudulent Form 34As. Is this right? Let's go to the next slide. What is in Mr. Odinga's affidavit? Look at the last column. It says, for Raila Amolo Odinga, 244 votes. For Mr. William Samoei Ruto, 38. What happened to the other votes? Something is fundamentally wrong. And this is just one document. We have filed other affidavits which illustrate what happened here. Let's look at the next slide. The law requires the IEBC to deliver certain forms. I'd invite the court to look at the form for this particular location, this particular polling station, and see whether what has been set out in Mr. Odinga's affidavit is correct. Let's go to the last slide. What then are we telling you? The numbers between the IEBC portal, the IEBC presiding officer, the UDA agent, the Azimio agent, and the Form 34A from Bomas are all aligned. Question we must ask is, where did the form that is presented by Mr. Odinga come from? Arnold Odinga, so that we do not mix up names. I think this must be what the late Isa Juma of Super Wanyika had in mind when he penned the words, sisi twajua anafanya biashara, lakini biashara anajua mwenyewe. Only Mr. Odinga can tell us where this came from. And the other 40, they are not part of what was actually the product of the people expressing their will. So, in a nutshell, even without trying to demonstrate to you how the other irregularities and alleged infringements of the law have not affected the law, the petitioners fall far short of what is expected. But let me look at one or two things, because one of the things that has really featured a lot, and I'm going to try and avoid rehashing what has been said by the other lawyers, is that the commissioners have a significant role. That what 138(3)(c) means is that the commissioners, the 7 men and women, have to be involved in the exercise that is to be undertaken. With respect, this submission is skewed by a failure to interpret the Constitution correctly. I think it's long been settled that the Constitution, the interpretation of the Constitution, looks both at the text and the context. And what has happened here is that the petitioners have decided we will stick with the text. And even that they stretch. They say the IEBC, the commission, means there's 7 of them. With respect, that's an invitation to the Supreme Court to, through the back door, overturn what Maina Kiai said, which is that you start at the lowest level and cascade things, but it is not the job of 7 men and women. Let's look at the 7 commissioners a little more, and in particular the 4 who it is said should lead to the conclusion that the election was not conducted in accordance with the Constitution. They were on board with every other commissioner. They spoke with one voice until about 3 p.m. on the 15th of August. Then they had their Damascus moment and made it to Serena. They changed their position. If you look at the affidavit of Samuel Gidai, look at the clips of the 4 commissioners announcing the results. But you were told here yesterday they were being given pieces of paper to read out numbers. Is this believable? But we were told by another speaker, another advocate, that these men and women were vetted by the National Assembly. They are therefore very serious citizens who correctly undertake a very important function, the running of elections. But they say they did not participate in this. In determining who to believe, look at the context. Look at the whole series of events from when the nomination took place, when the ballot papers were printed, including the supervision that they undertook, and determine whether these 4 commissioners are to be believed. Mr. Njenga, for I think the 7th respondent, argues they are here not to support either side, but to discharge their duty under the Constitution. But they did file a response. They started off by filing affidavits to set out the evidence. There's no property in a witness. They didn't stop there. On the 26th of August, they decided, we will appoint another lawyer on behalf of the IEBC who is in effect going to admit the alleged infringements. This is where you apply the duck test. If it looks like a duck, if it swims like a duck, if it quacks like a duck, it must be a duck. They are saying we are here to show you we are independent. Are they? With respect, their conduct demonstrates otherwise. In a word, it is my humble submission that the petitioners have not demonstrated there were any irregularities or illegalities. Forget the magnitude. They really haven't demonstrated any. I'd urge you to dismiss these petitions. Ordinarily in these sort of cases, and I'm not telling you what to do one way or the other, because of the nature of the matters, the parties are asked to bear their own costs. But again, what happens in 5 years if people can come in 8 petitions, 1 was struck out, and say whatever they wish to say without offering evidence? I think there was some advocate who said yesterday, we're going to have 200 petitions in 5 years. Why? Because nothing, there are no consequences. We can all come here and be on television, there are no consequences. So what are we asking of you? We are asking you to give us back our country. Determine that there were no infringements, that we had a proper election. We have been in election mode for so long. The only thing that creates wealth is actually working. And this is not work. With respect, the tens of thousands, men and women who preside over elections are teachers and farmers and artisans and you name it. We're being asked to make them come back to work in a few months, or in 60 days to be precise. There is no justification for that. The order that should commend itself to you is to dismiss these petitions because they fall far short of what is required. Those are my submissions. Mr. Kioko Kilukumi will now address you on the 9th issue.
Your Ladyship, the Chief Justice, Deputy Chief Justice, Justices of the Supreme Court, my name is Kioko Kilukumi, and I appear for the first respondent. Our team leader has asked me to deal with the issue raised by Mr. George Oraro, Senior Counsel, in regard to the affidavits filed by Joseph Kinyua and Kennedy Keara. This court did direct that the first respondent is at liberty to come and place the facts he has before this court, not through affidavits, but we've been given the permission to place the facts because time was running and the court directed we have that time. The first respondent wishes to place it on record that under Article 240 of the Kenya Constitution, there is established a National Security Council. And he is, by virtue of being the substantive deputy president, is entitled to sit in that council. He says, in the last 5 years, the council has not sat and discussed anything to do with elections. He further says that matters of election are vested in an independent body, and that independent body is the IEBC. That is the body that has the constitutional mandate to deal with elections. He further says, during that period of 5 years, the Council has not asked the National Security Advisory Committee to deal with IEBC on any matter relating to elections. And he takes the position that the visit by members of the National Security Advisory Committee to IEBC at the Tallying Center was an interference with the functions of IEBC. And it was calculated, given the membership who was sent there, it was designed and calculated to intimidate the chair of the IEBC and to seek to influence the outcome of the election. We ask the court to note that these affidavits were provoked by what Mr. Chebukati said in his affidavit sworn on the 26th of August, 2022. From paragraphs 55 to paragraph 75, he has given a subheading and he calls it an attempt to subvert the will of the people. And we invite the court to consider those paragraphs and to see which party is telling you the truth. We wish to refer you specifically to paragraph 66 in that affidavit. And it is an important averment, an important deposition in that affidavit. He says, Mr. Chebukati, when he was at the National Tallying Center, members of the National Security Advisory Committee visited him, and he sat with them after 2 p.m. It is important to contextualize the time. We are talking of the 15th of August. Bomas of Kenya, there is a meeting, and this meeting is attended by all the commissioners. All the 7 commissioners are there. The fact of that meeting is not disputed, or the affidavits filed regarding that matter make critical admissions. The first admission is that indeed Joseph Kinyua telephoned Chebukati and told him, I'm sending my members to you. That's an admission. The second admission is that all the commissioners, and these are the affidavits from Mr. Joseph Kinyua and Mr. Kenneth Kiara, all the commissioners were present. It is past 2 p.m. It doesn't say how long this meeting took. The country had been put on notice.
Yani ina maana nchi ama mji.
Yes, welcome to Mutembei.
For the afternoon session of the further hearing of the presidential election petition number 5, consolidated with E002, E001, E002, E003, E004, E007, and E008 of 2022, Raila Odinga and 7 others, versus William Ruto and others. The Honorable Chief Justice, President of the Supreme Court, is presiding.
Yes. My lady, the Chief Justice, the Deputy Chief Justice, my lady, my lords, in this matter, I appear with Mr. Emmanuel Bitter and Radhika Arora for the Attorney General. From the outside,
Gone bad towards the end. You will ask yourselves, does somebody disown results which he doesn't know? Do you believe these commissioners did not know what the outcome has been? We submit they knew the result, and that is why they were disowning it. We also ask the court to consider these 4 commissioners, apart from the press they did on 15th of September, they again did it on 16th, the following day, 16th of August. Was it a coincidence that again our TV screens were split into 2? You see the 4 commissioners, and you see the first petitioner, and they are speaking, the language they are talking, the words they are using are strikingly similar. Is it a coincidence? These are matters we invite the court to consider in trying to ask itself, which account do we believe? I urge this court to believe the account given by the 3 commissioners. The will of the people was just about to be subverted, and the attempt was unsuccessful because the 3 commissioners stood by their oath of office and faithfully executed what was expected of them by the Constitution of Kenya. This split between the commission, the court has asked posed questions. When did it happen? Once you look at the affidavit of Chebukati and the timing, at past 2, they are in a meeting, and by 4, they are in Serena Hotel, you will come to the inescapable conclusion that the division in IEBC was caused by the National Security and Advisory Committee. And indeed, they hijacked the 4. That is why the 4 would approach this court for the very first time in the history of this country, approach the court to seek nullification of an election that they superintended, and that they said they conducted a very good election. We ask the court to take into account that there appears to have been a mistaken impression that presidential elections are determined by commissioners. Anybody who wants to become the president of Kenya must have in his corner the Kenyan electorate. And that voter who turns up in the polling station, not the one who stays away. And if you convince that voter who turns out and you get the majority of votes, you become the president. 7 commissioners cannot make you the president. 4 commissioners cannot make you the president. Who makes the decision as to who becomes the president of the Republic of Kenya? It is our humble submission. It is not the commission. It is not any of the commissioners. It is the electorate. It is the people of Kenya. And therefore, this narrative that we are the majority, we needed to sit down and make a decision, that decision as to who becomes the president of Kenya does not lie with the commission. Theirs is to midwife the process, and that is all they can do. We wish to submit that the first respondent won these elections fair and square. You've had the submissions and the evidence that has been presented by the midwife, IEBC, and they have made it absolutely clear that this election was conducted in accordance with the Constitution. It was computed in accordance with the Constitution, and they have a very clear winner as to who obtained the highest number of votes and made all the requirements required by Article 138(4). For that reason, we ask this court to consider that this petition is the consolidated petition are founded, they are all anchored on fiction. They are all anchored in forgeries. They are anchored in fraud. That clearly tells you these petitions are built on sinking sand, and for that reason, they must fail. I wish to ask the court amply to reflect on the ruling of King Solomon. Just like King Solomon before you, you have 2 gentlemen here, each one claiming a baby. The baby they are claiming is the outcome of the 2022 election petition. During the days of Solomon, there was no DNA, and therefore he could not easily make up a decision as to whose baby is this. Today, you don't have mothers competing for this baby. You have 2 gentlemen, each one of them claiming the baby. What does the petitioner ask you to do? Just like the days of Solomon, he is telling you, give me the baby is mine. And then he goes on to tell you, if you cannot give me the baby, slice it into 2. We can call this baby Victoria. We can call this baby Victor. But the more gender neutral term, let's call this baby Victory. Baby Victory has a clear DNA. Baby Victory, his DNA is captured in the original Forms 34A. His DNA is captured also in Forms 34B. That baby belongs to Honorable William Samoei Ruto. Give him his baby. Don't divide the baby. The petitioner here is telling you, you either give me the baby or cut the baby into 2. Nullify the election. Solomon used that indicia to know who was the true mother of this child, because no mother would want a baby chopped into 2. And so by the petitioner coming to tell you here, if you don't give me the baby, slice the baby into 2, you already know whose baby the victory of 2022 presidential election is. I urge the court to give the baby to the legitimate and lawful father who is Honorable William Samoei Ruto. Thank you very much. I'm sorry, Your Ladyship, the Chief Justice, Justices of the Supreme Court, I wanted to yield the floor to my senior friend, Gatia, Senior Counsel. Thank you.
Madam Chief Justice, my duty is to make closing submissions as I also deal with the last issue. What are the appropriate reliefs? Yes. Oh. I start by apologizing. I left out two members of my team, two lawyers who have worked very hard, Rose Thiongo and Ham Langat, Mr. Ham Langat. I think in fairness, it's good I place them on record. They have done a sterling performance, and this is part of the mentorship we should do. Madam Chief Justice, let me also start by apologizing that I did not place on record the fact that we did file written submissions on 27th August this year, and we rely on those written submissions. We took lots of time to actually develop almost a treatise on the origin of Election Act. We went to 1870 in England, where we found the first codification of the Election Act, and the subsequent development and the hesitation by apex courts in not disturbing electoral victory. I would request you, in the fullness of time, please look at it. I should also, in fairness, indicate that the authority I referred to from Ghana decided last year the Mahana decision is authority number 5 in our list of authorities. And again, this, Madam Chief Justice, let me say this because I ought to acknowledge it. Judges in Ghana quoted with approval one of your judges. Writing of this apex court are now being quoted with approval in the continent of Africa. And if I could say so, this is also because of the very vibrant advocacy by my learned friends. So if we could participate in enriching the jurisprudence in Kenya and Africa, so be it. I now go to a very brief response overview. You have a petition before you by Julia, I think is now number 7, the one about special group of people, 500,000, who allegedly were denied the right to vote. And this is what we call, not now fiction, but theory, pleading or drafting a petition on the basis of abstract principles. The so-called 500 people, not a single one of them have filed an affidavit to say because they were working for IEBC or were working in any hospital, they were deprived an opportunity to vote. In other words, this court must also try to establish some rules of engagement. Are we going to be holding this country at ransom as we process these petitions, which are, to say in very modest terms, very frivolous? One comes and says 500 people are denied an opportunity to vote, and then he gets away with it. Juria is a very good example of what states in America have now resolved to do. They do punish a pleader who files a pleading with the full knowledge that what is being pleaded is incorrect. I go to another area of so-called suppression of votes. This is another constant denominator, that is suppression of vote, because one level of votes was not held. And the question is, where is the empirical evidence? Empirical evidence that because there is no voting for a senator, then the turnout for votes for the presidency are suppressed, and suppressed in relation to only one candidate, not both candidates. My learned friends have talked about what yesterday was being called dysfunctional IEBC. It is not dysfunctional IEBC. It was a functional IEBC until 3 p.m. on 15th. On 15th August, towards 3 p.m., some commissioners were hijacked with their free will, and they opted to walk out from their brothers and sisters. There is a point that concerns me as a regular practitioner in this court, in these electoral cycles. And this is this. For how long are we going to allow our political class to advance self-interest, and to hold this country in perpetuity of uncertainty? That is something I think, Madam CJ, you now have an opportunity under Section 3 of your Act. The first fundamental in Section 3 is your true north, is supremacy of the Constitution. Your true north being the supremacy of the Constitution, and then other factor to consider is that this court is required to help us develop even a political path for this country. Those two becomes very important aids in how we deal with the political class. I'll come to that towards the end. But it is something of concern, because unless it is captured early, I do not see great hope in the way we are proceeding. Madam CJ, first and second respondents are very ordinary Kenyans, very ordinary, humble origin, and this is a country I always have thought is a country of hope and opportunity. Hope and opportunity for each and every Kenyan. A child from humble origin ought to aspire one day to be a Chief Justice of this country. A child of very humble origin ought to aspire to be a top surgeon in this country. I say all this because, in all fairness, unless we show hope and opportunity to all, then we'll be missing an important aspect of our growth. There were questions that were posed to my learned friends. Since I won't have another opportunity, allow me just a few minutes to deal with a few of them. I'll start with the first question about rejected votes. It was posed by one of the judges. Rejected votes is a point we litigated in Raila 1, that's in 2013, not as a side issue, but it was the subject of a petition. In 2013, there was a petition dealing with nothing but rejected votes. Rejected votes, Madam CJ, can be the third candidate. It's very easy for rejected votes to be the third candidate. And in 2013 at Bomas, where I had the pleasure and privilege of being the chief agent for the candidate, it became quite obvious that rejected candidates will be the third candidate in that contest. And if they were to be factored, then the whole purpose of rejected votes is to bring down the victory of the candidate who would otherwise have won. So it is a point we litigated at length. Some of my learned friends, my seniors, we litigated at length, and this court held and found that what is to be considered are the valid votes cast. So in my submission, that is a point that has been dealt with. It was again repeated by the court in Ghana. Last year, they rejected the notion of considering rejected votes in the final tally. As a matter of fact, now that I remember, I'm getting a little older, I was clearer then in 2013, it is a misconception to call them rejected votes. It is actually rejected ballot, because a vote is that which is valid, which expresses a choice. So those so-called rejected votes are actually rejected ballot papers. The same holds true for spoiled ballots, and the same holds true for stray ballots. As fate would have it, you will not even know about the stray ballots at the point that the tallying is going on. I associate myself with the submissions made by my learned friends, IEBC. They are the ones who conducted the election. It is not within our place to supplement their submissions. We wish to associate ourselves with the submissions, particularly as regards how the election was conducted. I come to what is the elephant in the room, to quote Tata, who I have never quoted before. What is the way forward? On the one hand, you are being requested by many of my learned friends, actually all of them in unison. It's the first time I have seen so many lawyers making the same request: nullification of the election. Almost reminds me of the trial of Christ. Crucify him, nullify the election. After nullification of the election, no solution is provided. But all they request is nullify the election. As you consider the rival position, I will request you to consider the following. In the event you nullify the election, you will effectively be rejecting the substantive truth that the majority of voters in this country express their free choice. While considering that plea of nullify the election, we shall be acceding to a very dangerous trend in this country, that presidential elections are to be held, and if I'm aggrieved, not because of any error, but I want to hold the country at ransom, I will walk to the Supreme Court and the election will be nullified. While considering that request, please also consider the far-reaching consequences that we all participated, we all experienced in 2017. That is on the one hand. On the other hand, the first and second respondent come to you with a request. The request is voters did exercise their right. Hold them to that covenant. The covenant is they made a choice. Do allow the country to now move forward. We cannot and cannot afford election mode in perpetuity. I think I have said enough to demonstrate where my mind is. It is time for finality and stability. Finality and stability. In doing so, Madam Chief Justice, you'll be sending yet another signal to the political class. And here I am not finger pointing anybody. As I said in 2013, what I say for this client is what I'll say for the next client who is in that class. The country does not belong to them. This country belongs to all of us. And since the country belongs to all of us, no person should consider that there is an entitlement. Considering that there is an entitlement is to engage in an illusion. That illusion ought to be replaced by reality. Reality is that it is voters who make their choice. And once voters have made their choice, let us inculcate a culture that my brothers and sisters on this side are now used to. We walk to our court, we may think the law is on our side, we may think we are entitled to victory, but we accept the verdict of the court because much as we may think we are eloquent litigators, the final word is always with the court. With those comments, may I very humbly and respectfully request this court to let this cycle come to an end so that we can get back to our business, the business of developing our country. With those remarks, I would wish to close and to donate the 30 minutes to the court because we are patriotic enough to know that it's not really in the interest of this country to engage this never-ending circle of litigation. Thank you very much. Unless you have any questions for us, that's the end of our case.
Thank you very much. We appreciate the donation and the appreciation that this time that we have is very, very tight, because for us, the work actually begins when we finish all this. The bench will have questions to those submissions that have been named today, but I think there are a few who might also want to add some questions to the petitioners, especially the commissioners who are supporting the petition. I think what we want to do now is take a short health break, resume at 5:20, and this is going to be the order of business. We will ask questions to the petitioners and the commissioners who are supporting the petition. They will still respond tomorrow when they are doing their responses. But for the respondents, the first and the other respondents, we will request them to answer today the questions. We will also share the report on the scrutiny and the orders that were issued by this court on the discovery issues, the application by the petitioners. I think it was the first petitioner Kerif Karifa, and the youth advocacy, the hand applications for scrutiny. That report is being finalized. It will be shared. And tomorrow we will give you an opportunity to respond to the report. So we will adjourn for just 20 minutes.
Good morning and a very welcome to the Supreme Court of Kenya for the further hearing of the presidential petition number E005 of 2022. As consolidated with E001, E002, E003, E004, E007, and E008, Raila Amolo Odinga and 7 others versus William Ruto and others.
A very good morning to everybody, ladies and gentlemen. Welcome to today's proceedings. I'm looking at the consolidated petition. We had hoped to hear IMBC first. IMBC and the chairman and the other 2 commissioners. Just a minute, Fro. It looks like...
Your Ladyship, members of the court, before my learned friend takes the position, perhaps with the permission of the court and with the permission of my senior James Orengo, I would like to bring certain concerns of the first and second petitioners to the court regarding the ongoing scrutiny. With every passing second, of course, time is lost. It is still with regard to what we consider the non-compliance with order number 2 regarding access to the servers. I wish to report, as of this morning, nothing has changed. IEBC continue to refuse to provide the forensic image of all 8 servers. Your Ladyship, my lords, the 8, we've been using the word servers in plural, but I would like to refer to the affidavit of Mr. George Njoroge at page 11, which gives the name or identity of the 8 servers. Page 11 of the forensic report by George Njoroge, which gives the particulars of all 8 servers. Of those 8 servers, IBC are providing only limited access to server number 5. I have mentioned with every passing second, an opportunity for the court and ourselves is being lost. With the limited access provided yesterday to server number 5, our team were able to observe a large number of deletions. So we suspect and we are concerned that the delay on the part of IBC is to delete vital data, and when finally time runs out, not to provide the information that we require or provide logs that have no use to anybody. So we are requesting that the court direct further that access, forensic access, be provided to all 8 servers. together with copies of logs for all 8 servers. I am further advised that the question of the forensic imaging is the one that takes time. It takes hours. It takes hours. So that needs to be given, that direction or that order needs to be given right away. In the alternative, perhaps this is the moment when the court considers extending time so that IEBC do not do what they are good at doing, not providing or providing when it is too late. So that is all I wish to mention at this stage, and I would like that the court addresses it before we start the day. Thank you.
Thank Mr. Gumbo.
Question?
Good morning, my lady, my lords and my ladies. My name is Eric Gumbo, once again. Let me start from saying that I think I'm quite perturbed by remarks from my learned senior counsel when he says that IEBC is not complying with the court order. That certainly is an inaccurate reporting. I think the most important thing would be to get an accurate and objective position in relation to this matter. It cannot be, because we've seen tweets, we've seen a lot of social media activity in the night, which is not accurate. And I think whatever was happening was that report was meant to be for this court. It wasn't meant to be discussed in social media. And I think there was already guidance on that. So even this narrative that is being propagated certainly is not for this court. And I think we take exception to that. But back to the critical issue, yesterday we did give an indication that whereas the order of the court was that the IEBC was to give a supervised access to the servers, that was then interpreted by the applicants to mean that they would get a copy of the whole server. We then expressed concerns with what that would mean, and we asked that the court then gives guidance so that as we proceed, there's clarity. That is really what we had hoped that we'd get this morning to enable us resolve the matter. Certainly, it is not to take away the server from IEBC. I'm most obliged.
Thank you very much. On behalf of the court, may I say this? That issue was discussed by the full court this morning. We received a full report from our technical team that was leading the exercise at IEBC, and we have been informed that the process of compliance was completed last night. In fact, when we were here and Mr. Paul Mwangi was saying that the process had stalled, we received a message soon thereafter from the team to say the process is heading to completion. So that as far as our team is concerned, the process at the IEBC is finished. The process at Forodha House is coming to an end shortly. And so the court has then asked me to express, in anticipation of this question, that should there be any issues left unattended to or any concerns that parties have, let those issues be addressed when you receive the report later this morning. You can address the question of what you're calling non-compliance. You can address the question of what servers you think were not accessed. You can address the question of the information that you received, your agents were there, and you, IEBC, can respond to say what are your answers to the complaints by the petitioner's advocates, and then the court will ultimately determine what is the import of all the things you're saying. That report was meant for the court to make a decision on the issues you raised. So as far as we are concerned, that matter is spent. Please address us tomorrow substantively on each of the questions once you see the report, which is actually being prepared right now. That's all I have been informed to tell you by the court. I thank you, CJ. I thank you, Counsel.
Madam Chief Justice and the Honorable...
Sorry, Senior Counsel. I think, CJ, allow me to say this. As much as possible, let us do matters within this court. I think the debate out there is convoluting matters. And when we see documents being circulated outside the court, it only just inflames the public. Let us please keep matters right here. Let's manage our issues right here. until we finish. That's all I'm saying in answer to Mr. Gumbo's concerns. But as far as the court is concerned, we're on top of things. I thank you.
Madam Chief Justice and the honorable learned members of the court, I am Githu Muigai, and I appear for the IEBC for its chairman, Wafula Chebukati, and for Commissioner Professor Abdi Yakub Gulei and Boya Molu. I am assisted in the defense of this gentleman and the institution by Kamau Karori, Senior Counsel, Abdikadir Hussein Mohammed, Senior Counsel, Mr. Eric Gumbo, Mr. Mahat Somane, Dr. William Mutumbwa, and Mr. Peter Wanyama. I would like to request you, Madam Chief Justice, if you could kindly confirm that our combined team has 4 hours, our 3 hours, plus the 1 hour between the 2 commissioners who are represented by our team.
That is not correct, Prof. The 2 commissioners have 30 minutes. You remember the other 4 commissioners and 15 minutes each. They are 1 hour among the 4 of them. So you have 3.5 hours.
I'm guided by you, my lady, and I have changed that to 3.5 hours. Thank you. We have filed before you a wide range of documentation, which in our very humble view is very, very comprehensive. We draw your attention, honorable members of the court, the responses on behalf of the chairperson and IEBC, the affidavit of Wafula Chebukati, the affidavit of Marjan Hussein Marjan, the CEO, the affidavit of Professor Abdu Yakub Gulei, the affidavit of Commissioner Moya Mulu, the affidavit of Martin Washira Nyaga, the database administrator, the affidavit of Michael Uma, the director of ICT, the affidavit of Moses Lendema Senkuli, the acting director of voter registration, and affidavits filed by presiding officers and residing officers of the contested polling stations and constituencies. Let me start, my lady Chief Justice, by observing the peculiar nature of the proceedings before this court. That is to say, these are proceedings that are based on affidavit evidence. And we all appreciate the limitations that that has. That we have persons who have sworn affidavits who are not available to court to be cross-examined on their allegations. And some of the allegations we have had, as we shall demonstrate in the course of our submissions, are outrageous, to say the least. My lords and ladies, we have been here before you. Some of us have had the great privilege of being here before you in 2013, in 2017, twice. And this honorable court must take credit, I think, unparalleled in anywhere in the Commonwealth, in my humble learning of the subject, in helping to clarify how the electoral process in Kenya should be conducted. And we submit that the clarifications that this court has given since 2013 have enriched the conduct of the electoral process. And it is my first submission that the IEBC and its chairman conducted the 9th August 2022 presidential elections strictly in compliance with the guidelines that this court has given. My lords, Since the annulment of the presidential election in 2017, IEBC overhauled its entire electoral process procedures to align those procedures with the guidelines that my lords had given. Your decision in the minor care, the decision of the Court of Appeal in the minor care case set out the guidelines for the protection of the ballot at the polling station, the transmission, tallying, and declaration of presidential results. We have abided by that decision. Your decision, my lords, in Raila Odinga versus IEBC petition number 1 of 2017 rendered even more detailed clarifications on the procedure. The decision in the National Super Alliance versus the Independent Commission gave further clarification as to the very controversial issue up to that time of how to handle complementary voting. And again, we learned from that and we have used that in this election. Since 2017, over the last 5 years, the IEBC undertook post-election evaluation. It reviewed its strategic plan. It developed an elections operations plan, a boundaries review operations plan, continuous registration of voters, and several other measures that flowed from the guidance that this court had given. My ladies and my lords, in the cases that have brought us before you previously, we had numerous arguments about jurisprudence. What does the law mean? What do the regulations mean? What does the Act say? The petition now before you has absolutely nothing to do with any legal lacuna, because you have spoken so loudly on that subject previously. Although my learned friend, Mr. Karori, will be reiterating what you have said as regards Article 183, your own thoughts on the subject are very well laid out in your previous judgment. This, my lord, is a petition about facts. It's a petition about what happened. What happened, when, where, with what consequences. And therefore, ultimately, notwithstanding the very lucid and learned and honest arguments by my very learned friends to my right, this petition is about numbers. It is ultimately about numbers. The petitioners have tried to argue every other point except numbers. I will be demonstrating to you, my lady, my lords, in a short while, that we conducted a proper, fair, constitutional, legal, impartial election. My learned friend, Mr. Kamau Karori, will follow me, and he will get back to the parameters that you have set. Mr. Eric Gumbo will talk about, that's Mr. Karori will answer, and this is very important, my lords. We do not want to waste our 3 hours perambulating around every conceivable issue in this petition. We will be answering the questions you asked us. Mr. Kamau Karori will answer question 4, 6, and 8. And that will be a submission about the electoral process. My learned colleague, Eric Gumbo, will answer question 1, 2, and 3, and that's about the technology. My learned friend, Mr. Mahat Somane, will answer question 4, 3, 4, 5, 7, and 8. And I do not want to belittle the rest of our effort, but that is the man who will explain that numbers don't lie, that numbers speak for themselves. Mr. Abdikadir Mohammed, Senior Counsel, will address you on the burden of proof and the standard of proof and whether the reliefs sought by the petitioners can be granted in this matter. If we still have time, as we hope we shall, Dr. Mutumbwa and Peter Wanyama will address you on this issue that seems to be in the fridges, but in our view, totally inconsequential, of the KPMG report and the alleged problems with the voter registrar. Let me start by saying, my lords, you have been urged by several counsel who have spoken before me to find that this election was irretrievably flawed. That from the word go, one counsel said, and I quote, everything that could go wrong went wrong. If that be true, and we deny that that is true, then it would mean that everything from voter registration, voter education, procurement, nomination, voting, counting, tallying, verification, and declaration was totally flawed. What would be the consequence of that? First of all, and I say this with the most tremendous respect, first of all, you have been addressed by counsel of great eminence, including my learned senior James Orengo, my learned junior Professor Tom Ojienda. In this court, my lords, as we sit here this morning, there are no less than 3 governors addressing you elected under this election. There are no less than 4 senators elected under this election. And there are no less than 4 members of parliament elected under this election. When, my lords, it is not in my place to suggest the questions you should put to counsel, but I would plead with you to put that question to counsel when they return to the podium. Are they happy with their own election? If they are, how then is it that this election is irredeemably flawed? I suggest with tremendous respect that that is the use of hyperbole. This election was conducted as most international observers observed. It was the fairest. All observers came back with one conclusion. This was an open, transparent election. Was it a perfect election? No, because there is nothing like a perfect election. This is an election conducted by human beings, and there are human errors within the electoral process. Were the few errors that are admitted by IEBC of a magnitude to allow this court to set aside the election? It is our humble submission that the answer is no. It has not been demonstrated, and my learned friend, Mr. Abdikadir, will deal with that matter. Let me point out to you, my lords, that this is one of the few petitions that this court has seen that is full of generalities, innuendos, hypothecations. Yeah. We believe there was one counsel who repeated several times, our theory is, our take is, our understanding is, not evidence, nothing of probative value, speculation, generalization. It is our very humble submission that framed in those general speculative terms, lacking clear, cogent, probable evidence, these petitions lack merit. It is made worse, my ladies and my lords, by the fact that the petitions make grave allegations of a criminal nature: fraud, tampering with election materials and results, conspiracy to unlawfully influence an election outcome, and even implied treason. Implied treason. All that without a shred of evidence. All that without a shred of evidence, especially as it relates to the Honorable Chebukati, the chairman of the commission. The vilification against this gentleman goes...
Instances walked into the polling station, voted for the president and no other candidate or no other category of candidates. What in this court we call the Mwilu question, in reference to my lady, the vice president, I think arising from the 2017 question that I think my lady and my lord, Mr. Justice Smokin Wanjala posed. Did you have any of those where you are issued with 5, 6 ballot papers, but you don't utilize all of them? Senior Counsel Kamau Karori, the appointment of the chairperson of the IBC was gazetted by the chairman himself. I would like to know whether he was gazetted as an agent of the commission or he was gazetted as national returning officer in his capacity as the chairman of the commission, and whether, if it was as an agent of the commission, whether there were any resolutions preceding this appointment. I'm back to Mr. Mahat with the question of voter turnout. According to your presentation on PowerPoint this afternoon, you said there were 45,994 voters were identified through Kim's kit, and this is out of 46,229. Sorry, that Kim's kit were used in 45,994 polling stations out of 46,229. That gives us 235 polling stations, which I assume I did not use Kim's kit. Therefore, assuming that the manual system was employed to identify them, are you able to say the numbers from these 235 polling stations? I saw some figures like 860 or 86,000, 114,000. So if you can just clarify that for us. And again to Mr. Mahat, because he dealt with figures. Mr. Umtata yesterday presented also a PowerPoint to demonstrate that 1.6 million votes were cast or were streaming in many hours after the closure of voting. If you can also respond to that question. Mr. Gumbo, both Mr. Issa and Mr. George Oraro, Senior Counsel, in their submissions talked about how Kenyans were following the streaming of results live. And then something happened and that stopped. Can you explain to us what may have happened for this to have stopped? My lady, those are all I have. Thank you.
Thank you, President, and thank you, Council. Again, your submissions were most helpful. We thank you. Professor Muigai, you said that the whole dispute revolves around numbers. And you were before us in 2017, and the question of Section 83 of the Elections Act was prominent at the time. Morgan versus Simpson was prominent. You were Attorney General at the time. A number of things happened around Section 83 post our judgment. My question is, looking at the qualitative, the quantitative test, and Professor Kindiki raised the question too around Section 83. I had it before he raised it. Could you speak to it, and what is the approach we should take in this case regarding the test to apply? Number two, again, to your team, and any of you could answer it. It's not a flippant question. I'm raising it deliberately because I have reason to. I know that the events of 15th August are in our minds, but remember that there was an extra day by which Mr. Chebukati could have declared the result. Why did you not wait until that day, violence or no violence? Perhaps you have another reason. Reach out to the commissioners, the four that are now named the four. Try and reach a consensus. Address the question of the 27 constituencies so that these suspicions that have now cropped up would not have been an issue. Is there any other reason why he did not take advantage of the extra day to do what he had to do? Mr. Oraro, I understand where you're coming from. I understand where your clients are coming from. I understand where Mr. Kenyo and Mr. Kihara and the rest are coming from. We are now in a spot where public office is becoming exceedingly dangerous. Falsehoods are being peddled, not just to those on this side, but more even on this side and those outside. So I understand the need for you to say, my clients would like to clear their names because they've been mentioned in these proceedings. But let us come back to the proceedings, the pain of social media, the pain of affidavits aside. What do you want this court to do with the information you've given us? So we have had your side of the story. We've had Mr. Chebukati's side. We've had Cherera's side and our colleagues. What do you tell the court to do in the context of this judgment, in the context of the issues for determination? What do we do with the matters you place before us? And while you're at it, you also mentioned Section 83. Perhaps you could also say something about Regulation 87.3. Perhaps since you appear for the Attorney General, and for the first time you're not appearing as amicus but as a respondent, could you say something about Regulation 87.3 and the question I posed to Mr. Noroji? It would be helpful for us if we could hear you on that question. I believe those are my, Mr. Mahat, I may have missed this, but I still want to clear my, this is a question I posed to Mr. Murgor as well. So the format initially is JPEG. At what point exactly does it convert to PDF? Forget the CSV story. I guess Mr. Murgor dropped that. But I just want to understand for myself. At what point you've taken the image, You've asked all the questions, very good questions you've asked. The system has asked you the question. At what point does it convert to PDF? I thank you all very much. Thank you, Judge President.
Thank you, Judge President. My questions will go to Professor Muigai. As we've been asked by a number of parties that they've asked us to settle the law around Article 138.3 and 10. In your submissions, you suggested that the term commission can be used in multiple senses. How do we know which sense will be applied when? As a former Attorney General, perhaps you can point out to us whether it is in regulations, it is in the law, but how do we know which sense is applied when? My second question goes to the history of independent commissions, and Professor Muigai, you sat on the CKRC together with my colleague, Justice Lenaula, and you do know that the drafters of the Constitution introduced independent commissions and independent offices to deal with issues of authoritarianism, accountability, transparency, and to do away with the issue of one person having power. But from the narrative that we are hearing here in the court, there appears to be an all-powerful chair who, so what is the check for this all-powerful chair if the commissioners have nothing to do with his role? What would happen if the chair was to announce the wrong results completely? Or if he was mentally incapacitated or sick, or worst case scenario, dead? Who then would announce the results? What is the role of the other commissioners? I think this is bothering me, especially because it seems to me that your client and the IEBC suggest that the chairperson works with the CEO, and I feel a bit concerned. The CEO is not vetted by Parliament. He is appointed, but he seems to wield immense powers over and above the other commissioners. I cannot imagine that that could have been the intention of the drafters of the Constitution. So what role do these commissioners actually do? Because it hasn't come clearly. Or, for example, if one commissioner says he's in charge of ICT, what does that mean? Does it mean he's in charge of ICT until the presidential election, then he's not? What does it mean? What is the role of these commissioners? And I'm asking this question more towards trying to understand the leadership and the management in the commission as opposed to the management of the presidential election. Because I think they're two separate issues, and I'm trying to figure out whether this is a Chebukati problem, is it a leadership problem, is it a commissioner's problem? What's this problem we're seeing? I'm trying to understand that, and I'd like to hear that from you. Thank you. One more question, sorry. When the results come for other elections, so you have returning officers for senator, for governor, for MCA, and they're all announced or declared locally at the polling station, constituency, county. How is that information transmitted to the public? And when that information is transmitted to the public through a gazette notice, are the commissioners involved? Or is it the CEO only? Or is it the chairperson only? Who is involved in the declaration or the transmission of declaration publicly of those results? Thank you.
Thank you, Chief Justice. My first question, I think, could be addressed by Mr. Karori. In the morning, you did really argue quite strongly that when it comes to verification, tallying, and declaration of the result, the presidential election result, that really, if you look at the law in your interpretation of the Article 138 and the jurisprudence jurisprudence that you say emanates from this court, you seem to be arguing that that is strictly within the purview of the chair's mandate, and that really these other commissioners, let's say the remaining, the 6 commissioners, really ought not to be around that, because that's a role preserved for the chair. But then you said, according to the statute that establishes this commission, the enabling statute, the roles and functions of the commission, are stated. One of them is oversight. What is oversight? If, in fact, the commissioners, I would have thought that one of the most important oversight roles in the commissioner's life would be when they are overseeing the verification and tallying of the presidential election result at the center before the same is then declared on behalf and for, and but for the people of Kenya by the chair. So what is oversight? I ask this because we were informed yesterday, and I think you were here, that instead of perhaps playing this role, some of them were allocated welfare scenarios, protocol, and media. But what is oversight? What would they be oversighting over? That's the question. In other words, at what point in this corporate entity scenario does the chair then disengage from the other commissioners? Be they 2 or be they 5 or 6? When do you say this is chair qua chair and this is chair as part of the commission? Because we need to understand that. We've been asked to provide clarity. Then let's go to Mahat. Mahat, there is this story about this Venezuelan. And one of the issues is whether the technology system employed or deployed was penetrated. And you did tell us, again, quite robustly, that there was no such penetration or infiltration or intrusion, whichever. But you did also concede that this Venezuelan, whatever his name is, had access to the server. But your answer was that the contract between the IEBC and Smartmatic was to supply and maintenance. So if I understood you correctly, this Venezuelan was accessing the server as part of the maintenance. So what is this maintenance? What does it entail? What was he doing there? Say he was released and locked out just before the election. So what was he maintaining in that system? Maybe you just want to tell us what maintenance entails as part of that contract agreement. Then back to the question of percentages, again, in terms of the turnout. I think I asked this question, I asked Mr. Orengo, but now that you may not have another, you may also want to address it. In the arguments that have been presented before us, Mr. Chebukati, the chair, first mentioned a 65.4% turnout. And then he did indicate that that was bound to change as results kept streaming in, especially if you took into consideration the number of those who had voted manually and the numbers that had yet to come in from the elders. Now, it is the petitioner's argument that if there was to be any change at all, then that percentage would have to increase rather than decrease. So I don't know. And how relevant, again, is this turnout to to the determination of whether a candidate gathered 50% plus one vote. And then, you see, we have been asked by Mr. Ngatia, who do you believe among these two protagonists? Who do you believe? This question has been put to us, and believe you me, we will have to deal with it. Who do we believe? Now, the question of the National Security Advisory Council. This, I think, Mr. Oraro, this could be of interest to you. On the one hand, you are telling us that this personnel visited the premises at the Bomas to express their concern, because, of course, being an advisory council, they must have arrived at a conclusion that unless the results were released, then there was bound to be chaos. But on the other hand, the chair, in his affidavit, tells the court that the only reason the AG, or I mean not the AG, but the individuals, distinguished people for whom we have a lot of respect, paid that visit, was to tell the chair to somehow re-engineer the results in favor of one of the candidates. Now, this is not a question to you, but a question to Mr. Chebukati's counsel. Professor, you may want to, or even Mr. Karori, are we to assume that by the time Mr. Kenywa placed this call, if the intention was to influence the declaration of the results, to change it, to re-engineer it, are we to assume that by the time that call was placed, and by the time these gentlemen paid this visit, they already knew the results? Because there's no way they would have been on that mission if they had not known the results. So are we to assume that in fact, if this be their mission, are we to assume that they already knew the results? Okay. Then finally, Mr. Kilokumi, you know, you cited King Solomon. And this court treats Holy Scriptures very seriously. You came up with, you say there is victory. Because in King Solomon's story, the protagonists were distinguished mothers. But here, you called them two gentlemen. But I also remember that one of the mothers who turned out, or the mother claimants, who according to Solomonic wisdom could not have been the mother, is the one who was saying, cut the baby. But the other one, I remember, said, no, let her take the baby. Because what she was interested in is to preserve the baby. Would you be willing to advise? I rest my case.
Okay. Thank you, Honorable CJ and President of the Court. I just have one inquiry, one question for the respondents, and it may go to, actually it may be answered by either the counsel, Senior Counsel Gidu Migai and his team for the first and second respondents, or it could also be taken up at the same time by counsel for the ninth respondent. That is the team of the team of Senior Counsel Fred Ngatia. It's my understanding that one of the submissions and cases in response by the first and second respondents on the one hand, and the ninth respondent, that is the president-elect, are placing the blame on the events of the ninth at the Tallying Center, Bomas of Kenya. That the two groups of parties are placing the blame on the first and second petitioners' agents and sympathizers and supporters during the tallying and verification. Of course, we have images. Many of us were not there. At least the bench was not there. But we have images which we saw on TV. We cannot say anything about what exactly happened. But we just know there was commotion, and people are throwing chairs, and even perhaps attempts to harm each other. But we cannot say anything about it ourselves as a bench. Neither were those matters before us in these proceedings. No evidence or allegations, affidavits. We have seen the affidavits, seen the submissions, but no actually determination or delving into any evidence. So, and yet there is a request, a suggestion that we should attribute and apportion blame among the, we should place the blame on some parties, particularly the petitioners, because of their agents, supporters, and therefore actually you expect, particularly I can see the submissions of the ninth respondents, and even I saw the affidavit of Professor Goulier, where he actually says he expects action to be taken to investigate those criminal election offenses. So I just wanted to inquire that would you expect, having had such elaborate submissions and affidavits, would you still expect us to make a determination, apportion blame, attribute blame, yet really the matter is not before us? Neither are we witnesses, neither were we at the Bomas, neither were these matters had on merit before us. That's the question I would like you to think about and reflect, and when you come back, you will tell us whether you expect any release from us on that aspect. Thank you.
Thank you, Judge President. My clarifications will be sought from the team led by Professor Gidu Muigai, Senior Counsel. The first clarification I seek is as follows. As regards the requirement of Article 140, and just remaining within Article 140, and even considering that the 4 new commissioners only arrived in, was it September last year? And whatever it is they've been doing on a day-to-day basis, please clarify in my mind, because it's a major issue here, what the constitutional role of the 6 commissioners is under Article 140. And once you tell us what it is, just position their role against that of the staff of the Secretariat and of the chair. To the same team, and that is as per Article 138, 3C. To the same team, of course, numbers are critical. They are, for me, they are. Because that is a mandate of 138, 4A and B, the threshold, the 50% plus 1. And numbers are important for as long as they are not negated by any other process. And numbers would point to a good election, a good result, if they are not affected by anything else. And if Article 138 for A and B are not enough, deriving from them, this court in 2017 told us that although numbers were very, very important, other things could affect the numbers. Now, here is my concern. With the fact of the numbers being undisputed, they are important, kindly comment on whether or not, this question flows from the first one, the walking away of the 4 commissioners to go and hold, was it an IBC meeting at Serena? Or was the IBC meeting at Bomas? But please comment on the walking away of the 4 commissioners almost at the same time as the chair was about to declare the results. And in fact, I recall, because I was glued on TV myself, among their first words were that we have done an excellent job as concerns this election. But the results that the chairman is about to release are his results. So please comment for my benefit that working out, and how was it timed? You've got to know, because these are your clients, that they would be walking out of Bomas to Serena to allow all media houses, in fact, except for the violence that occurred at Bomas, the split screens of media houses would have been showing each one of them addressing us, the Kenyan voter, at the same time. In fact, at one moment there, I thought the team at Serena would give us their numbers, and the team at Bomas was going to give us their own numbers. So my concern is, does their walking out mean anything under Article 140? If it does, what is it? If it doesn't, why not? Still on numbers, and answering all of us, yours and our issue number 4 and 5, we were told, and I need clarity on this one because it cuts across 2 main issues, that the turnout, the voter turnout, was affected by the postponed election. Now, this is my concern. On the 9th, we were voting for 6 people, 6 officers. And we actually voted for 6 officers, including in the places where elections were postponed. And we were told that turnout was affected by the postponement. And since you are the central player in this thing, you could pass this to Mahat or anybody else in your team. Did the postponement affect only the vote of the president? And since we are in the habit of taking judicial notice, and since I am in a position to take judicial notice of the fact that elections have since happened in the postponed areas, have the subsequent elections returned a different result as to turnout? Because that happened, was it Monday? And we have yet to write a judgment. If they are affected, in what respect? Mr. Mahat, you told us that there is a holy place. You called it a sanctified place for the agents. And that it is the responsibility of parties to have agents. Your sister, while submitting, Ngania, told us that in 2017, we also emphasized the position of the agent. This is my question flowing from that, and it goes to the process of the election. What if there were no agents? The Article 81, I think 81E, places the burden of ensuring that we have a fair, free, transparent, accountable, and all those things, election, where, for whatever reason, agents are not present at an election. Is it not the role of the IEBC to ensure that Article 81E is upheld? And in the event, I know you said in Tiati, some constituency there, in fact, there were no agents from anyone. The process, and where there are no agents, the process. Finally, we have seen somebody named the 4 commissioners as respondents. One of these petitions, or some of them, named them as respondents. I think someone had even named them as interested parties or something like that during interlocutories. But by whatever name code, they remain commissioners. I have also seen, we have seen affidavits that they have sworn, which tend to show that they take certain positions. Now, what is the position to be taken by a commissioner? Is it a position of the party, any party, or is it the neutral position of the IEBC? And when they take, as I think they have done in this case, the position of any side, what is the court to do? Did I say finally? Then I'll say the second finally. That Kenya's call, Mr. Joseph Kenya's call, and whatever else that happened, the night meetings, the security issues, and so on and so forth. The name of this commission starts with the letter I, which says, I stands for the Independent Electoral and Boundaries Commission. And in the body of 88 going down is that, and even in their act, they shall not be directed in the manner in which they do their work. But I want you to clarify in my mind, because it's now an issue here, when it comes to writing the judgment, what do you want me to write? There are commissioners, and we talked about the dysfunctionality. It came from you, it didn't come from this side of the bench. Of the commission, I'm glad today I have had an attempt at answering my question yesterday as to when it became dysfunctional, but I'm still waiting for answers from the person to whom the question was directed, which is the petitioners. But tell me what the IEBC was supposed to do. On the one hand, they are being told, hurry up and announce. On the other hand, the court, as represented by the Honorable Mr. Justice Isaac Lenaola, is saying, but there is still time. There is yet another day before you can announce what is the IEBC to do. Thank you. Thank you very much. Thank you, President.
Thank you, colleagues, for those questions. I think they were quite comprehensive. The team led by Professor Geth Muigai, you can see what we want to understand is this disconnect arising from IEBC. Because when we look at Article 88, the role of IEBC is to supervise and conduct elections. I do not want to repeat this question. Why the chairman deemed it fit to allocate commissioners, I think what has been described as domestic chores, leaving the core business of IEBC to the CEO to supervise. We've been told that they did a good job in the polling stations. Polling went on well, counting, tallying, and transmission until the National Tallying Center, where they are all there, but they are not doing the core business of, according to the Constitution, they have been given other duties. This is bringing a lot of questions in our minds. Then when we look at Article 138, 3C, we see they have a law, at least to look at the tallying results and ask questions whether the president-elect met the constitutional threshold before the chairman can go and announce the results, because we all understand nobody can tinker with the forms 34A and B the way they have come. And you have had IEBC being likened to the Supreme Court, much to the chagrin of the judges here, because the question which was being asked, I think, by Mr. Otieno is that if 7 people are sitting on a judgment or a decision, and there is a dissenting voice, why didn't the chairman tell Kenyans exactly what happened? That we conducted this election, we came to the National Tallying Center, we have these results, but some of the colleagues have a dissenting voice. They will tell Kenyans why they are dissenting. Another thing that worries us, and I think your team should answer, is why the streaming, the live streaming of the results stopped. Because if Kenyans were able to follow the streaming from the beginning to the end, which was being done in the spirit of accountability and stability and transparency, then the rhyme which we were being told of the pige ponki would not arise, because there would have been no confusion. We know this is how things are happening, and therefore maybe the losing candidate who is being called to go to the National Tallying Center can decide not to go, because they know already the results they are on the screen. So I would also like a clarification. The question has been asked, and it was demonstrated very ably by Mr. Mahat. I would really like to follow his presentation, because he did it with passion. Mr. Kirago Kemani also did it, but I think I want you, Mr. Mahat, to, just demonstrate how the forms 34A that were attached to the affidavits of the respondents were photoshopped. I think I liked your language of photoshopping, and I could follow it, but I want to understand exactly how they were photoshopped. I think that is what I would like to ask. Thank you. Oh, one more.
Thank you, CJ. Sorry, I don't know whether it has been up, but time without number, the issue of the 27 constituencies whose results, it is said, had not been included in the final tally before the announcement was made, keeps coming up. We have been told that in fact, these 27 constituency results had been verified and tallied. But because of the commotion, somehow they would not be part of the announcement. But why did the chair, just before, when Koome was restored, why would he not have included them? Because they had already been verified and tallied. Or did not include in the final, so that they shouldn't be here bothering us? Why was it, where was the hurry this time? And already the results had been tallied and verified. Thank you, CJ.
Sorry, I just forgot a quick question, Professor Muigai, regarding my questions on Article 138. What is the implication of what you are suggesting on the chairpersons of other commissions? And I say chairperson, I noticed today everyone's talking about chairman. The correct term is chairperson.
Senior Counsel, I think myself that, and if I'm wrong, please correct me, that the most important day for a commissioner of the IEBC has got to be that time that they are doing the presidential election, and I think there is a reason why their term is 6 years, because our elections are every 5 years. So that, I think it's likely that in the 6 years, or whatever time one gets in, a commissioner would have to conduct an election, a general election. Let's not just say presidential, but a general election. Therefore, what is the role of the commissioner, the 7 commissioners? Back to my question number 1, and strictly under Article 140 for me, and 138, 3C. Thank you.
My lady, my lords, We thank you for those very incisive questions. My team has requested me to very humbly request you to give us time, because you place much weight on those issues. We would equally want to come back, not with off-the-cuff remarks, but with well thought out responses that can help you appreciate the issues you've raised. And I think that that would put us in parity with our colleagues, because you raised questions with them yesterday. They've had 24 hours. I think they are still mulling over them. In their case, I think there were more difficult questions. If you would very kindly allow us to respond tomorrow morning, we assure you we will not take more than the time you will allocate us. And this is particularly for Mr. Mahat, our numbers expert, because he would like again to have something to demonstrate to the court on the screen. Thank you.
Yes, we are consulting because we did not want to give you a second bite of the cherry. You know you have no right to reply as respondents. But we have asked these questions on the tailhead. The hour is also late, but you know we are operating under very, very strict timelines because of the extraordinary circumstances of this matter. We have agreed to allow you to respond in the morning, considering that if you put your minds together, you'll be faster in the response than if we do it now. So we will give you 15 minutes tomorrow morning to respond, fasting tomorrow morning, to respond to those questions.
Milady, we don't want to sound ungrateful. We welcome the change you have made and thank the court, but we would request 30 minutes. And we will try our best, although you've asked these questions of many of us, we will try to have, at the very most, 2 people speak to it. 1 person to the law and 1 person to the numbers. Thank you very much.
Thank you very much. Yes. Yes. Thank you very much. I think that brings us to the end of today's proceedings. We will share in the course of this evening the reports from the discovery or the scrutiny that went on. And then the order of business tomorrow, we will start with the team of Professor Githu Muigai responding to those questions. And then we will hear the rebuttal by the petitioners. And thereafter, we will give the parties who are participating in the scrutiny. That is the first petitioner, I think Youth Advocacy, Kerif, then IBC, and the first respondent to comment on the report on scrutiny. We'll give each 15 minutes because we are trying to see how we can bring these proceedings to an end at least by midday tomorrow, so that for us we can retreat to our chambers to work, to do the biggest job that has fallen on our hands, to come up with a judgment by Monday. So we will continue to ask you to bear with us and be very kind to us. Thank you very much. Have a very nice evening.
Akili zangu nguvu zangu nimeziweka mbele yako, bibi yangu na watoto nimewaweka mbele yako, tabu zangu shida zangu ziangalie Kenya yangu, tabu zangu shida zangu ziangalie Kenya.
Any concerns that parties have, let those issues be addressed when you receive the report later this morning. You can address the question of what you're calling non-compliance. You can address the question of what servers you think were not accessed. You can address the question of the information that you received, your agents were there. And you, IEBC, can respond to say, what are your answers to the complaints by the petitioners' advocates? And then the court will ultimately determine what is the import of all the things you're saying. That report was meant for the court to make a decision on the issues you raised. So as far as we are concerned, that matter is spent. Please address us tomorrow substantively on each of the questions once you see the report, which is actually being prepared right now. That's all I have been informed to tell you by the court. I thank you, CJ. I thank you, Council.
Madam Chief Justice and the Honorable...
Sorry, Senior Counsel. I think, CJ, allow me to say this. As much as possible, let us do matters within this court. I think the debate out there is convoluting matters. And when we see documents being circulated outside the court, it only just inflames the public. Let us please keep matters right here. Let's manage our issues right here until we finish. That's all I'm saying in answer to Mr. Gunbo's concerns. But as far as the court is concerned, we're on top of things. I thank you.
Madam Chief Justice and the Honorable learned members of the court, I am Githu Muigai, and I appear for the IEBC, for its chairman, Wafula Chebukati, and for Commissioner Professor Abdi Yakub Gulei and Boya Molu. I am assisted in the defense of this gentleman and the institution by Kamau Karori, Senior Counsel, Abdikadir Hussein Mohammed, Senior Counsel, Mr. Eric Gumbo, Mr. Mahat Somane, Dr. Willie Mutumbwa, and Mr. Peter Wanyama. I would like to request you, Madam Chief Justice, if you could kindly confirm that our combined team has 4 hours, our 3 hours, plus the 1 hour between the 2 commissioners who are represented by our team.
That is not correct, Prof. The 2 commissioners have 30 minutes. You remember the other 4 commissioners and 15 minutes each. They are 1 hour among the 4 of them. So you have 3.5 hours.
I'm guided by you, my lady, and I have changed that to 3.5 hours. Thank you. We have filed before you a wide range of documentation, which in our very humble view is very, very comprehensive. We draw your attention, honorable members of the court, the responses on behalf of the chairperson and IEBC, the affidavit of Wafula Chebukati, the affidavit of Marjan Hussein Marjan, the CEO, the affidavit of Professor Abdu Yakub Gulei, the affidavit of Commissioner Moya Mulu, the affidavit of Martin Washira Nyaga, the database administrator, the affidavit of Michael Ouma, the director of ICT, the affidavit of Moses Lendema Senkuli, the acting director voter registration, and affidavits filed by presiding officers and residing officers of the contested polling stations and constituencies. Let me start, my lady Chief Justice, by observing the peculiar nature of the proceedings before this court. That is to say,
Thank you very much. I will invite the Honorable Justice Ouko to begin with these questions.
Thank you, Judge President. I have a couple of questions. I'll start with Mr. Mahat, who, without leave, proceeded to convert this courtroom into a classroom. Mr. Mahat, there was an allegation that 33,000 vote differential were noted between the votes cast for the president and those for governor, senator, women rep. You tried this morning to explain that some of those instances arose from stray ballots. Would you tell us how many constitute stray ballots? And can you also share with us how those stray ballots are distributed in terms of counties? Related to that, did you have, in your analysis, did you have any instances where voters walked into the polling station, voted for the president, and no other candidate or no other category of candidates? What in this court we call the Mwilu question, in reference to my lady, the Vice President, I think arising from the 2017 question that I think my lady and my Lord, Mr. Justice Smokin Wanjala posed. Did you have any of those where you are issued with 5, 6 ballot papers, but you don't utilize all of them? Senior Counsel Kamau Karori, the appointment of the chairperson of the IBC was gazetted by the chairman himself. I would like to know whether he was gazetted as an agent of the commission, or he was gazetted as national returning officer in his capacity as the chairman of the commission, and whether, if it was as an agent of the commission, whether there were any resolutions preceding this appointment. I'm back to Mr. Mahat with the question of voter turnout. According to your presentation on PowerPoint this afternoon, you said there were 45,994 voters who were identified through Kim's kit, and this is out of 46,229. Sorry, that Kim's kit were used in 45,994 polling stations out of 46,229. That gives us 235 polling stations, which I assume I did not use Kim's kit. Therefore, assuming that the manual system was employed to identify them, are you able to say the numbers from these 235 polling stations? I saw some figures like 860 or 86,000, 114,000. So if you can just clarify that for us. And again to Mr. Mahat, because he dealt with figures. Mr. Umtata yesterday presented also a PowerPoint to demonstrate that 1.6 million votes were cast or were streaming in many hours after the closure of voting. If you can also respond to that question. Mr. Gumbo, both Mr. Issa and Mr. George Raro, Senior Counsel, in their submissions talked about how Kenyans were following the streaming of results live. And then something happened and that stopped. Can you explain to us what may have happened for this to have stopped? My lady, those are all I have. Thank you.
Thank you, President, and thank you, Council. Again, your submissions were most helpful. We thank you. Professor Muigai, you said that the whole dispute revolves around numbers. And you were before us in 2017, and the question of Section 83 of the Elections Act was prominent at the time. Morgan versus Simpson was prominent. You were Attorney General at the time. A number of things happened around Section 83 post our judgment. My question is, looking at the qualitative, the quantitative test, and Professor Kindiki raised the question too around Section 83. I had it before he raised it. Could you speak to it? And what is the approach you should take in this case regarding the test to apply? Number two, again, to your team, and any of you could answer it. It's not a flippant question. I'm raising it deliberately because I have reason to. I know that the events of 15th August are in our minds, but remember that there was an extra day by which Mr. Chebukati could have declared the result. Why did he not wait until that day? Violence or no violence? Perhaps you have another reason. Reach out to the commissioners, the four that are now named the four. Try and reach a consensus. Address the question of the 27 constituencies so that these suspicions that have now cropped up would not have been an issue. Is there any other reason why he did not take advantage of the extra day to do what he had to do? Mr. Oraro, I understand where you're coming from. I understand where your clients are coming from. I understand where Mr. Kenyu and Mr. Kihara and the rest are coming from. We are now in a sport where public office is becoming exceedingly dangerous. Falsehoods are being peddled, not just to those on this side, but more even on this side and those outside. So I understand the need for you to say, my clients would like to clear their names because they've been mentioned in these proceedings. But let us come back to the proceedings, the pain of social media, the pain of affidavits aside. What do you want this court to do with the information you've given us? So we have had your side of the story. We've had Mr. Chebukati's side. We've had Cherera's side and our colleagues. What do you tell the court to do in the context of this judgment, in the context of the issues for determination? What do we do with the matters you place before us? And while you're at it, you also mentioned Section 83. Perhaps you could also say something about Regulation 87.3. Perhaps since you appear for the Attorney General, and for the first time you're not appearing as amicus, but as a respondent, could you say something about Regulation 87.3 and the question I posed to Mr. Noroji? It would be helpful for us if we could hear you on that question. I believe those are my, Mr. Mahat, I may have missed this, but I still want to clear my, this is a question I posed to Mr. Murgora as well. So the format initially is JPEG. At what point exactly does it convert to PDF? Forget the CSV story, I guess Mr. Mulgore dropped that, but I just want to understand for myself. At what point you've taken the image, you've asked all the questions, very good questions you've asked, the system has asked you the question, at what point does it convert to PDF? I thank you all very much. Thank you, Judge President.
Thank you, Judge President. My questions will go to Professor Muigai. As we've been asked by a number of parties that they've asked us to settle the law around Article 138.3 and 10. In your submissions, you suggested that the term commission can be used in multiple senses. How do we know which sense will be applied when? As a former Attorney General, perhaps you can point out to us whether it is in regulations, it is in the law, but how do we know which sense is applied when? My second question goes to the history of independent commissions